Well, good morning, everyone. Thank you for joining us this bright morning, starting off our day. My name is Scott Zucker, and I'm honored to be the chair of the State Bar Alternative Dispute Resolution section this year, and your host for today's full-day program on dispute resolution. I'm humbly carrying on the tradition of my predecessors, our past ADR section chairs, Sasan Nabatpakash and Erica Berg, who helped to create programs like this in the past, these full-day conflict resolution education programs. But today, many of you will learn, is a very special day. Today is designated, as is the third Thursday of October every year, as Conflict Resolution Day. That was the intentionality of doing this program on October 19th, because today is World Conflict Resolution Day. So Conflict Resolution Day is a global event intended to promote the concept of conflict resolution. The day honors the hard work and dedication of those who strive to resolve conflicts in a peaceful and constructive manner, serves as a reminder that conflict may be inevitable, but it doesn't have to be negative. It can be worked out. So today, as an educational event, the purpose of this day and our program day is to increase awareness of methods of conflict resolution like mediation and arbitration. Conflict Resolution Day falls within Conflict Resolution Week, and in a moment we'll hear from Tracy Johnson from the Georgia Office of Dispute Resolution to tell us more about our Conflict Resolution Week. But I wanted you all to know that we really truly are in Conflict Resolution Day, and we celebrate with you to put on this large involved program on education of conflict resolution. So I have a few minutes. I just want to extend some special thank yous from the start. Clearly, without these folks, today would not have been possible. And first, to our amazing senior sections coordinator at the State Bar, Lane Sotheby, who's coordinating today for us and is available and helping our presenters, has been instrumental throughout in the helping and the planning of this. So a big shout out to Lane, as well as to Charlie Smith, the sections coordinator, and to Mary Jo Sullivan, the sections director, all from the State Bar. A day like today would not have been possible without their hard work and dedication to put this all on. So I want to thank them so much in advance. I want to thank our section board of directors, Erica Berg, our past chair, Sean Moman, our chair-elect, who will be following me next year, Joyce Clemmer, our secretary, Doug Witten, our treasurer, Ray Chadwick, Mark Daler, and Casey Crumbly, all who are at-large members of the ADR section board and work with us to put on programs like this and programs that we've been putting on since the beginning of the year, and will continue into next year on a monthly basis to educate you on conflict resolution. I do want to take this opportunity to just do a plug for the ADR section. Whether you're an advocate or a neutral, we'd love to get you involved. We were a very active session, and you'll learn more about that as you go through the day today to hear about what's going on in the mediation world in Georgia. And our section is very involved in that. We'd love for you to participate and be involved, and maybe even take some leadership of the possibility of the ADR section of the State Bar. Again, we get tremendous support from the State Bar staff, and we think we can make things really positive in our industry of conflict resolution and ADR. We need your help. I'd like for you to join us. So again, as we get started for the day, I want to thank in advance our tremendous panel of speakers that you'll hear today. I just want to give basically a shout out to each of them in advance. What you'll see in the materials that you've been provided is a bio of each of these presenters. So as we go through the day, we won't spend time giving their bios before their presentations. I'd like for you to see these materials, read about your presenters before they begin, and learn about them, and appreciate their taking their time and their energy to put on these programs today. So you will hear from today very excited about all of these speakers. Tracy Johnson from the Georgia Office of Dispute Resolution, Hal Gray from the AAA, who's also on the commission, Ken Kendrick from Henning, Judge Gail Tucson from JAMS, Parag Shah from Miles, Nigel Wright from NAM, Lee Warshauer from Henning, Randy Rich from Henning, Michael Eschman from Miles, Doug Witten from Bay Mediation, Justice Sears from NAM, Marcy Dixon from NAM, Audrey Lee from Harvard, Daniel Sravinsky from UGA, Paul Faxon and Mark Sheridan from out of state talking to us about collaborative law, both coming out of North Carolina. And to close, Sean Moman, my vice chair, next year's chair of the section. Again, an incredible lineup of speakers for you to hear from today on these topics. So lastly, a little bit on logistics. We have jam-packed this session. So you are going to go from Tracy and Hal's introductory program from 8:30 to 9 into 1 hour block sessions from 9 to 10, 10 to 11, 11 to 12. We have a 12 to 12:30 break, and then 12:30 to 1:30, 1:30, 2:30, 2:30, 3:30 until the end of the day. Our last session ends at 3:30. We've done this in a virtual format, so if you need to take a break, take a break. We're going to kind of run through the programs back to back, except for the lunch break. So we like to say that if you're sitting at your desk, get up and stretch your legs, or if you're sitting by the pool and you want to take a dip, go ahead and enjoy yourself and come back to our program. We love the virtual Zoom format, so hope this is a relaxing and entertaining and informative day for you. Again, the materials that have been sent to you in advance also provide the CLE materials that have been provided by each speaker to support the fact that this program will provide a 6 credit hours of your CLE requirements, general credit hours for CLE for the state bar requirement. And we have been granted approval from the Georgia Office of Dispute Resolution that these same credit hours that you're getting today can be used for your accreditation and credit requirements as part of your certification for the Georgia Office of Dispute Resolution. So we thank them, thank the State Bar. So these materials that are provided to you are part of your CLE packet for use for your accreditations. So again, we are going to move in a few moments to our first program as we sort of logistically set up. And we again invite you to enjoy the day, to listen in on each of the sessions. The credit hours will be issued after the end of the full day based upon your attendance. And if you have any questions, please put them in the chat, and we will be watching the chat to make sure that everything is coming through on your end, that you can hear us, gather the information. And if you have any questions for the speakers as you hear through the programs today, we'll try to watch the chat and be able to hopefully respond to your questions as they occur during the day. So that's it. Thank you for getting up again this morning. I hope you have a cup of coffee to enjoy and sit back and listen to our presenters. And we will get going in just about 2 or 3 minutes. So again, get organized and we will get started. Thank you very much. A few minutes early to get us going for the day, and we are going to be introducing as our start for the day Tracy Johnson from the Georgia Office of Dispute Resolution and Hal Gray, as I mentioned, serves on the Georgia Supreme Court Commission for Dispute Resolution. And welcome to the two of you, and look forward to hearing from you about the Georgia Office of Dispute Resolution.
Thank you, Scott. When we got the announcement at FIRE about this program, it occurred to me that probably the vast majority of people who are attending the seminar don't even know what the Georgia Commission on Dispute Resolution is, who's on it, what its job is, what its task is, and much more importantly, what the Georgia Office of Dispute Resolution is. So, and what the myriad of things that it does and does exceptionally well for neutrals in the state of Georgia. So I asked Tracy if she would join with me to give y'all a glimpse, a slice of what it is that the commission and the office do, and how I think they are both very critical to dispute resolution in the state of Georgia. And Tracy, who has more things to do than anybody who's on this call right now, was kind enough to say, yeah, I think it's a good idea. Let's give it a shot. So, Tracy, I'll turn it over to you for right now.
Sure, and thank you, Hal, and thank you for the invite. And the Commission on Dispute Resolution is truly one of the hardest working commissions. And Hal, as you'll see, he chairs a committee, and he's involved in a lot of the projects that we have going on. I first, though, want to share, piggybacking on Scott's Dispute Resolution Day, Conflict Resolution Day, we have a proclamation from the governor for this week claiming Dispute Resolution Week. So we are in this week. It is a joint effort of the commission and the dispute resolution section. So we appreciate the continued collaboration with the state bar, and just want to recognize all of the hardworking neutrals, your work, your service, and your continued collaboration. So with that, I'm going to share our PowerPoint. We have a lot of slides, but we're going to go through some of them pretty quickly because we want to make sure we get to the okay. So as Hal mentioned, just the office and the commission, we're just going to go briefly through the rules, and only the reason is the Supreme Court Commission is actually established in the Supreme Court ADR rules. We'll talk a little bit, just an overview of both, and then what we do, and then what we're working on. So you can see sort of some of the initiatives coming out soon. So Hal, you may just run through these really quick. Is that good?
Okay, sure, Tracy. I think probably the most significant piece of legislation affecting dispute resolution in the state, at least within my memory, is the Georgia Uniform Mediation Act, GUMA, which was passed a few years ago by the General Assembly. The driving force behind GUMA to try to clear up a lot of loose ends in the law about what mediation was, what privileges attached, when they attached, what the mediator could do, what the mediator could not do, were more or less bundled together in case law over the last, pick a number, 20, 30, 40, 50 years. The commission and the office, and understand the commission, let me just a quick aside, the commission is a group of people, and we'll get down to the details in a minute, who were appointed by the Supreme Court. The commission is constituted of lawyers, judges, social workers, ADR program administrators, just about somebody from every group of professionals in the state of Georgia who touch ADR at some point in time. The Office of Dispute Resolution, of which Tracy, and I am one of, I think, 16 members of the commission. The Office of Dispute Resolution is the engine that makes the Georgia Commission run. They are the folks that do the work. They're the folks, and it's Tracy as executive director and Carly Saws as deputy director, and that's it. There are two people who do the work of probably 30. But both Tracy and Carly and the commission all got together, and with the help of several members of the General Assembly, had managed to get the Uniform Mediation Act codified a couple of years ago, and now we know what the rules are. And believe it or not, it was a little bigger effort than you would have contemplated it being, because of a lot of different political considerations. Imagine that. At the General Assembly. Anyway, that is something of which both the office and the commission are very, very proud. And the court rules, the Supreme Court ADR rules, are the general guidelines of a whole lot of things. And we will work through some of those and tell you where they lead and where they are. They're all published, of course. They're all on the webpage. And they laid the ground rules and the groundwork out for ADR in Georgia. The next step in that process are the local court ADR program rules, which are created by the ADR programs that are scattered around the state, that court annexed ADR programs that are scattered around the state. Those provide, again, the ground rules for what we do. And if you haven't read them, take a look. Take a look at them, and I think you'll understand more about the scope of what this commission and what the office do. I know before I got involved in it, I didn't really understand what the commission does and what the office does. And since I have become involved, and since I was appointed to the commission, I am constantly amazed by the different places in the state, particularly with regard to mediation, that this commission and the office have a hand in making sure that it all works the way it's supposed to work.
Thank you, Hal.
Tracy?
And the dispute resolution section also supported the Georgia Uniform Mediation Act. So it was a state bar legislative matter, and it took 3 years, but it is through. Just a few quick things, because we've presented on this before. But as Hal said, it became effective in 21. It applies to all mediations, in both domestic and international. The highlights, Hal touched on a lot of those. The one that I do always like to highlight above all is the definition of a mediator. Within the Georgia Uniform Mediation Act, it basically says you're a mediator if you call yourself a mediator. However, if you're mediating pursuant to the Supreme Court ADR rules, you have to follow those rules, which means you have to be registered in the appropriate category if you are mediating a court-ordered case. So I always just want to mention that, so that that's common knowledge, and it sort of separates then what's court-ordered. If it's got an order, it needs to follow the court rules. If it doesn't have an order, then it's a private case. Participation also, in mediation, parties can have either an attorney or someone else with them. So they could bring a friend, they can bring their mom, so they are allowed to have one or the other, but not necessarily both. Whether you have more people in there or not, that's up to you. The Supreme Court rules, as Hal mentioned, there are the Supreme Court rules establish the commission. They establish the duties of the commission. They then establish the office and the duties of the office. It outlines the makeup of the commission members, and rules for neutrals, rules for programs. And then you have these following appendices. So as Hal said, there are local court programs. These are allowed to exist pursuant to OCGA, the 1523 1 through 12, which is the Court-Connected ADR Act. Courts can apply to the commission to have a court program. If they then are approved, they can collect filing fees to help fund that program. And that's sort of how they're set up. And as you know, if you practice across Georgia, they're very different. There's some that are one county, there's some that are multi-county, there's some that are districts. So the rules are similar, and that's pursuant to Appendix A, the uniform rules for dispute resolution programs. So there's some things that have to remain uniform across all programs, but procedures like timing, types of cases that might go to ADR, those differ in the various court programs. And that's to allow some flexibility. the way that ADR was set up in Georgia was to allow courts to be able to create a program that fit their needs. Not everybody's the same across Georgia. Appendix B is our rules for qualification and training of neutrals. They've been recently updated, and we'll include some of the changes, but one of those is the inclusion of probate mediation as a registration category. And I'll talk a little bit about that in just a few minutes. Appendix C is our ethical standard for neutrals. This includes both the standards that we have, but also the procedures. We are in the process of working on a best practices for neutrals. In Appendix C, there's a lot of commentary. So we're going to take that out and put it somewhere where it makes a little more sense so that there will be more information and covering more details in the best practices, and then updating Appendix C. Appendix D is our rules for mediation in cases involving issues of domestic violence. This was a long effort and involved a joint partnership with the Georgia Commission on Family Violence. So we maintain that partnership, and this is for the safety of parties who are mediating cases in where there might be issues of domestic violence, such as a domestic case. Okay, so that was just a quick overview, but I wanted to sort of give you some context as to who the commission is and sort of how it's established. So Hal, you want to take over on the commission?
Sure, Tracy, thank you. The commission, as you can see, was created in 1993 by the Supreme Court. The concern with the concern of the Supreme Court was that there would be a set of rules that would be relatively uniform across the state, so that that if, as an advocate, you are going to get a court-appointed mediator, you want a court-appointed mediator in Carrollton, that he or she is going to have the same qualifications and receive the same training as somebody in Quitman. And that uniformity that has been given by the commission and by the rules has been critical to the development of dispute resolution, especially in the form of mediation in the state of Georgia. The commission, as you can see, consists of 15 members. There's a member from the Supreme Court, a member from the Court of Appeals, a member from several superior courts, members from probate courts, members who are lawyers, members who are social workers, members who are directors of ADR programs across the state. It's not an accident. It is intended to involve people at every level of dispute resolution and who touch dispute resolution in the state of Georgia. And this commission, I've been on other organizations, as we all have, who, well, you've got folks who are there and they say, I want to be a member of the commission, I want to be a member of a director of this group, and they want to put it on their resume. And when it comes time to push your shoulder to the wheel, they can't be found. I will tell you that on this commission, there's nobody that falls into that category. This is a group of hardworking people who are dedicated professionals, who are dedicated to the proposition that the justice system in Georgia is founded on fair and equitable results, and that the commission and the office have worked very hard to ensure the framework for that is in place. Tracy, you want another slide here? The commission has, like every other organization, has five standing committees. And Tracy, I'll let you take the lead on this one.
Sure. Yeah. So, with that many members, it's hard to sort of compartmentalize and get things done. So our budget and personnel basically for the office. Our ethics committee stays pretty busy. We do receive ethical complaints. This year has been our top year for complaints. I think we're on 9 or 10 at this point. But we consider all complaints. We look at them if there are any violations, or we see it seems to be there might be a violation of an ethical standard. Those will go to the ethics committee. The training credential is a hardworking group. I think House serves on that group as well. They meet, and they're the ones who recently did the overhaul of Appendix B, and they consider things such as the probate mediation. What training curriculum needs to come out of that? What qualifications need to be for each set of registration categories? The domestic violence rules is we meet now once a year now that the rules are in place, and that does include people from both the dispute resolution community as well as the family violence community. And then Hal, you can take the outreach if you'd like, as the chair.
Yeah. The outreach committee is charged with doing all it can do to ensure that the commission is focused in part on several things. First of all, is believe it or not, there are still places and significant numbers of counties and districts in this state that do not have ADR programs for whatever reason. There are myriad different reasons for that. One of the things the outreach committee is doing is in fact reaching out to those folks and saying, you know, you may not have an ADR program, you may not have a court mediation program, you may not have whatever it is that they have in Fulton County and a number of, 100 other counties in the state. And if you don't, we are here to try to convince you to do that, to put it in, because we think it would be good for your courts, for your judges, for your lawyers, and for the citizens of your county. It has met with some success. Believe it or not, Dougherty County did not have an ADR program until the last few years, and now they do, and it's up and running, and everybody's happy. And the commission was able to help Dougherty County do that. Ware County and Waycross is also now, they're coming on board. They are going to put in a program, and we will be able to, the outreach committee in the office will be able to provide them with a lot of tools that they need in order to do that. I think we're finding that there are a lot of counties who have not put in programs because of inertia. It's because of when it all got started in 1993, people really didn't understand what it was all about and were hesitant to spend money and time on something they didn't really understand. We're beyond all that now. And the outreach committee, in being involved with these underserved or unserved areas of the state, we can provide them a package. We can provide them a handbook, a dispute resolution handbook in Georgia that pretty much goes from soup to nuts as to what all is involved, how it's done, how you go about it, what the elements are, and the whole package. That was put together by the office and not the commission. The commission were certainly appreciated all the work that went into it, but that was Tracy and Carly's work. It was their job. Another thing we have done is because it all, like everything else these days, the rest of our universe is run by a computer. When I became involved in this commission several years ago, it was astounding to me, and because I sit in Atlanta like most of y'all do probably, and we don't get out beyond immediate metropolitan Atlanta, and you're not aware of the different situations and different problems that occur in this state, or different challenges that are encountered by ADR program administrators in different parts of the state. In Atlanta and Decatur and DeKalb and Gwinnett and Cobb and Clayton and all the ones that we see on a regular basis, we take it for granted that the ADR programs are financed and that they have money to do the things that are necessary to do it, that they have the computers, that they have the software, that they have all the tools that one needs to set up a court-administered ADR program. Well, trust me, when you get outside the major metropolitan areas of the state, the Macons, the Albany's, well, even Albany didn't have a program, but Savannah, Athens, Rome, Macon, fill in the blank. There are a lot of places. A lot of places with ADR programs who just don't have the money. I mean, when I first got involved in this, there were folks in some of the rural counties of the state who were trying to run ADR programs on what was essentially a 1978 IBM PC Junior with software that didn't work. Well, one of the things the commission and the office did was to commission the creation of software, and we bought it. We pay for it. So we have been able to provide that to some of these places, more rural counties in the state, and we can provide it to the new counties when they come on board. Here's the package. Here's the software. You don't have to pay for it. We're going to give it to you. We keep it up. We keep it maintained. And the outreach committee has worked very hard with Tracy and the office to try to make it easier for people to put in programs in this state where they don't have programs. That is one of the major things we have undertaken, and it's not just software. It reaches all the way across the whole nut. And because we have on the commission, we have ADR administrators such as Randy Weiland from down in southeast Georgia. We have people who can answer questions. We have people who can help guide the process. And Randy, I know, is already involved down in Waycross and Ware County with those folks down there. Outreach is we are the evangelists. We are the folks who are from the commission who can reach out to the various different constituents of ADR or DR. There's no A in it anymore because it's not alternative. It's the way things work. And reach out to the different constituents, different people in different places, and who have different needs, and try to address those. It's been very, very rewarding because I think our committee members, who are all very dedicated professionals and who, again, are scattered from Fort Mountain to the Florida line, understand, have been there, understand it, know what's going on, and have concrete advice, they can answer questions with concrete answers, and provide guidance to some places in the state who just don't have the money or the wherewithal to be able to do that on their own.
I think that's a good segue into some of the duties, Hal. And we've talked about some of these, but certainly approving court programs. They're not just set up by the local courts. There are actually rules and that they have to follow and things they have to do. And now we have policies on maintaining good standing to oversee the development, ensure the quality of all those programs is part of the commission's duties. And I will say, just having been involved in national conferences where state directors get together, Georgia is by far one of the more advanced states in organized dispute resolution. We're one of 5 states that has a Supreme Court commission. We have statewide rules. And so it allows us, even though Georgia's not uniform and there's some challenges with rolling out anything on a statewide basis, the way that it is structured allows us to, as Hal said, be able to reach out, be able to onboard new programs, encourage the use of more mediation. And we're doing that through a lot of our projects through the office.
Before you go there, Tracy,
yes.
let me go back, if I may, just go back to the outreach issues. I mean, the outreach issues are to the level that if there are folks who are coming on board, there are folks who are entering into the process. Not only are the commission outreach folks available to help out, Tracy will drive to wherever it is that needs to be driven to and meet and sit down with folks and explain to them and answer their questions and be able to, help them through this exercise. And she comes there from the point of view of somebody who ran for a number of years. She was a ADR program administrator in West Georgia, and she comes to us. We have the benefit. The commission has the benefit. The state DR community has the benefit of having somebody run the Office of Dispute Resolution who has been in the trenches, and that's we couldn't. That's beyond anybody's wildest dreams. One other thing that the outreach committee tries to do, and the office again runs and does the legwork for it, are the annual ADR program administrator conferences. We actually go out. Tracy sets it up. Tracy and Carly set it up. It's been in Athens. It's been in St. Simons. It's been in Savannah. It's going to be in Atlanta this year, where we invite the ADR program administrators in and say, what can we do for you? What do you need? What questions do you have? We're not just people in Atlanta who sit around thinking great thoughts. We want to make your jobs easier and better. And Tracy and Carly have done a spectacular job of setting up those programs. And my committee, I'm very proud to say my committee goes to those meetings. We go to those conferences because we want to know what somebody in Effingham County, what problems they have, because I'll guarantee you they're different than the problems we have in Atlanta. Now, Tracy, I'm sorry.
Oh, no, thank you, Hal. And thank you for that. Like you said, it's Carly and I at the office. And so you've got half the office here with you today. We do get support from the administrative office support. So a lot of our legal and our IT and our HR, a lot of that is handled by the AOC, thank goodness, because we couldn't do it all. Just a few things, the duties. We are the administrative arm of the commission. So while the commission sets the standards for neutrals, we actually register the neutrals. So once they set those standards, then we provide the means for them to do that. We are currently at about 3,000 registered neutrals. When I first started 7 years ago, we were right at 2,000. So we are not only bringing on more neutrals, so we're maintaining and retaining those neutrals. We do provide technical assistance to new and existing court programs. Alapaha Judicial Circuit has a new ADR director. So I will be driving down to Homerville in a few weeks and meeting with her, getting her up board. The other thing we do is collect statistics. And as Hal said, there's been a lot of challenges with collecting statistics across the state, because some people are using paper and pen, some people are using some software that was developed back in the 90s. So with the new case management software that we have developed and we have made available to all the programs, programs can use that. They don't have to, but it collects all the statistics that we need to be able to show what we're doing in Georgia, because that's where we're lacking, is being able to show what we're doing. And so starting this coming year, 2024, programs are required to collect certain data elements. And this will help us get this information and be able to put it out there and really highlight the work that's being done in Georgia. Programs must do this whether or not they use the case management system. They can modify theirs if they want, but it at least allows, there's something for those programs to be able to collect that information. Really quickly, just because I know we're getting short on time, just the neutral registration. If you're interested, if you're not registered, you take the approved training, you get the initial registration, you get 3 hours of continuing education, which is really easy, especially things like this. And then there's annual registration renewal. So I'm going to talk just a minute, but we've actually added probate mediation to the registration categories. So this is sort of a diagram, but as you can see, to be a probate mediator now, you'll first have to be a general civil. You don't have to be a domestic, but you do have to be general civil. So this just kind of is a visual graph of the registration and the categories. What you have to do first. They do build upon one another. So probate mediation. The commission this year approved to add probate mediation to the categories. And this was after about a year to working group that involved the Probate Judges Council. We had judges on there, we had trainers, we had members who also had done some probate mediation. And we just felt like it's a specialized court. They have specialized issues. They have very unique issues. And so why don't we have specialized training for that? We're going to do some initial training with the court program starting next year. And then July 1, 2024, it will be opened up to whomever wants to take that training. Mediators will have until July 1st, 2025 in order to get that training to be able to mediate court-ordered probate cases. We have rolled out an entire training and education plan where we have actually, I went last week to the Probate Judges Conference and talked to them. And we've been in making sure we get before people. So if there's anybody you'd like for us to talk to or talk about this effort, we're happy to get out there and get in front of them. Ellie Lanier from UGA, well, formerly from UGA, who's done a lot of work in probate, has been a driving force in this area. So we're very excited. This is really a passion project for me, and I'd love to see more probate courts send cases to mediation because it is families, and there are issues that could be helped by using mediation. I know.
Well, and Tracy, I think that you hit the nail on the head that y'all, not we, y'all, did get involved with the probate council. The probate judges.
Yes. It was awesome.
And one of the driving forces, I think, behind that whole exercise is the fact that probate judges are tired of dealing with people like me who are construction lawyers who last time they knew anything about probate was when they were in law school. And they're coming into probate cases saying, I'm here to qualify to mediate these probate cases because I've been a mediator for 25 years and I don't even know the right words. So that the whole goal of that is to educate a group of people who are qualified mediators, make sure they understand the probate process. So when they get involved, they're not creating more problems than they are resolving.
And we talked about the other things. So I just want to put this up here. That is our website. That is our email address. We are here to serve. If you have ethical questions, if you have issues, please reach out. If I don't know the answer, I promise you I will find the answer for you. And we truly are a service organization. And we just want to be here for you. So thank you for this opportunity.
Tracy, Hal, thank you so much for taking the time to talk with us this morning. I can't think of a better way to start a day like today, but from hearing from both of you about the Georgia Office of Dispute Resolution on the Georgia Commission on Dispute Resolution. So we all kind of know where we're starting from in terms of the organizations that are out there to support us doing the work that we're doing. So it's really important to understand that. I want, Tracy, before you jump off, I want you to give a plug for the November 16th program.
Thank you. And it was on that last slide, and I think it was being hidden. But we have the ADR Institute. It is November 16th at the State Bar. It is a Thursday, so it's a little bit different, but we've got a great lineup. You have until November the 5th to register. It is in person, so I know these virtuals are great and they're convenient, and we love them because it allows so much more access. But in person also gives you that that networking. So we're excited. We will be giving out the Clark Award, which is the most prestigious award. We have a past recipient here, Mr. Hal Gray. And so we're very excited about that. And thank you, Scott. I would have been remiss if I had not mentioned that.
Yeah, we hope that everybody's attending today can attend the November 16th program. Again, more information to learn to strengthen your practices. So again, Tracy and Hal, thank you. And Tracy, congratulations on Dispute Resolution Week. That's pretty cool. The proclamation, for those of you who joined us just the last few minutes, Tracy was able to get through the Governor a Dispute Resolution Week proclamation, supporting not just the week, but also our Global Conflict Resolution Day. So thank you both again for joining us this morning.
Thank you, Scott. Thanks for letting us come to the party.
All right, we're going to move on to our next session. And for those of you who have joined us, I saw people joining on to the Zoom as the program was continuing. Wanted to remind you again that the materials have been provided. You have the bios on all the speakers that we have today. So I'm not really going to introduce our speakers at each session, ask you to look at the bio information. But let's get started. Let me tell you a little bit about this program as we begin. It was a really sort of unique opportunity for the Georgia ADR section to invite representatives of some of the larger mediation companies in Georgia to gather together in a panel and talk about the world of mediation from their experiences and sort of understanding that they carry a lot of the work of mediation in the state. So I thought it'd be fascinating to get them together. We have the benefit of Ken Kendrick from Henning, Judge Gail Tucson from JAMS, Parag Shah from Miles, and Nigel Wright from NAM to join us today. So I welcome each of you as you pop up on our panel, and we can begin our conversation once we all get loaded. So welcome. Good morning, everybody.
Good morning.
Morning.
So let's just jump into it. I know that we've talked a little bit to prepare for today, and we wanted to make sure the audience of participants got an opportunity to learn from each of you. So let me just start with this question, and I'll ask each of you. Interested in knowing from each of you, basically personally, what you see as the future trends for ADR, either as an advocate or a neutral. What do you see going forward? Judge Tucson, why don't you get us started?
Well, thanks, Scott, and good morning to everyone and to my panelists. Good to see you. I was happy to see that one of the current projects for the Georgia Office of Dispute Resolution is actually outreach efforts to underserved sections of the state, because I definitely kind of using my judicial and access to justice lens, see this as important as we move forward. I think court systems certainly have come to appreciate even more as a result of the last few years in the pandemic, the value of virtual sessions and technology in assisting the court systems and keeping up with the pace of court filings, adhering to court clearance rates, that are imposed by various entities, and providing citizens with an opportunity to resolve their disputes virtually. But I think it's important, and I'll be interested in seeing how we can better address making sure that we are, as courts are continuing to rely on this, that we're making sure that citizens have true access. And certainly in our rural areas and underserved communities, individuals don't have the same access, the same bandwidth and access to devices that we have here in urban settings. And so I think that is important. And I look forward to working to assure that individuals, when they're ordered perhaps to jump on a Zoom, that they will understand the value of it and not feel that their right to a day in court is being compromised by imposing technology on them.
Ken, what do you think?
Well, I want to look back a little bit because I think perspective of history is important in seeing where we're going. In 1994, I participated in my first mediation court-ordered federal court. I'd never heard of it. As a result of that, the mediator encouraged me to go up and get training at Harvard, which I did with Frank Sander, and was exposed to people from all over the country who were doing this, and realized we didn't even have a bar section. Came back, got together with Ed Henning primarily and Jack Etheridge and said, let's start a bar section in Georgia. We organized it. Judge Tucson, you'll be happy to know that Jack Etheridge was our first chairman. I'll put in a plug for the ADR Institute that Ed Henning organized the first one, and to see how far that's come, Tracy and Hal, to see what you all have done over the period of time in the last 20, 30 years, just amazing in terms of institutionalizing mediation and ADR as part of our justice system. A long way to go, though. I mean, having seen how far it's come, it's been 15 years since the Vanishing Jury Trial research was published, showing that 98% plus of all civil cases in this country are decided outside of a courtroom. And I would say we are still on the front end of dedicating 98% of our resources toward what happens 98% of the time. In law schools, we still spend, I suspect, more time teaching evidence, civil procedure, and what happens in a courtroom than we do what happens in how disputes are really resolved. So I'm encouraged, and I really appreciate the work of the commission, the Georgia Bar Section, where it's come since we first organized it, and just see we still got a long way to go, but you guys have certainly done a great job in creating a foundation for that. Especially, again, I want to add the Uniform Mediation Act, and finally defining the scope of confidentiality in Georgia has just been a great benefit.
Nigel?
Thank you, Scott. I think mediation is really just going to grow. To echo Ken's comments, I started mediating like many, many years ago, and I had never heard of it when I think it was almost 30 years ago, I did my first mediation, which was over in London with a center called CEDA, which had just started up, and it was selling its wares to the insurance industry. And I think that what's happened in the meantime is that a lot of lawyers, particularly in Georgia, but also other states, have realized that mediation is a great way to resolve your case. However, a lot of parties still need to work, in my personal view, on pre-resolution strategies and using mediators, for example, in e-discovery disputes, in other discovery disputes, in trying to narrow down the issues. For those of you that do construction defect, you often have multi-parties, you have subs, you have main contractors, and using mediation just to whittle those down, irrespective of resolving the actual case, has tremendous advantage. So I think that, in my own personal view, over the next 5-10 years, I hope that we're going to see mediation become just part of the strategy of litigation to reduce expense and reduce conflict and to narrow down the issues.
Thank you. Now, last but not least, Parag.
Oh, thank you, Scott. I appreciate it. The future trend for ADR is clients want more than their disputes resolved. What they want is a personalized ADR experience. If you look at all other industries, that's what they're doing. So if you look at streaming services, not like Netflix, they are providing you a personalized experience based on what you're watching. If you look at Amazon, they're providing you a personalized experience based on what you're buying. If you're looking at social media, they're providing you a personalized experience by what you're looking at. In the ADR field, in the company, what a personalized experience means is providing clients with a number of things: efficiency, affordability, diversity, what Judge Tucson said, accessibility. There are multiple factors that go into the experience. And these are the pillars that will enhance the customer experience. Companies that are not focused on that for the future are going to die a slow death. And I say that because the way we operate is it has to be client-centric. And the future trend is that's what clients want, and that's what a client wants, and that's what we have to provide. So that's where I see the future happening, a more personalized ADR experience.
Well, you mentioned the client side, and that sort of is a perfect segue into a broader conversation for all of us with respect to what, and when we say clients, folks that are in the midst of dispute that come to all of us for resolution. What is happening for them to make their experiences better and work towards a resolution? So let me ask each of you, and now this is sort of a free-for-all for comment here. This whole transition from live mediation to virtual, maybe back to live, the different types of mediations, whether they be personal injury or commercial. Talk to us about the shifting the world of mediation in these contexts. What's working best out there to help people solve their problems? Anyone?
Scott, if I can screen share for a second.
Sure.
As
long as Lane makes sure he gives you authority to do so.
Yeah. Let me see. First of all, I've got to get my view up. The National Association of Distinguished Neutrals did a very comprehensive review of this and surveyed almost 1,200 neutrals in terms of post-pandemic practice. And I'll share a couple of slides from this. It was 1,100 neutrals who were members. They got a remarkably high participation in the United States, 85%. Here's a map of post-pandemic virtual versus hybrid versus in-person mediations, contrary to my practice, which has almost gone back to almost all in-person. But you can see where in the bright blue, there has been a very high percentage of virtual, continuing the top virtual states being Hawaii, Vermont, New Mexico, Florida, surprisingly, Maine, California, not surprisingly. The least virtual usage going on in the Deep South in Alabama, Mississippi, and Louisiana. I want to skip through. They also took a look at people who are doing virtual only and people who are doing mediators who are doing in-person only. On the right side, you'll see in the dark magenta the in-person onlys, and the left side, you'll see the virtual onlys. These are people who are only doing virtual mediations, won't do in person, and they outnumber the in-persons 5 to 1. Again, very surprising and contrary to my personal experience, but as Parag said, all this being customer focused, what are customers asking for? Different in different parts of the country, but some pretty surprising results.
Yeah, and if I could follow up with that, I like to compare our clients to Delta customers because above all else, they want quality. And so for an ADR company, what quality means is you have the best neutrals and you have the best customer service. That's kind of the core aspect of it. And it all goes, but what the clients want is a little bit of what Ken was saying, which is they want choice. So for example, if I take the Delta analogy, if I'm going out of the country, maybe I want to fly Delta first class. I want to sleep. I want that nice meal. I want all that. But if I'm flying to Savannah, maybe I want to save a little bit, fly coach, middle seat, by the bathroom. But I have all those options, but the core quality is still the same. And so that's where I also see the data shows. So for example, we have two different products. We have ADR on demand, which is about convenience, affordability. And then we have the Miles standard premium brand. And what we will find is the same client will choose ADR on demand for a auto case under 100,000, 3 hours virtual, and want to pay a flat fee and have a mediator assigned to them. That same client will the next week have a $1 million case and prefer an in-person experience, be able to select their mediator and those type of things. So I think one of the things that you can have a client that wants a personalized ADR experience, but what that means also is they want choice within that quality brand. And that's kind of where our data is a little bit different than what the NADN. Ours is based on what the clients have chosen. And in the states, we're in the states in the Southeast, Florida, Georgia, South Carolina, North Carolina, Tennessee. It varies by jurisdiction, like Florida, highly virtual, Georgia, not as highly virtual. Varies by practice area, auto, very virtual, employment, construction, very in person. And so there are different distinguishing factors, but what you'll find is it's all about the client's preference. And you have to be able to provide those options if you want to continue to grow your business as a company, as an ADR company.
So I agree with what my colleagues have said. Flexibility, I think, is another word to kind of apply to what we're talking about. Just recently, with the virtual platform, I was asked to consider the fact that one of the parties was going to be overseas, and because of the time difference, needed to start much, much later in what we would consider a regular workday as a start point. And so I said, sure, if that's what the client needs, I'll take a nap, whatever I need to do in order to, to start at 5 and move into the evening. JAMS over the last year has experienced a decline in the number of purely virtual mediations. I would say probably 75% of our caseload currently is hybrid, which again, I think talks to the flexibility. You have, some parties in person, some parties together, someone virtual, not in the same location. Personally, I have seen more virtual and hybrid cases on my own practice over the last few years as opposed to in person. But we remain willing to provide whatever the client needs, and certainly have actually through COVID renovated our space to be able to make it a more comfortable space for those in-person opportunities. I think when we also talk about, what the client wants and needs, we need to keep in mind the pre-mediation session preparation time, because I think that's very important. I think many of us engage in opportunities to get to know the clients and counsel and the issues prior to the actual day of the mediation. And I think when we are kind of tracking, well, how long does a typical mediation take, it's important to make sure that we're talking, including the pre-time as well as the time afterwards, because as we all know, the case may not necessarily resolve the day of the mediation, but certainly is likely to resolve as a result of the mediation in terms of the time that the neutral puts in afterwards in working with the parties and counsel.
Okay. I just want to add a couple of comments to that. I actually completely agree with Parag. I think that things are really moving to a client experience. And what we're seeing at NAM, and I should distinguish between there's NAM, the company, and then there's the mediator. And the data analytics and the interests of those are not necessarily aligned. Mediators, to my understanding, are always independent contractors. They are always neutral, and their responsibility is to, both parties or 5 parties or however many parties it is. So I just thought give that little caveat beforehand. So I'm just going to share very quickly what NAM are doing, and they are working with a number of different carriers and different companies. And what they're trying to do is seek arrangements. So to Parag's point, they're talking to these companies and saying, look, we can resolve all of these issues for you. Enter an agreement with us, and we can help you nationally or locally or whatever it happens to be. But I think one of the things to really remember is that it is a choice. And so it doesn't mean that that's the right way to go. And there's always at least 2 parties in any mediation. So I thought I'd just very quickly share that screen. And of course, now I'm trying to get off it. And just generally speaking, I think we need to really distinguish between the interests of the companies and the interests of the mediators. The interest of the mediators is to help both the parties, and the companies, of course, is to spread their influence and try and attract as many clients as possible.
I think it's a fascinating discussion to start with Ken, who talks about the sort of the origin story of mediation, how it came to be, this evolution from litigation to wanting some dispute resolution, to what Nigel, what you just showed, which shows to some degree the corporate element of the mediation business. So it's just fascinating to see how far we've come in 30, 40 years of this world. But on that aspect of the evolution of mediation, there's so many elements that I know have affected each of you, and you want to talk about with regard to the ethical considerations that apply as mediation grows. The issues of AI, Chat GPT, or other technology that impacts what mediation is becoming. So let's chat about that. Nigel, I know that was one of your first issues. Tell us your thought on what's happening out there on the AI side.
Well, most people have heard about the Avianca case in New York, where an unfortunate plaintiff lawyer used GPT-4 in order to obtain citations and cases to support his case in relation to a claim against the airline. And the law firm on the other side, which is a very well-known and experienced aviation law firm, didn't recognize any of the cases. So they raised it. And it turned out that the cases were made up by AI and weren't real cases at all. Now, I don't want to get into the ins and outs of what happened, but I know that the plaintiff lawyer was exceptionally apologetic and basically threw himself on the mercy of the court. And that issue, I think, is still ongoing in other areas. But the simple point is that AI is a great tool. And if, as a lawyer, you're not using the AI, you're probably behind the curve. And as a mediator, if you're not thinking about AI, you're also probably behind the curve. And the reason I say that is that if you think about it to its logical conclusion, the more data points you have, the more likely it is you should be able to predict the outcome of any resolution or dispute. So you can see it being an exceptionally helpful tool in three particular areas. The first area, in my personal view, is relatively low value personal injury claims, where it isn't that different from either party's perspective, but maybe there's a small difference between the two. I think AI is going to have a big influence there. I think also coverage is one area. And I know the policyholder lawyers are going to tell me correctly that there are nuances and there are issues involved, which there are. But the outcome of the Court of Appeals decision or the Supreme Court decision on the interpretation of a different policy, although based on fact, may actually be a lot clearer with AI in use, because it's going to be easier for the parties to get to that issue. And I think really the third issue is a mediator. I've had a number of mediations, as I'm sure everybody else has, where you get a lever, what I call a lever arch file, three ring whole binder full of documentation, and you're asked to read it and review it. And you're typically a little bit terrified because you know that if you did read every word, there might be some discussion about how much you charged. So you get this information. Well, in an ideal world, if I could scan that through an AI app, and it could tell me the top 5 arguments for and against, and then I got another binder from the other party or other parties, and it did the same thing, then I could print out a 2 or 3 page analysis of that. And my work as a mediator is so much easier because I'm not going to waste a lot of time. Having said that, those of you who have endured long mediations will know that often decision-making is like trying to turn around a super tanker. So it doesn't necessarily happen overnight. And I'm not saying that knowing, quote, the answer is going to help you. But what it will do is it will mean that your mediators are a lot more focused on what the real issues are, rather than, you know, did you have a nice game of golf last weekend?
Scott, I'll jump in our session. I was concerned about what the collision between ethical considerations are and how you build a data set that would be used by AI to be a predictor. And I want to start by saying, Nigel, that I'm one of those guys who's way behind the curve. I actually made a reference yesterday in the mediation to a little band called The Who, and one of the young lawyers in the session had never heard of them. I said, well, I'm just going to go home and start drinking heavily. I mean, so I want to qualify this by saying that I'm completely out of touch. But AI, it seems to me, is the idea in identifying those 5 basic arguments is still looking solely to a litigation prediction outcome, which is only one aspect of what we do in mediation, at least in the commercial cases that I do. And again, if I can share screen and do a better job of it this time, the commission talked about how long they worked on obtaining the statutory basis for confidentiality and mediation, all communications in a mediation being confidential. And if yes, you have laws, yes, you can look at appellate arguments, but the data about how cases are settling that would give you a predictor, say, of a range of a possible settlement has got to come from mediation experiences. And it has caused me to wonder, is the future going to involve, I sign up for mediation somewhere with a mediator, and I've got to click the box that say, did you read my privacy policy? And instead of a disclosure about, well, this is what confidentiality and mediation means, but now have you read my privacy policy, which is going to let me disclose data about this mediation and about your experience and about your claim into some sort of data collection. Is it going to start looking like HIPAA, for example, where, and nobody reads that stuff, so you don't know what you're giving up. It seems to me like the cornerstone of the mediation experience, at least for the people that I deal with, has to do with confidentiality. It's the reason it works. The ability to have a conversation in a very unique place where what you're saying, what you're providing won't be shared is what makes the practice unique. I totally get your point. I've seen automobile cases. I mean, there's no doubt that Allstate, State Farm, nationwide carriers have bell curves out there about how they're going to treat certain cases, and they don't care about the outliers because they're built into the model. I don't know how that works in divorces. I don't know how that works in a lot of construction cases that you brought up, where very complex fact situations in one may not translate to another, or deal gone bads or professional liability cases that are the sorts of things that I do. But interesting subject. We need to keep up with our old music too.
Very, very interesting. I agree with Nigel in that, you know, every time I read an article or hear a session on AI, I come away even more informed, but also a little wary of of, you know, where my role fits in all of this, and you know, being able to rely, I guess, on what's being presented to you. But in my practice, I do enjoy working with smaller companies and with startups. And I think that AI and generative AI and our uncertainty about how our courts are going to respond to issues and disputes involving AI is brought to their attention is a good reason to consider ADR as an alternative for trying to work through and have more control over the outcome in terms of these disputes. I'd like to refer the participants to an recent article published by a couple of my colleagues at JAMS, Judge Lucky, as well as Erica Briscoe, and talking about startups and some of the AI issues involving, you know, infringement, involving the human contribution factor for purposes of intellectual property and protections, as well as the human factor and who is the author and protecting trade secrets involving this AI as far as the companies are concerned. And I think that this is an opportunity for us as neutrals to become informed, but also to become instrumental in trying to establish kind of what should be the safeguards, what should be the standards for use of AI, and, you know, what is acceptable and responsible conduct among our clients.
I have a different kind of take on how to use AI. I think it's definitely what Nigel said, it's a tool, it's an aid, it's not a substitute. And the way that, so I think it's very beneficial for solo practitioner mediators and arbitrators. And here's how. One of the greatest benefits of being part of an organization that has 85 people, we have tons of people in the lobby right now going to mediation, is that at any point during the mediation, if a mediator needs to work an issue or figure out how they're going to kind of work the process, they can talk to other people. Independent mediators don't really have that option. And so AI is a great kind of party or colleague to talk with. And so here's 3 conflict rules that I use. Anytime you want to say the word you, substitute it with I. Anytime you want to say the word but, substitute it with and. Anytime you want to ask a question with why, substitute it with how. But it's easier said than done. Instead of why are you offering that, you might say, how did you come up with that evaluation? That subtle difference changes how the mediation happens, but it's hard. In the heat of a mediation, things are going up, someone's blowing up, something's happening, this offer is here, it's going to make the other person mad. And you can put in ChatGPT, you can say, how do I ask this question? Or how do I ask a question where I can de-escalate or send this message or say it in a different way? This is what I want to say. So you go from your gut, this is what I want to say. How can I say it that's in a more de-escalating tone or different things of that nature? And so in that sense, I find it very useful as a kind of a companion partner, someone to go with. But the other piece of all this is there is a human touch element. Trust, I believe, is an emotion. And, as much as awesome as this is, I can't do this with any of you. And there's something about touch, there's something about senses, there's something about energy that changes a dynamic. And it depends on the case. So, in a lot of employment cases, it is about emotion. If you're talking about a business divorce, sometimes it's a lot more than just about the negotiation. Family law, those type of things as well. So what I'm saying is it's the human touch, but everybody needs help. You're not going to be on it all the time. And in the heat of the moment, it's very hard. And mediators get flustered. Arbitrators get flustered. And sometimes you need someone to you need to take a breath, and you need to be able to ask someone, how do I keep this process going? Because the last thing any mediator wants is for the people to walk out. Nobody wants that.
I'd like to continue this conversation just for a minute before we move on, because what you're talking about is the personal aspects of a mediator, the skill of a mediator to help resolve a dispute. And that seems to me to be the unique element of who your mediator is their skill of helping the parties reach a dispute. I think about AI, I think about a computer acting in that place. And I agree with you, Parag. It just doesn't seem to me that would be successful. So I'm just looking for your input about the skills, the quality, the personality of the mediator being a relevant piece of the success of a mediation.
Can I just jump in very, very quickly? And I know you asked one question, and like all good lawyers, I'm not answering that and answering a different question. But Ken mentioned the ethical issue. And I do think that's something that everyone needs to be aware of in terms of privacy. What do your mediation center's terms and conditions say? Are you allowed to share it? But I think one of the things that law firms have been working on this for some time now. And I think what you'll find is that certainly the large law firms and the more entrepreneurial, smaller law firms are building their own version of ChatGPT-4, where they are inputting the data and therefore they own the data. So they're doing what I'm saying will probably happen in the mediation world. They're just doing it in a confidential way. And I suspect that somebody in one of the main and everyone and probably every organization represented here, ultimately we're all going to have our own version, and we're all going to be using it somehow so that we aren't foul of any confidentiality agreement, and that we can ethically have data points which are helpful. And then just in terms of talking about the skills, I did talk about turning a super tanker around, which is one of my favorite analogies, because when you're dealing with in many ways, any kind of case, it is emotional. That's why there's a dispute. If there wasn't a dispute, you probably wouldn't have nearly as much litigation, and it certainly wouldn't go as long as often it does. So I think Ken, with his work, he has to persuade a GC, a COO, and maybe even a CEO, to do something that they have maybe invested personal capital in taking the opposite position. And that does take time. It is. And so what I'm basically saying with the use of data from ChatGPT or other AI facilities is that you're going to get to those issues quicker. Just because you get to them quicker as a mediator doesn't mean it's going to be quicker in resolving the case. It just means you're not going to spend the first 3 hours talking about the who incidentally I do know, Ken. Just
Oh, excellent. Good to know. I suggested that he go watch the movie Woodstock, the original one, but I'm not sure. I want to go back to what your question, Scott, and Parag said. No matter how it gets started, no matter how you get an understanding of the issues, whether it's from a ChatGPT prompt, meeting, like Judge Toussaint said, with parties beforehand, sooner or later, I mean, my goal in mediation is always to try to find where the human beings are. I will say sometimes I'm successful in that, and sometimes I'm not. It's in systems-based dispute resolution. There were earlier this month, I was involved in a 2-day mediation. That's an MDL case that involved, a collection of hundreds of lawsuits, members of an executive committee. They are looking for a system-wide resolution of a whole group of somewhat similar cases. And that was a very different conversation, but the vast majority of the mediations that I do, whether they're business problems, especially involving professional liability, especially involving business breakups, where people are hugely involved in what happens with their life. Ultimately, there are going to be human beings involved, and there'll be a law element, but much bigger than that, there'll be a human element, emotions, what's going to happen at the end of this, where do I end up? Things that the courts can't take into consideration, but a mediator can, especially in terms of hearing and responding to them. So I think Parag's just exactly right that when we lose that element of a mediation or the mediation process, I'm just not sure where it goes from there.
So when parties come back, when counsel come back and reuse mediators, it's typically because they have seen something in the mediators' interaction with former clients that they think might be helpful going forward, in addition to whatever their expertise may be in a particular subject area. But I think the human element cannot be taken for granted, especially in I do a good bit of family law mediations, and in that instance, I do find that it's really important and usually will help the parties if I can actually connect with the parties and get past the attorneys. And so by that, I mean, sometimes I think the attorneys come into the process very protective, as we understand they need to be, of their respective clients. But their sense of the outcome is not necessarily the client's feeling of what would be satisfactory, what they feel would be fair. And I think it's important for the advocate to make sure that they permit room for the neutral that they've selected to actually establish a rapport, speak not outside of their presence, but directly to the clients in order to kind of get past kind of what the legal positions are, and ultimately in a very highly emotional, personal kind of a controversy, find out what will make each party feel like they've been heard and like they're going to be able to leave, with some dignity and satisfied economically, especially with the outcome, as well as what will be in the best interest of their family going forward.
And Scott, if I may jump in, I want to answer your question in this way, which is, me and another mediator, we have this argument all the time. He believes mediators are born. I believe they're made. When I joined in 2015, I'd never mediated a case. John Miles made a push to get a more diverse, younger group of neutrals in 2015. There were 5 of us, never mediated before. Within 3 years, we were mediating full time, based on having mentorship, training, and all those type of things. I kind of relate it to Moneyball, the movie Moneyball. Back then they used to pick baseball players based on their jaw, shoulders, those type of things. And then suddenly it went to, there are other things we need to look at, skills. It's about getting runs. And I know a lot of people believe, oh, you got to have this personality, you got to do all this stuff. But if you look at the people on the screen, we're all very different, but we're all very successful in what we do. And so the best way I can answer your question is, how do we select mediators? Is we are in the business of providing value to the client. That's it. So you as the mediator, you're here to provide value to the client. And clients want different things. They want cultural competency. They want to see someone they recognize on the other side. They want to be able to feel that they are trusted. And so one of the things that we do when we're selecting is we want people that focus on the client. That's what they want. They want to provide value to the client and want to make a career out of it. So the things that I don't like hearing, just FYI, if anyone's ever interested in coming to Miles and you say, these are things I don't like hearing. I hate the law, so I'm going to do this. You know what? I'm retiring and this sounds like a good gig. Or, I just need to supplement my income. I don't want to hear any of that, because you know what that says? It's about you. And we're not in the business of providing value to you. We're in the business of providing value to the client. And so I want to hear things like, litigation has gone crazy. We need to help more people get through the needs that they have. People are coming into a lot of mediation places and it's just like court. It feels just like court. It's alternative dispute resolution. It's an alternative to the normal court proceeding. If everything is just like court, just go to court. Just go to court. So that's how we're thinking about it. It's really skill, training, education, and client focus. And I think that's what the clients want.
Scott, if I can
I'm gonna
jump
use that.
in.
Well, go ahead, Ken, then because it is a good segue to this other question, but go ahead.
It was a hilarious experience. I followed up my training out of Pepperdine in 2008, and we're sitting in the first general session and people are talking about why they're there. And this young person raised their hand and said, well, I want to do this because I've been in litigation and I'm just so tired of being involved in conflict. And there were some of us who had been doing this for a while that just busted out like, I'm sorry, this was not where you wanted to come. This is what we do. We don't even get involved in the buildup. I mean, when we get involved, generally, there's front lines established and we just get dropped in the battlefield right between this. There's that and the people who say, I'm tired of this law practice stuff. I want to retire and be a mediator because that looks so easy. I know we're speaking to a lot of neutrals out there. When you do this, this. For me, it's like the first day of trial. It is physically exhausting, hard work. And I had that confirmed by a well-known litigator in the state that I was working with a couple of months ago, who came to me and said, people ask me to do this all the time and I never do. Finally, I did one. And at the end of it, I was trashed. I said, welcome aboard, sailor. This is what we do.
Well, both of those points are perfect segues to this next question. I actually received a question how do you define who a neutral is? Like what is a neutral to you? And let me broaden that question to also add for each of you that in your own companies, as you've been adding to your bench, kind of what Parag just said a second ago, how are you selecting your mediators to help you based on experience, diversity? What is a neutral, and what are you looking for helping you support your clients? So who wants to start?
So I'll start. I would define a neutral as a person who listens well, an active listener, someone who certainly has interpersonal skills to be able to relate and connect to a broad variety of people. Someone who the party can identify with in some way. And to that point, I want to talk a little bit about something that JAMS is doing that I'm proud of. We have a diversity fellows program, and I think it's pretty unique in the industry in that time and mentors and resources are being applied to individuals outside of JAMS who are interested in building their dispute resolution practices. We're grooming them, we're trying to support them, we're helping them with networking and resources, and they may ultimately become JAMS neutrals, but that's not the necessary point. We're trying to share our resources with the industry at large. And we have about 26 resolution centers across the country, but we are growing our panel by focusing on highly qualified neutrals in areas where we may not have an actual office or center, but we're reusing our kind of remote case management support system to bring them on board to make sure that individuals can access us regardless of where they may live within the country.
Anyone else? Neutrals and
Yeah,
skills.
I'd be happy to jump in. There are multiple data sets that we look at, and we have enough experience, enough mediators to see kind of what might make a neutral successful in their practice, but everybody has different goals. And so one of the things that as a company that we're focused on is where are we not providing value to the clients? Are there practice areas? Are there locations? Are there, let's take, Michael Eschman's going to be on here later today talking about language barriers in ADR. Is it, is it bilingual? The population is changing. Who our clients are today are not going to be our same clients 10, 15, 20 years from now. And are we looking forward to thinking about, are we going to be meeting those needs when that time comes? One of the things John Miles was always visionary about was he always saw around the curve. And I think that's honestly the big challenge I have. I'm no John Miles. And so it's constantly trying to think about what are going to be the needs and for the clients moving forward. And so aside from what Tucson said in terms of the personal characteristics, it's also about, what is it? What is the value that needs to be provided that's not out there? And so, and like I said, and you can be made, you can come from no experience, no nothing, but you got to have the continuing learning mindset because things are changing. And if you're not willing to change with the client, as clients change and as technology change, then we're not the right group. But I don't know many companies that it would work out for. You're then in it for a limited time period. There's no longevity to it.
Scott, I'm going to answer your questions in reverse order. Where do they come from? Henning has always had one of the leading training programs, I think, in the state, and well respected. I certainly went through the domestic training there, and that's a good way. That's one of the primary sources that Henning uses to spot folks who really are committed to being neutrals, committed to the practice of mediation and arbitration. When you have somebody who's going through a 40-hour training, you get to know them and see what their objectives are, and that's been a very successful source of finding neutrals and identifying great talent for Henning over time. On the question of what is a neutral, and I want to say this is highly personal to me. I know it's different for other people. I came to this and very slow, even after my initial training, several more years as trial lawyer, advocate, before I finally said, I've got to make the jump. But even after that, there got to be a point after 3 or 4 years of saying I'm a full-time neutral, where there was just a shift that happened, that I understood that I wasn't analyzing problems from the point of view of an advocate anymore, or a trial lawyer anymore. And it's very hard to describe. I would not be qualified to go back and be a trial lawyer these days. It's just a different perspective. I don't know how you get it other than doing this work for a while. I'm sure there are some people who are better at it, or quicker studies at it, but it'd be very difficult for me to be a practicing advocate and to be a true neutral at the same time. So that's sort of a very vague answer to your first question.
Okay, Scott, I'll just say a couple of words. I think with regard to what NAM is looking for, that's something that is probably better addressed by Marcy Dixon, who's talking later on today. She is driving Tapestry at NAM, which I'm actually part of, which is for specialists, and it's a very inclusive group of mediators. But with regard to what I think, and I always worry when as a mediator you use the word I, but what I think is important as a mediator, I think it's a willingness to work hard. I think you've got to really want to resolve that case, to Ken's point, right up until the last second. And you want to try and keep them there to, I think Parag said it earlier, as long as you can, not because you're trying to increase the hours, but because you're desperately trying to get the case resolved. So I think it is exhausting, and I think it's someone who's willing to do the work, and the work typically doesn't start on the day of the mediation. If you have a mediator that hasn't talked to you before the mediation, or you haven't had some discussion about the merits of your pre-mediation brief, that's a question for you. Now you might, why you selected that particular mediator. But also there are different needs that different parties have in different circumstances. And I think that it's very difficult for either a mediation center or alternatively a mediator to satisfy all of those needs. For example, you may have a personal injury case and your client, the plaintiff, may have unrealistic expectations. There are particular mediators who are good at that. On the other hand, you might consider that's not what you want. You want somebody who is a lot more sympathetic. There are different mediators for that. And so I think that it's really incumbent on the bar to do some work and research on who they're selecting and why they're selecting it. Are you selecting the person because you're very comfortable with them? And should you be comfortable if you're trying to resolve the case? So I really, maybe not really answering why mediation centers, select particular mediators, but I think what I'm asking is for the bar and for those listening to think about, why do you select a mediator? Have you thought through all of the issues that are important to you in your selection process? Because that is often the most critical decision that you're going to make in terms of whether you're going to resolve the case at mediation or not.
And the reality is the marketplace is gonna ferret that out. The ones that have the skills that are doing all those things, the clients are going to go to them. Those that aren't, they're not going to get any. So I think the marketplace is kind of the judge of, who can be a neutral.
And sometimes the clients maybe need some assistance, I guess, in achieving their goals, especially if they've set goals for purposes of diversifying the professionals that they're using to resolve their cases. In-house at JAMS, we have an actual report that is generated and provided to the clients that kind of reminds them of, the disputes, the neutrals that they have selected or used in the past. And the neutrals themselves are asked to kind of self-identify in terms of diversity, regardless of, experience, background, age, what their prior legal experiences have been, public defenders versus prosecutors, corporate attorneys, you like. And I think by receiving the report, it is a gentle reminder of the goal and our ability to provide the mediator or the neutral that may be best for a particular case with those guidelines in mind.
But I think for me, and this is really hard because going back to what Nigel said, we work hard to try to get cases settled, but the real value is I've seen mediation evolve, and was the reason that I was really drawn to it to begin with. It's the only place I know of where the client gets afforded the dignity to decide for themselves whether they want to do this, whether they want to resolve this, sometimes on terms very different than they thought would be acceptable when they walked in, but they get to decide, as opposed to, back when I was a trial lawyer, offering them the option of letting 6 or 12 registered voters decide for them, the outcome of a major life dispute. Some cases need to be tried. Some people get to make the decision that, no, that's the route I want to go. And I try to go into every mediation thinking, that ultimately this is not going to be my decision. And when you asked the question about what is a neutral, being willing to do your best work and then let other people decide for themselves, I think it's really just at the core of the practice, at least from as how I view it.
I think those are absolutely beautiful last words for this session, is as the neutrals that you're talking about allow people to control their decision-making for their disputes, is actually, I can't think of a more eloquent way to close this session with that philosophy. Boy, I just have to thank the four of you so much. This has really been an intellectual conversation in many ways, and a little frightening too about the AI pieces of this. But thank you for taking the time and the energy to join us today, and for teaching all of us, and very much appreciate your role in our ADR life here in Georgia. Thank you all.
Thank you. And I invite anybody that wants to talk further, or have questions, or ever need anything from us, please reach out anytime. Our door is always open. Thank you, Scott.
Thank you. All right, we will continue on schedule as we move to our next group. Boy, that's a tough act to follow, but I'm going to invite Lyle Warshauer and Judge Randy Rich to join us for their session on mediation, the new way to litigate. Hi, Lyle. How are you? Judge Rich, good morning.
Good morning.
I'm going to turn it over to the both of you. Again, for those of you who have joined us a little later in the morning, the bios of our speakers are contained in all the presentation materials that have been sent to you. If you have questions, please put them in the chat, and we will get back to asking these questions to the presenters at the end of the program. But I will turn it over to the both of you, and thank you both for being here and for educating our participants today.
Yeah, and I think Scott knows this change of format. We originally planned to have another mediator from Henning here, and we were going to have a panel. There's going to be some great Q&A, and we had to change the format sort of at the last minute. So I think the new format, Scott, if it's agreeable with you, is Lyle's going to ask me a question. I'm going to give a great answer, which I would normally do, and then I'll ask her some questions too, and it'll just be sort of a back and forth. And then at the end, we would like to save maybe 20 minutes or so to get questions from the folks, that are attendees to see if, if we can help answer any of their questions, if that works.
If they don't have questions, I have questions for you guys. So you'll do fine. I will jump off and leave it to the two of you. Thank you.
Okay.
Great, great. So Judge Rich, I think we talked a little bit about starting this off with me asking you some questions, and we'll do that. But just sort of to put it in context, I feel like our discussion is going to be very similar to the one that we just heard. We can just kind of expand on that. Many of the comments that were made by the panelists before, I think, speak to the topic that we have here. And we may kind of piggyback on some of that. But just sort of to put it in context of what we're doing and talking about the differences between trial and mediation, because that's kind of how I see this topic. We start with the concept that very few cases that are in the courts ultimately get resolved by way of trial. Some people may be surprised by the statistics that it's really less than 2%, maybe closer to 1% of cases are actually tried in this country, regardless of whether that's state court, federal court, or any type of case. So why is that? And I think what we'll ultimately learn today is that a large reason is because cases are getting resolved through this ADR process. But why is that so successful? And ADR mediation is very successful. Over 75% of cases that are mediated do resolve, maybe not the day of a mediation, but they do resolve through that process. There are some commentators that have suggested that the reason that trials are so rare now is that they've sort of become obsolete because of the process that litigation undergoes. Extensive discovery process and motion process. And because of all of that, the parties, cases are disposed through pretrial practice or ultimately through ADR. And I just wonder if you agree with that as a explanation for it, whether you've seen that in your practice as a judge and as a mediator.
Yeah, and you sent me some great questions last night, and I apologize I didn't get you questions, but you gave me a quote from some professor at Yale Law School, and I had never heard the quote, but it goes something like this. The litigants no longer go to trial because they no longer need to, and that's really true. And especially in civil litigation, you've got all these consumer cases that used to be, going to court, and they're going to be now by contract going to some sort of ADR thing. And then your big commercial cases, the ones that are nuclear power plant, construction and that kind of stuff, they're all going to have arbitration clauses that shift them out of the court system and go another route. I think when I was in law school, there was only one class on ADR, and that was it. And now they've got multiple classes, whole programs. They got the ADR competitions they do, competing with other ADR outcome procedures with other law schools, and it's just a whole new world. And I think it probably, the system works, and I think just like one of the last folks in the last panel said, some cases have to go to trial, like this big, the big Ford verdict that they had out in, not Ford, I guess it was Ford, out in Gwinnett County, and it was like some $1 billion verdict. And they probably tried to throw millions and millions of dollars at that case to make it not go to trial. But it had to go to trial. So, and it took, I think they had one mistrial. So it took 2 trials to get that outcome. But that was that case had to go to trial, but the system, in terms of making a just outcome happen, I think it still works. I believe in the system, but there are better routes too. Like some of the folks on the last panel were talking about, you get to choose your route. And if you've got a route and you've got a solution that saves you all the stress of a case going to the system, I think, you'd always want to choose that if you could, for whatever reason. anyway, I just think the whole world has changed in terms of making outcomes happen without everything, that used to be required to make an outcome happen.
Well, let me follow up on that a little bit, because we've all talked about how, mediation is beneficial for the efficiency and certainly the expense, to avoid the expense of a protracted litigation. But one of the reasons, or one of the explanations for why mediation is successful, is because we do have the backdrop of all of the knowledge that we gain through the litigation process leading up to the mediation. So if you've gone all the way through discovery and you've had motions, motion for summary judgment, analysis, everyone pretty much knows what the case is about and what the issues are going to be when it goes to trial. Of course, that's a costly endeavor to get there. Do you think that, in your experience, have you seen mediations being more successful if they are conducted sort of after everything is done, as opposed to an early, even pre-suit mediation where all of those things have not been fleshed out yet?
Yeah, and I guess there's going to be benefits at every stage, but the outcome obviously is going to vary. So if you got a even lawsuit demand, and you've got an adjuster that says, yeah, we've got some liability here, let's get this thing into mediation, you're probably going to get a better outcome from the adjuster side if you get that thing settled pretty quickly. You could still spend the money and go through a summary judgment route and all that sort of stuff, but your outcome, dollars out of your pocket from the insurance side, it's going to be probably more. And then after summary judgment, it's going to be even more. So there's every stage has its own benefit, for the parties. And of course, a plaintiff that never even has to file a lawsuit, they can really maximize their outcome, I think, way up here too. So benefits, or change, obviously, if you're going to be going to trial in a month or two, you've got a real incentive down here at this level, so sometimes all those things have to happen in order for you to, get the outcome that you want. So it's everything, I think, is just relative in terms of everyone's incentives, at those different phases to make it happen. And I've seen cases we mediate, didn't work, and then all of a sudden summary judgment comes out and the whole outcome changes. They want to come back to mediation because now the whole board has shifted. So every phase has its own I don't know what the word is, but I guess I would just say incentive per phase, in terms of where everybody sits.
And I've certainly been involved in cases where we've mediated multiple times throughout the course of the litigation, early, mid, and right before trial. This is a question I hadn't thought of before, but in instances where that happens, do you think it's beneficial to mediate a second or third time with the same mediator, or have a new perspective with a different mediator at that point?
Well, I guess it sort of depends on the parties, but I've seen it be successful both ways, meaning the same mediator, having a crack at it a couple of times, that can be very, very effective, because, even though things have shifted, perhaps they know the case, and it's going to be a little less the educational process trying to get the mediator up to speed. But then I've seen it be successful the other way too, where so-and-so tried 2 or 3 times, no success, and let's get a fresh set of, eyes and ears in here, and let's try to see if we can, have success with this new person. So, I think I can see it working, and I have seen it work both ways. And I would say every chance you get, try to go back to mediation if it didn't work out the first time, just because, it's still better to me than the alternative, which is an uncertain outcome with an uncertain dynamic on your hands in terms of length of the actual day that you get, a check in your hands or whatever it may be from a plaintiff standpoint.
Sure.
Did
you have something you wanted to tackle?
Well, yeah, I was going to ask you, guys, kind of touched on it yesterday with you a little bit, and I just think it'd be, I'm curious, but at the same time, I'd like the folks in the, the audience to hear kind of too. I think you're in this phase of, very successful practice, but you kind of wanted to transition a little bit into maybe being a full-time mediator down the road. And so I was just curious in terms of, tell me how that works for you in terms of making that happen.
Well, I mean, I love working cases. I love the intellectual exercise of it. I don't always love the schedule and being beholden to folks like you were at one time, where you'd say, be here, you have no choice, you must be here at that time, and traveling around the country to do depositions and the like. But I love working the case and understanding the issues and getting at solutions. And so I see to the points that each of the panelists before made, to be a mediator, you still have to work hard, and you have to think, and you just kind of do it from a different perspective. You take your advocacy hat off, and you work more at solving problems. And that's really what I see my strengths in what I've done as a litigator as well, sort of managing files from a higher level and having other people actually do the work, if you will, but coming up with the concepts and the solutions. So I see it as sort of doing more of the same. It is difficult to manage a practice and transition to mediation, because you still have all of those other obligations. But I think it's just a matter of choosing to do casework less and less. I think we've all been through that transition, those of us that have had practices and then transition to mediation. But to one point that Ken made earlier, I think that it is helpful to still be involved in the world of litigation, to be able to have that perspective when you're looking at a case, particularly a particular kind of case that maybe the mediator has experience in, to know about the risks and benefits, even just through motion practice. What is a judge likely to do with this issue if there is a summary judgment motion? While we're not expected to offer an opinion on how that would come out, if asked, we can do that a little bit. We can't say it's absolutely going to come down this way, but these are some things you might want to be thinking about in terms of risks. And I think the farther we get away from actually being engaged in the process, the less we have of a real perspective on that. So I think there's benefit to still having your foot in the water a little bit, so that you can provide that perspective if asked by the clients at mediation.
Yeah. I in terms of how much time would you think it would take? I know you're in the process now, but going from a full-time successful litigator to being a full-time successful mediator, what does that look like in terms of time?
I've heard it said, I think Parag even offered this at one point, that it's about a 3-year process. If your goal is to transition to full-time mediation, that, in the beginning, you're only going to be able to do a couple a month, and then it's going to increase. And I think you talked to your experience in that as well. But that it does take time, because you have to, it is client centric, right? So you need to work with some folks that where you get good results, or they feel like you worked really hard for them. And so then you get repeat customers, that type of thing. And so I think the 3-year mark is probably pretty realistic.
Yeah, and that does sound about right. Well, what's your next question for me then, if I may?
So this is something I've thought a lot about. We know that mediation, in contrast to litigation, requires that the parties be conciliatory rather than put on their advocacy, be advocacy, or certainly adversarial. But for a lot of people, the clients and the clients of the clients, so the ultimate parties, they consider the mediation to be their day in court often. And so they still need their counsel to advocate for them. And I'm just curious if you can explain or give some examples of some folks who were good at advocating while not being adversarial in the mediation process?
Yeah, of course, in the opening statement, you've got that opportunity to sort of like, here, neutral, here's my case, and here's why we're going to win on liability, here's why we're going to win on damages, and this is kind of what we think a jury would do with the case. And so you've got that, stand up 5 or 10 or 15 minutes, whatever you want to do, opportunity to advocate, in that opening statement room. But then I found it really important because, each side is going to have their own strengths, I can prove so-and-so ran the red light because I've got an ex-police officer. He was sitting two cars behind. He's going to testify. I've got the, plaintiff is going to testify, and I got a passenger in the plaintiff's car is going to testify. And so if that's a dispute, how is that going to shake out in a courtroom? You want that lawyer to be able to have those things kind of on demand, on their laptop, that you can pull it up, send it to the mediator. The mediator can show it to the other side in the other room to say, I think they're going to be able to prove that, your client ran the red light. Here's what they've got. And then if you've got something on the other side, 3 witnesses at the same red light and other cars that say the exact opposite, in the other room, you want to have those immediately available to say this dispute, we can't say for a fact how it's going to shake out. It may shake out on your side. It may not, so those things where you have immediate access, and videotapes too. I think, a lot of times you've got these dash cams, or trucking companies will have the cameras that show the actual impact. And some of those things are, critical for the adjuster to see that this is going to make a difference. This dynamic piece of evidence that, that they want me to focus on in this room, it's going to change that outcome probably, in one side or the other. So I feel like having a lawyer to have that immediate access to the evidence that, that's going to make or break their case. And then the advocacy and the opening statement obviously is critical too. And so I feel like if you have that immediate access and you have the, everything, you start off kind of adversarial, right? But as the day goes on, and now we're just talking about numbers, and things shift. So I feel like those, that shift is just natural, in terms of sitting there for 4 hours. But, at the end of the day, let's say you prove what you're going to prove, how are we going to resolve it with a dollar and cents, outcome?
Let me follow up a little bit on that, because you started off with the opening statement. And that, is an issue that a lot of people discuss in mediation. When I was, litigating cases 30 years ago, when we started doing ADR, we would prepare lengthy and, we call dog and pony show opening statements for mediation, where, PowerPoint and, clips from testimony, and that seems to have come, gone out of favor. And I think probably for good reason, for a couple of reasons, and I'm going to see if you agree with me or have a different take on it. First, I think if you prepare the mediator, and if you provide a mediation statement that you are willing to share with the other side, then everybody is on the same page in terms of the facts. If you are the plaintiff and you've already made a demand and you've tried to engage in some kind of negotiation, not always successful, but at least people know where you're coming from before you get there. That if you do the opening statement and really advocate in that, what you're doing is starting the process adversarial. You're going in there guns a-blazing, saying, we're going to beat you, whether it's the plaintiff or the defendant. And if you've got, a really hurt or grieving plaintiff, to hear the other side say whatever their strengths are, which often can be blaming the victim, so to speak, that you're not starting off on a very good footing for compromise and resolution. There are exceptions, though, where an opening, at least of some type, is really necessary. If only for getting back to the client needs to hear you advocate for them. What is your take? Are you a pro opening statement, or rather not have it kind of guy?
Yeah, I always leave it up to the parties, of course, but I found since COVID anyway, it really has almost dwindled down to almost nobody wants to do an opening anymore, and that's fine. And sometimes you're right, especially if you're going to point out defects in a plaintiff, injuries and, that kind of thing, that maybe it's a degenerative disease versus a recent injury kind of thing. Those kind of things tend not to work. So, if you end up going that route, you've just got to be so, we're just pointing out the strengths of this other side, not pointing out the weaknesses of you as a witness or whatever. I'd let the parties decide, but I found, I guess, that if I were picking and I was choosing, what I would prefer, I would say, probably not going to be that beneficial. But I know some mediators feel 100% differently, that they think that's the most beneficial time, that you can sit in the same room and everybody can sort of like, I understand we're going to try to resolve it. We're all going to be here in good faith. And that's, the less adversarial you can make it if you end up going, with an opening, that's always going to work better than, trying to do the adversarial thing. But I guess to me, the parties choose, and I'll go with whatever the parties want to do. And some adjusters I've found on the insurance side, that they want to be in that room and just say, "We're so sorry this happened. We're so sorry, and we want to take responsibility. We're going to disagree on some things, but we want to get this resolved, and we want to get you, back on your, whatever the outcome is."
And I think it's really important for everybody to at least have an opportunity to meet and know who's going to be involved in the process. It's hard if you're sitting in your little room, or you're with the plaintiff and you're having your discussions, and then you go to the other side, maybe multiple rooms, but those folks you don't want to virtually eliminate reality. You want to at least know who it is that's over there as the participant. And as a mediator, I want everyone to understand that these are people working really hard today to get this done. So you've got to at least meet and greet.
Yeah, I agree with that. Well, so your phrase you used a second ago, virtually eliminate reality. And I know you've got a question about Zoom mediations too, but I just wanted to ask you, from your perspective, litigator wise, what's your thoughts on the Zoom mediation versus the live mediation?
I think, regardless of which hat I have on, I personally think that it is much more effective to do it in person. At the outset, people can turn off their cameras, they can do other things. You don't really have to look somebody eye to eye. And I think that, as I just said a minute ago, I think there's value in that, and knowing who it is that you are negotiating with. And I think it's hard. I don't like the process as much as having the face-to-face. I certainly have done many virtual mediations, more as a mediator than as a litigant. And they've been successful. So they work. Just as a personal preference thing, I think people are more intentional and more focused on the task at hand if it's live. And as a mediator, this is one thing that I thought of last night that I think is more difficult when you have a virtual mediation, that there's sort of these things and I think somebody mentioned it on the last panel, that there are things that happen in the hallway when you pass people. And there's that camaraderie that happens when you're out of the caucus and you're just chatting with people, and it becomes real. And also I've found that there are times when I think it's important to have a conversation, perhaps just with counsel, apart from the client, because there's some things going on there that maybe are a little emotional, or there's a touchy issue that you kind of want to get a sense of, and you don't want to have that conversation in front of the client. It's very difficult to take an attorney out of the room virtually without all kinds of flags. And so I've found that, ultimately, I don't feel like I'm not comfortable doing that as the mediator. Whereas, we can be getting lunch and say, hey, if you have a minute, there's something I want to run by you. And you can do that without making the client feel like they're being excluded. And it's harder to do that virtually.
Yeah. Yeah, we had a case earlier this week, and I don't know if it's going to touch on your question, that's on your list later, but this, I think it had to be done virtually because this gentleman was in a state prison, but he's got a claim, and so anyway, it worked out great in his circumstances where he had no real option to attend, and of course he had good counsel, there too. But it's just sometimes it's the only thing that will work,
It is a great option. I mean, I think we all agree that one of the positive things that came out of the pandemic is this process that we can have meetings that we wouldn't otherwise be able to have. Logistically, it would just be too difficult. I think the hybrid mediation works real well too, because where you'll have a situation where, like I had one recently where I have a very, very injured, disabled client who couldn't leave the home. He's in a hospital bed at home. So he was on camera, but his wife was in the office with me. And then the mediator was actually on camera, and then all counsel were present in my office. So everybody was able to, I think the mediator actually had COVID and couldn't come, but we still were able to have he wasn't really sick. He just was quarantined. And so we still were able to have the mediation where otherwise we wouldn't have been able to. So there's definitely benefits to the process. So I want to ask you about the creativity angle. One of the things that, getting back to the differences between trial and mediation, is that when you go to trial, there's, assuming it's a civil case where damages are sought, the only real remedy is for the judge or jury to award or not award damages. One of the real benefits to mediation is that there can be creative solutions beyond just a monetary exchange. And I've found that really valuable, both in my experience as a mediator as well as a litigator. And I just wondered if you had as well, and if you had some examples of how parties were able to come up with creative solutions where a client's needs are met in a way other than just obtaining or paying damages.
Yeah, in fact, that case I was mentioning to you, the one with the gentleman in prison, it was a very complicated trust that he was a beneficiary of, but only voting rights for his children, which were minors at the time, and there still are minors. So he had a say so in this trust dynamic that was created, and the trust was basically going to pay salaries during the lifetime of the trust, and then once these children reached 18, everybody was going to be able to take a share of the actual corpus of the trust. And so he had this voting, potential that was given to him by a judge. It wasn't in the trust itself. It was a divorce judge just put it in there that he would have the right to vote. And if anyhow, that outcome that we had to structure, and it did not end up getting the case settled, but I think it probably is going to settle this week. But he would have to give up this potential right that he had that was sort of a judicially created thing that no court could make him give up. You know what I mean? No outcome, a verdict couldn't make him do that. And he basically was trying to remove the trustee, which was his remedy that he thought would get a new trustee in there, and then I'll get along better with the trustee. But so he had to agree to just give that up, and that's something I don't think a court could order him to do. And there was another case that your question made me think of too. These folks, two brothers, owned a brewery together, and they started it. One brother was sort of the finance guy, and the other brother was the brew guy. And they started, it was going great. And then COVID hit and things got south, and the money guy was sort of like, well, what am I going to do? I've got all this money tied up in this thing that can't generate money. And so they had a big, huge dispute. And before they could even talk about how to resolve it financially, the one brother said, I've got to get a real serious apology from the other brother, because otherwise I don't even want to talk to him. I never want to talk to him again as long as I live, And, it was one of those kind of things where just to get the conversation started, you had to get a long, written apology, and just to get in the same room, just to make that part happen. So those, I guess, two examples I can think of where you can get an outcome that a judge couldn't order you to give,
I've done a lot of medical cases in my career, and often, and you'll hear this from clients in a variety of situations where they've been injured, that where the clients will say, I don't want this to happen to someone else, right? And that's why I'm doing this. And in large part, it is true. I mean, obviously there is a financial component to it, and we've been able to fashion a number of remedies, if you will, where policy changes occur, or in-service occurs to train staff so that the error that occurred doesn't happen again. About 20 years ago or so, I had a series of cases where they involved metabolic disorders in newborns that were undiagnosed. And as part of a settlement, we were actually able to get a hospital to increase add a particular metabolic disorder to a testing regimen as part of the settlement, so that this injury wouldn't happen to another child. So I've seen that happen a lot, very successfully. And then there's this sense of gratification for the plaintiff that they've done this for sort of the community at large. And the defendant medical providers have that same sense that now we've done something good, and this process has resulted in a good remedy.
I can see that. I was curious too, and this is, I guess, relatively new, and I just had some experience with this process about a month ago. Have you heard about this? It's like I say, relatively new, but it's called judicially hosted settlement conferences.
Is that different from a judge just handling a settlement? I'm not sure I know what that is.
Yeah, no, it is slightly different. And I think it's been around for maybe 3 or 4 years, but I think the state courts anyway, I don't know about superior courts, but the state courts have gotten extra funding to help some of these things happen. Based on the COVID backlog and things, but essentially what it is, and mine was in Gwinnett, so it was Judge Inazoni. And so basically the sitting judge, whoever the case is assigned to, will designate a senior judge to host in the courtroom or in the conference rooms at the courthouse these judicially hosted settlement conferences, where they pay for the mediator, for whatever period of time the mediator is there, whatever the senior judge rate is. And that idea that you had a minute ago about you want your day in court, you want somebody official to hear your side of the dispute, whatever it is. And that's so important for people. It gives them that opportunity. And at the same time, you've got an experienced person that, takes people into different rooms and says, we've got this dispute. We've all, heard the side of it. How are we going to get it resolved? And it was very successful in the case that, that I participated in last month. And that was the first time I had seen that happen. But I think in the metro areas anyway, I think if you request something like that from your designated judge, they can try to make that happen for you.
I have heard of that. I haven't heard that it's happened a lot, but I think it's a great idea. I think as long as it's non-binding, I think it can be very effective for the clients, the parties, to see what another viewpoint would be in terms of an evaluation. So I assume that's a truly evaluative process where that judge would then say, this is how I would see this outcome, or how I would rule in this instance, if it's that to that level. I think that would be invaluable.
Yeah, well, it really was. And in our situation, it was basically we went back and forth all day with numbers. And then at the end, we said, well, Judge, you've heard both sides, you give us a number. And so he did, and that didn't settle it, but it got very, very close and ended up settling, within a week.
So a couple questions come out of that discussion. The first is whether, in your experience, when you were a judge, or as a litigant, or as now a mediator as well, what has your experience been with court-ordered mediations? When would you order parties to a mediation? Under what circumstances? And how effective is a court-ordered mediation in your experience?
Well, I guess it's going to be mixed, but if you look at the stats, and I think every administrative office of the courts keeps these statistics, and I don't know about every, but I think most circuits are required to have some sort of program in place. But statistically, civil cases anyway, which are the only ones that are going to go to mediation, I guess I'd divide them up by civil versus domestic. Domestic sometimes are going to settle, but not all the time. But the normal civil case, the statistics are in the 90% range in terms of those court-ordered mediations. They work. It doesn't always settle the case that day, but at the same time, just that process getting started, talking about a resolution, they do end up resolving that case eventually. So I think statistically they work, but at the same time, as a mediator, I've had people come in and say, hey, we're ordered to be here. We don't think it's going to settle. We're too far apart, blah, blah, blah. And so I've seen it go the other side too, as from a mediator's side, that if you're not in the game to get it settled, it's probably not going to settle, and I guess it's the mindset of the adjuster or whoever, that I've got this amount of money, that's all I can do, so take it or leave it kind of thing. Those don't always work. But if you're facing a trial calendar and you're court ordered to mediation and you're going to trial Monday, sometimes I can get some more money, to make that case go away. So I've seen it work both ways. And we did, when I was a state court judge, we ordered it almost in every civil, car wreck case we had. And of course, we still had car wreck trials, because not all of them settled, but 90% of them did. So it works really well there. On the domestic side, it probably worked half the time. And some domestics are so emotionally entwined that you're not always going to be able to, to get the mediator to be able to untangle all that to get an outcome.
I think you can use mediation to get it to narrow issues, to figure out really where the problems are. So you might not actually get a case settled. And we see this all the time, where we talked about multiple mediations earlier. I think as mediators, our job, if we're talking about a tort case where we're going to be talking about what the value of the case is and what's going to be paid, is our job is really to figure out what is it going to take to settle the case? How much does the plaintiff really need to get that case? And what is the defendant willing to pay, right? And you want to know by the end of the day, what is the real gap? And so that has benefit, right? As you go forward, is this something we can continue to work towards, or are the parties just so far, they don't even see the case the same way, just a complete different viewpoint on the case? And another thing that happens, again, getting back to the medical cases, is in most instances, at least in Georgia, medical providers or at least physicians have to consent to settlement. And so if the provider says, I don't consent, then, the carrier and the attorney, they can want to settle all they want, but they can't, right? I've had judges order us to go to mediation to get that consent, and I think just maybe they think that getting, the physician in the room and to hear the issues and to see the other side, that maybe that'll wear them down a little bit. Did you ever have instances to do that when you were on the bench?
Yeah. And same thing with the mediations. I've had policy limits, everybody's in agreement except the doctor, and it just can't happen, and I think eventually they not at the day I was there, but eventually they resolve it. But it's so hard. I think I did nothing wrong. I did everything exactly like I was supposed to. And so therefore I don't want this ding on my, my insurance record,
Yep.
We had another thing, and we're talking about creative solutions. This happened last week too. We had this really, really complex business ownership dispute, and it was a $1 million, a couple $1 million business, and it was a question of who owned the shares, who had the all this kind of stuff, and it was going to be so complex because they had to have two interpreters to do the they were getting ready for court. And I was like, guys, this is not going to be a great jury case. You would be better off getting your judge to hear it and getting your judge to, because, it is a very complex ownership kind of question. And I said, your judge is going to be a lot better decider than 12 folks that may or may not have went to high school, you know? So anyway, that was an outcome that I think is going to be beneficial. I haven't, you know, I don't know how the judge is going to rule, but I just feel like that's going to be a much better use of the time of the lawyers presenting it to a court versus presenting it to a jury.
Another thing came up when you were discussing, something occurred to me when you were discussing this judicial evaluation process that, you know, when we try cases, and it would be the same in that instance, that's a separate judge that's going to do that. It's not the judge that's going to try the case, right? Because the judge that tries the case is supposed to be agnostic in the whole process and not give opinions and enter, you know, state how the case is supposed to end up at the end. And in large part, that's what we're supposed to do as mediators as well. We're just getting the information and processing it and reconstituting it to sort of help with the information to be heard and to let the parties get where they want to go. But there are instances where, you know, a mediator is either on his or her own or maybe asked by the parties, you know, to sort of say how this should end up. And one way to do that is to either float a number or more officially to give a mediator's proposal. Can you talk a little bit about how that works and in what circumstances you elect to make a mediator's proposal?
Well, usually it's going to be sort of an end of the day conversation where you're so far apart still, you know, you've been at it a couple hours and you're still very, very far apart. You know, you can ask the lawyers if that would be something that they would be open to hearing. And, you know, I always try to do it after the mediation's over and I sort of write up something and send it to the lawyers. And then the lawyers can accept it or not accept it, you know, depending on their point of view. But we had a thing come up yesterday, and I guess it came up a couple of months ago too, that was a very unique way to float a number that, you know, that I guess you have to have obviously the parties be agreeable to this, but this came up about a year. I think it was about a year ago in a case, and it also came up this week. But basically, you've got a number, a damage number that you think you can prove as the plaintiff. There you go. Give me that number. Put it on a piece of paper. The defense thinks the damage number is going to be this. So if you really believe that number, it's going to be a lot lower than the plaintiff's number. Put it on paper and give it to me. I'll come up with my own number. Whichever number I'm closest to, we take the average of those two, and that's going to be the outcome. Or, you know, it could just take my number, whatever it is. You know, whoever the number is closest to kind of prevails. And so, anyway, that really, really works. It's creative because they have a little bit of say so. There's a little bit of a risk there too, but
sort of a high-low in mediation.
Exactly, yeah. And so it worked. It didn't work last week, but it worked. You know, with the old case a while back. And you know, it's all those things are end of the day conversations where, you know, you can't really make progress in real numbers, so you kind of make up a way to come up with a number that will, you know, everybody just sort of like, okay, I trust that person's number, so I'll take it, you know, whatever it is.
Well, we're about 15 minutes to go. Want to get Scott back in?
Yeah, no, I was just about to jump in, guys, because this is a perfect segue to getting some answers to some questions that you've raised as you've talked, which has really been interesting to follow. And Judge, I can't help but understand the unique role of a judge as a mediator, past judge as a mediator, if we have as many mediators, because of the gravitas that comes with the expectation that the judge understands a case and how they would rule. So I want to bring up something that Lyle mentioned to you as a question. The difference between an evaluative mediator and what we might call as a messenger mediator that goes back and forth. I'd love to hear from the two of you the perspective of what you believe is a greater quality as a mediator, being evaluative or messenger type, and what's worked.
Well, you want to tackle it or you want me to jump in?
I'll go ahead, and then you've got more experience in that from the judicial angle, but I would say, there's been a lot of discussion today already about the selection of the mediator. And so there are some mediators that tend to be more evaluative and some that are really, just go back and forth with numbers. And it really depends on what you need. And so there are times where as a plaintiff's lawyer, I will go to mediation because I need my client to get real, right? And so I want them to hear the tough stuff that's coming from the other side, and I want the mediator to help me explain the risks to my client. And so, I will tell, and as a mediator, I really appreciate being prepared, right? I don't like going into a mediation and just learning about it for the first time. I like for folks to share the good facts and the bad facts with me. And I do that as a litigator too, because I think that's the only way the mediator can really be effective. And so I think one of the most difficult things in mediating cases when the clients don't share with me as the mediator the negative things, or worse, they haven't shared those with their client. So they're hearing for the first time there's this really bad fact in the case. That's not a good time for them to hear it for the first time. But with all of that, I think there's real benefit to a mediator, not in an ugly way or a you must do this way, but in a have you thought about how this might be perceived by 12 people who don't know you from Adam? And here's some ways they might perceive it, and that can be really helpful.
Yeah, I agree with you 100% on what the parties need to, kind of get real about an outcome. I try to do it, I guess it's my personality. I try to be the messenger guy, and see how that goes. And then sort of toward, halfway or, toward the end of the day, I'll just ask permission to share, is it okay if I share with you kind of what I think? And the lawyers and the parties, always say, sure, because, that's, part of why we got you here. And so once, if I have permission to share, I always try to be respectful. I'm not trying to hurt your, point of view on the case, but you take this into a jury 10 different times, you're going to win 4 or 5, but you're not going to win, 6 or 7. You know what I mean? You got a lot of risk, and I don't want you to be in that situation. I want you to have an outcome that you can live with. And here we are, they're offering you a good outcome today. It may not be as good as you want, but it's a pretty good outcome, and we can work toward getting a little more. But that's the way I see it. And hopefully, that I don't know. It seems to be working in terms of, end of the day sort of dialogue about getting somebody real with, maybe my case is not as strong as I think it is.
I think that's a very positive viewpoint of what our clients want from us to help them resolve their cases. In the same context, do maybe both of you talk about your use of bracketing? Do you find that a useful strategy in your mediations to help people, if you're going to be evaluative, to work them towards a bracket to reach a resolution? Can you talk about that?
Yeah, Lana, you want to jump? Or
I love brackets. I just think it's a timing thing. Sometimes it's beneficial to get to brackets pretty early, because you can really see, even if it's just to get a really good sense of how far everybody's apart. I mediated a large case last week, and it looked like worlds apart, but when the brackets were used, the messaging was so clear in terms of where both parties needed to be. And that was that actually ended in a mediator's number, because the signaling was really strong with the use of the brackets, and the parties just needed somebody other than themselves to say, this is where we're going to end up.
Yeah, I agree 100%. The messaging part of the brackets is like, even if they're never going to be accepted, the message is, this is where I think it ought to settle. And the other side said, well, this is where I think it ought to settle. So at least, sort of that small gap, and then you are really working toward those gaps. And I love them. I think they're great. And again, the timing is important. But I've found anyway, some adjusters hate them and they refuse to, propose a bracket. They'll listen to a bracket, but they're not ever going to propose a bracket. And I don't know. It's just a personality thing, I guess, that they just don't believe in them.
I think that's good though, if they don't to come out and say it, because one of the things you really have to work with when you're talking about brackets, and really it's not just the brackets, it's the numbers all day long, that certain people hear things a certain way. And, you'll have people say, well, this is the bracket that I'm proposing, but I'm not looking at the middle. I'm not working towards the middle.
Right.
And I'll always tell people, I was like, I get it. I want to do that too when I'm the litigator, but I'm just telling you, as the mediator, you're sending a message with a bracket that certain people can only hear one thing out of that. And so if that isn't what you want to do, maybe we try a different approach, because like it or not, that's the message you're sending. And so you have to be really transparent about what you mean when you send a bracket. And as a mediator, I think you have to go and, be able to explain that. And if you don't think the other side's going to hear it the way it's being conveyed, then don't use it.
Yeah, 100%. I agree. Yeah.
Okay, one other strategy question for you two experienced mediators then is the use of opening statements as part of your mediations. How do you decide whether the parties are each going to make presentations to each other to have the parties in the room as the initial session of your mediation, as compared to just going into your separate sessions? How do you approach it?
I think we talked about that a little bit earlier, and I think you have to just depend on what the parties want to do. I think the important thing though is that they be on the same page. It's not helpful at all if one side wants to do a very fancy opening and the other side doesn't want to at all. And I think they, as part of the process of facilitating this hopeful resolution, is if one side is saying that is not going to be helpful. In fact, it is going to be disruptive to the process. My folks are not going to like it. Then I think it's our job to say, I think it would be better if we just have a, meet and greet and then get on with the day. But with that in mind, you have to be sure that you as the mediator and both sides have been educated enough that you can't just go start talking about numbers if there's something that is really missing in terms of the knowledge of the case on either side.
Yeah. I agree 100%. The lawyers decide, but if it's not going to be helpful, we got to get that out there too. And most of the time, the folks that prepare a 10 or 15-minute PowerPoint or something, they're going to be ready to go, and they practiced it, and they want to be able to do that. And so if it's going to be something that's going to be hurtful or not helpful, you just got to prepare the other side in terms of not reacting, and hopefully it'll just be over, and we can start really talking about getting things settled.
And you may ask to not do it in that setting where it's us against them kind of thing, but to say, is there something in that you can give to me that I can take over there and share why you included that? Or if there's a video of something that you think will be helpful, can I share that at the appropriate time later in the day, and can do it that way.
Yep.
All right, and then the one last question, let's go to the end of the mediation. How do you both feel about chasing the parties after what might be an impasse to staying involved and helping the parties ultimately reach a resolution post the mediation day? How do you approach the stress of wanting to help settle a case even after the mediation day is over? Do you follow up? Are you still engaged, or do you stop?
Yeah. What do you got there, Lyle?
Most of the time there's a willingness to, sometimes it's just exhaustion, right? They're done, they're spent, or the adjuster had to leave. They have a flight, and, so we have to convene for the day. Most of the time people are open to, sure, if there's anything else that, they want to say later, we're happy to hear it, either way. certainly there are occasions where it's really obvious. We said some cases just have to get tried. There's some that, this is not going to settle. It's apples and oranges. They're looking at two entirely different cases. And, you just kind of have to accept that outcome. But most of the time people want you to keep working.
Yeah, I agree too. I usually get follow-up emails, within a day or two. Hey, we got really close. Will you convey this new round of offer to these folks and see if that's going to be something that can work? And, we just go back and forth with text or emails to try to keep the engagement going. And sometimes, at the end of the day, you're close enough where it should settle. You know what I mean? You shouldn't go to trial over $30,000, but sometimes, they make the wrong decision there. But it's at the end of the day, it's so close, and you keep working and hopefully, making sure both sides know that you're available if needed. And sometimes they can do it on their own too. But if needed, I always try to make sure that the door's open and the emails are, conveyed and all that, not every case settles that day, but 90% of the cases do settle.
And you may need to come back actually physically together. Maybe somebody needs to get additional authority, or there was an issue with like a ruling that needed to come out before people could really get on par. And then you just come back together and then solve those issues at a later time.
I know a lot of folks are just love to hear from other people's experience, like from the two of you. And it's really been helpful for you guys I like this question and answer approach you guys came up with to guide us through the mediation process. Really interesting. Thank you both for taking the time to participate today. And I guess we'll wrap up our session and move on to the next one. Thank you both very much.
Thank you.
Thank y'all.
All right. As we continue on our big day of dispute resolution, I'm excited to present the beginnings of the next program. This is a topic that we get asked about a lot with regard to language barriers and mediation. And I know Michael and Doug have done this program for the Georgia Office of Dispute Resolution. And actually, I heard it and really loved it. And I know that the feedback was tremendous. So we're really excited to get Michael and Doug to join us today to walk us through this topic of addressing language barriers and mediation. Michael, Doug, welcome, and I will turn it over to you.
Bueno, gracias, Doug. Le agradezco la oportunidad de presentar en español esta presentación por primera vez con el State Bar de Georgia. And I think there were 150 of you on this a minute ago. And if I haven't lost any of you, hopefully you're still there. We will not actually do this entirely in Spanish, though I think Doug understood that. I'm Michael Eshman. I am, my last name wouldn't suggest it, but I am Latino. I'm half Colombian, half Wisconsinian, which is, I think, how I come by my fascination and my interest in the issue of language access in litigation and in mediation generally. And so I have been, I think 4 or 5 years ago, I invited Doug to coffee to talk specifically really about Spanish speakers, I think, as we both speak Spanish in mediation and what we do, how we approach that language barrier in mediation. And we had a coffee chat. And Doug and I have done a couple of presentations since, and I think have been having a lot of really interesting conversations for us since then. No real solutions, I don't think, but some ideas of what works and what doesn't work, and some horror stories and hopefully some stories of things that worked that we want to share today. So that's my introduction of me and the program. We're going to go more, I guess, coffee chat, podcast style in our presentation today.
Right. And first of all, thank you, Scott. And it's just great to be part of this program, to see so many ADR leaders and people that I really admire in this field, and to be sharing the mic with them. And one of them is Michael Eshman here. I guess, our bios are in the materials, but I guess for me, I've been mediating bilingually for about 20 years now, in English and in Spanish. And a good part of my ADR practice involves at least one Spanish speaking party. And over the years, I was thinking about it, I've mediated with parties in at least 15 or 20 different languages, maybe more over the years. And this is a topic that we are very passionate about. And Michael and I have talked about this a good deal. And, you know, our topic is addressing language barriers at mediation. And this is about how you as neutrals and advocates can identify and address language barriers to keep your mediations running smoothly. And, you know, we generally like discussing this. And like he said, we know there's no easy answer. We don't have all the solutions, but we've gotten to where I think we have seen a good bit of what works well in these situations and some of, unfortunately, what doesn't work as well, and how to be prepared by, number one, being aware of the issue, knowing as you approach a mediation, how to identify what your language challenges might be. Sometimes they're obvious, sometimes they're not so obvious. And then from there, also being aware of potential solutions. When we have a language issue, what are some ways we can try to address it? And there are often a range of options. What are some of those? And with that, you know, kind of the third piece, the way we look at this is being aware of the potential pitfalls, as Michael alluded to, where things can go wrong. Even when you have the best laid plans, sometimes these things can happen. And you just have to find a way to make sure that you're enhancing communication, because that's really the heart of the issue at mediation. And when dealing with language barriers, it's without communication, there's no mediation. That's how essential this topic is. And that's what's at stake. And the more clearly messages are delivered and understood, the more effectively mediation serves as a dispute resolution process.
Yeah, I mean, I think we talked yesterday a lot about, and in general, a lot about this communication being at the heart of negotiation. And if, you know, I did a CLE at Miles, I guess earlier this year, and I looked up the definition of mediator that we provide in the Georgia Code, which I hadn't looked at probably since I went through my mediator training, you know, 5 or 6 years ago. And the definition itself I thought was interesting just because it defines it. It says that mediation is a process in which a mediator facilitates communication and negotiation, right? And interestingly, it names both, but that communication comes first also. You can't have good negotiation without good communication. I'm going to steal something. I think it was Nisbet Kendrick said earlier, and I loved it in their presentation a little bit ago, but he talked about giving people the dignity to control their decision-making, right? And when you encounter a language barrier, right? So a party who, for whatever reason, doesn't understand either the process or what is being said within the process, you're not giving them the dignity of controlling their decision-making, right? They can't make a good decision or their own decision voluntarily if they don't understand what's being discussed or how it's being done. And so I think what we do as mediators, facilitating that communication, giving people the dignity of being able to understand not just the what is being said, but how we're doing it, right? Because at least for me, I deal a lot with plaintiffs who have never been in a mediation before, you know, not really ever been to court before. And how do I reach them and help them understand what we're going to do and what mediation is and how it's different than court, so that they can really exercise that self-determination, which is the core of what mediation is. So I think this, you know, language, I think Doug and I in the past have focused specifically on, you know, where you have a participant who speaks a different language. I think in my mind, this issue of language barriers at mediation is much broader than that, right? Because you can have everyone in the room speaking the same language and we talk past each other, through each other, over each other, and it's just not working. And so what are the tools available to us within those different barriers, the different types of language barriers we might encounter, to help to make sure that everyone is engaged and giving them that dignity to make their own decision. And so as I think about language barriers more broadly like that, I kind of broken it down, and I think we're going to talk about it a little bit today in that way into when you're the first section, we said, be aware of the language barrier, what exists, right? And I think generally in broad strokes, there are 5 kind of general categories that I've identified of language barriers that we might encounter, within the mediation or everyday life, but within mediation. And so first I have the linguistic barriers, right? And that's probably, that's what Doug and I talk about the most. That's where probably what most of y'all think about when you think about language barriers at mediation, where parties speak different languages, right? So here where you have a participant, a party who has limited English proficiency, and you've got to try to address that linguistic barrier to engage them in the process. The second one is a dialect barrier, which is different, right? There are oftentimes, we understand it in English that, there are different countries with different dialects, different regions of our country with different dialects. And the same is true of every other language, or at least certainly Spanish. I know there are a lot of different dialects, and helping to make sure that we address or are aware and sensitive to potential dialect barriers within mediation. I call that when people speak the same language differently. The third one is a cultural barrier, and this one's pretty broad, admittedly. I think about not just cross country barriers, but thinking really about the different ways that we all use language, how we speak and how we receive language. There are some people who, if you get directly to the matter at heart, they are offended that you didn't spend a long time on all the pleasantries. There are other people that if you spend too long on the pleasantries of trying to build rapport, or get offended that you didn't get straight to the matter at heart, right? And those are cultural differences in how we use communication. Certainly across countries, we can think of some also. For instance, I'm half Colombian. Colombia tends to be an indirect, tends to use language indirectly. In other words, that would be generally, and you don't want to overgeneralize, but generally in Colombia, people want a lot of the background stuff before you get to the heart of the matter, right? You don't get directly to it. You talk about, how people are, you get to know them. You really, before you can get into, the business of the day. Whereas the other half of me is German, which I imagine that the kind of the stereotype anyway there is that they very much want to get straight to it, and they want to get to the details. And it's funny, that's not always necessarily so. It's not with me. I'm kind of a mixture of those things, but anyway, but that's what I think of when I think about cultural barriers. The fourth one are technical barriers, right, in mediation. And there I'm thinking about the use of jargon, if you're, the words that folks don't understand. And the last one is body language barriers. How does what we see and what we do with our own body affect how we're able to communicate and engage the parties within the mediation? So those are the 5, I guess, general, very broad categories of barriers that I've identified that we should at least be aware of in preparing for our mediations and during our mediations.
And I think, something really interesting about your list is it's not, we can have some of these miscommunications even when we're speaking technically the same language. I mean, that's what's really fascinating is, in mediation, the whole deal is trying to get people to communicate more clearly and enhance communication. And that's even when you're speaking the same language. So then you throw the linguistic and the dialect issues on top of it, and things can get complicated in a hurry, right? And just to maybe make a comment on one of those non-linguistic or dialect categories, I think body language is one that I'm finding really, again, fascinating and very interesting, particularly in this day of video and virtual mediation, because, I think we like to believe that if you're in the same room with someone, you can pick up on these nonverbal cues and things like, if somebody is tapping their pencil on the table, or their legs, their foot is tapping as you're mediating, you think, oh, this person may be feeling a certain way. Or if somebody is looking in one direction, you think, oh, they're nervous and maybe they're not being completely truthful about something. But when you're removed from the physical space of someone, you're trying to communicate over video or even over phone, or now people are, you're seeing part of these mediations being conducted maybe even by text or email after the fact. So there's all these, if you're removing yourself from the full context of being in the actual physical room with someone, what are we losing potentially by not having all of the full picture? If you're looking at someone just through a video camera and you're seeing from their shoulders up, you're seeing just part of them, and then maybe depends on how clear your video is, or the fidelity of your means of connecting. What are you losing there? What's going on that you're not maybe necessarily picking up on as you would were you in the same room? And then even if you were to pick up on it, are you reading it correctly? So there's a whole level. It's like it can get really tricky to try to delve into some of those, what you would say fairly, they are communication barriers potentially. You have to at least be aware of them as you're entering into these mediation situations.
Yeah, I think the you glomming onto the body language barriers is interesting to me, and especially in this day and age where Zoom and virtual is such a great tool, right? I mean, I think a lot of us allowed us, right, to keep mediating during the pandemic. But beyond that, it is allowed us this other option going forward. But I do think there's some things that are lost within it. They may not be necessary for every mediation, right? But for some mediations, I do think I think that being in person and allowing for that focus, right? Because at least in my experience, we may not speak the same language. There may be some other barrier, but if I am making eye contact with you, if I am leaned forward, if I look like I'm engaged and I care, it makes a huge difference. And when I'm as an attorney, when I'm picking a mediator, if I'm not picking a mediator if I have a Spanish speaking client, if I can't get one, or I'm not picking one who speaks Spanish or doing that, I'm looking for those mediators who connect in that way with body language with my clients, right? Notwithstanding that they can't speak the same language. And I, kind of when I think about being aware of your body language and the Zoom age, the anecdote, at least in my mind, that comes to mind is a mediation I had. I think it was fairly early on during the Zoom days. But we actually had a participant who was deaf and hard of hearing. I believe he was capital D deaf. And so, right, we were aware of the barrier in advance, right? That's the first part of what we talked about. We knew that we had to address this. We had to be able to engage this person who was deaf within the mediation. And within that context, there are ADA requirements for what you need to do and make available to folks who come into the mediation who are deaf and hard of hearing. And so we had an ASL interpreter, or two ASL interpreters, because they take turns because it's so exhausting. And then we had closed captioning available for him also. And we're having the conversation with him and everything. And at a certain point, we think we're set up perfectly for it. He asked us to turn the closed captioning off. And he said the closed captioning there was so much going on his screen, right? There were just so many. There was his attorney, there were two interpreters there was me, there was him, and then there was this closed captioning box that it made it hard for him to see the ASL interpreters. And that was how he was understanding the process. That's how he was understanding what was being said, was through that ASL interpreter. And so by him saying that, we took it away, right, and allowed him to focus. But that's what he needed, right? And so although we came in with the plan of what we thought would work for that individual, we had to be very flexible and open to really empowering the party, right? The participant themselves to letting us know, hey, you can let us know if this doesn't work for you, right? What works best for you to understand what we're doing here, because that's most important ultimately. Yeah. And so Zoom is an interesting, I mean, we talked about interpreting over Zoom. I mean, it's an interesting hurdle sometimes.
Especially, I'm sure people have had the experience during the pandemic, particularly when you have people that may be over Zoom. And then on top of it, if some people are in the same room, they've got a mask on, some people, and then you're left, that can affect what you're able to hear, the sound quality, the actual hearing the words. And then also you can't see their lips moving. If you're having an interpretation issue on top of it, then everything, again, it's just another layer of complexity that we just have to be aware of. And I think a lot of the awareness piece too just comes down to planning in advance. And in an ideal world, you are in contact. We've talked about this throughout the day, before a mediation, if you're the neutral, you've ideally gotten some communication from the parties, from the lawyers that can give you a heads up and say, hey, we've got this issue, this language issue, or this barrier that we're trying to work around, and give you a heads up, whether it's by a phone call or mediation statement, or seeing some records that you're reviewing where you can pick up on a language issue, but just planning in advance so you can start to be thinking about what are our potential range of solutions to make sure everybody's comfortable with the process and everybody's understanding and able to participate fully in what we hope will be a productive mediation.
Yeah. Yeah, I think that, as I think about solutions for addressing language barriers, and obviously there's some very discreet ones, right? You can get an interpreter, you can do those things, but more broadly, I think about the planning process that if you're able to, in advance of the mediation, I will reach out to the parties, invite them to tell me about the case. But I also want to talk about any logistical barriers. I want to address those before the day of mediation, right? And so some of those, right, to some degree, a logistical barrier can be, prior negotiations have gone haywire. They don't even agree where they are. And I love to address that before we get to if I can, mediation. So I don't spend my, my first hour or 2 hours just getting the parties to where they thought they were before, right? So there's that's a logistical barrier. But logistical barriers are also, right, the language component, like we're talking about. And so inviting the attorneys to have a telephone call with me, and let's talk about, okay, you have a participant who has limited English proficiency, right? What's your plan, right, to the attorney? Because I think there is, I want to be respectful of what their plan is. And I hear all different things sometimes, right? Some will say, we have an interpreter coming with us. Some will say, we've got someone in our office speaks the language. Some will say we've got a family member or a child, which presents its own issues. And some will say, well, you speak Spanish, so, we're covered. And so I have that conversation at the outset, because while I am bilingual, while I do speak both languages, when I'm in that role, I'm the mediator. And I want them to understand that I'm not the interpreter in that context. I don't serve in that role. But I let them know how I think being a bilingual mediator will help or will be helpful to them. And then we can plan, okay, will that work or won't that work, depending on what their plan is, but they've at least informed me so I can offer insight into how we address that language barrier in advance, right? Because the more I feel like the better prepared and planned we are for it, generally, the better it'll go the day of.
That's right. And, personally, I really do enjoy working with interpreters, even if it's a Spanish language case. I have a tremendous respect for how difficult that job is and how hard it is to do well. And I think it's inaccurate to assume that because someone's bilingual, that does not automatically qualify them to be interpreting at a professional level. And so I think that's really, it's an important thing to remember, as a bilingual mediator or a bilingual attorney, that there's another level of skill and value add that a really good interpreter can bring to the process. And I think you do have to have that trust, whatever that attorney or that party has as a plan, I think you need to make sure that everyone's comfortable with it and you're aware of it, you're comfortable with it as a mediator, but that they need to feel like whatever they're doing to address their language issue, that it's going to be something that is going to enhance the process instead of being an additional challenge. Because, you know, in particular, when you think about mediation, you've got, okay, if you've got an opening session, you've got private caucuses, the dynamics in just those pieces of the mediation are very different. And I think in the way an interpreter can add to a joint session is very different than what goes on in a private caucus. And when you're in a private caucus, you know, as a mediator, I'm thinking, I want everyone to be as comfortable as possible. I want them to feel like they can express themselves. I want them to feel like they can talk openly. And the interpreter, they bring a technical quality that's very important, but they also bring, you know, it's a delicate balance. So they have a personality they might bring. If I'm a party, I might be thinking about, what does the interpreter bring in terms of demeanor? Are they going to make my client feel more relaxed? Or are they going to make them feel more anxious? What's their style? You know, there's all different ways of interpreting. And I think it's a mistake to just think, oh, you've heard an interpreter, they're all the same, or they all do things the same way, because it's not that at all. And I think that's an important, sometimes you really have to drill down on that to make sure everyone's on the same page coming into the process.
Yeah. So, and I will, you know, we could, I think, spend this entire program on working with interpreters, this entire hour, probably more than that. And I will, in any presentation I get the chance to do on language issues, will scream from the rooftops that interpreting is hard. It is so difficult to do, difficult enough that the highest level of certification in the state, I think, changed a little bit of this earlier this year, but generally speaking, the level of certification for a court interpreter in the state of Georgia, and I think most states, is 70% passing on a written and an oral exam. And then on the oral interpreting, I think you have to do it both consecutively, and then so there's the one that follows that's while you're speaking, and then the one
simultaneous
and
consecutive.
So, but it's a 70%. And so I just, for anyone who thinks, okay, I've got an interpreter, my language barrier, whatever that is solved. I've got someone who can speak that participant's language, you know, that may be so, right? And I hope that is so. But I want to caution that at the highest level, it's still possible that that participant is missing 30% of what is being said, or that you're missing 30% of what they are saying, right? It's possible. Hopefully you're getting closer than that. And I've used this before, Doug. I think I used it last year. You know, I gave the example of, you know, if you were, you know, in a foreign city and getting directions and getting it interpreted, and the direction said, you know, in 5 miles, turn right, and your interpretation said in 5 miles, turn left, right? That's an 80%, right? It got rid of the 5 words. That's 80%, but yet you've gone in the exact wrong direction, right? And so I say that, I guess, not to terrify people about, you know, working with interpreters. Interpreters are great, and generally, you know, I think are great, but you need to be aware of that, because number one, I think it's really important to know when you're working with an interpreter, if you can, what their certification and qualifications are, right? Some will say I'm certified and may or may not know exactly what that means. And there's medical certification, there's court certification, or at least state court certification. There's a federal certification. They're different things, and they mean different things. And so asking the interpreter what that means to them, I've heard from judges who have had interpreters say that they're certified, and they weren't certified. The interpreter themselves didn't really understand what that meant. Okay. So I think one, you know, really understanding the qualifications of the person that you're working with as an interpreter. And then, you know, I always talk about empowering the parties to let me know if they're if it's working for them. But I also think it's really important to empower the interpreter at the outset to acknowledge how hard their job is, and to let them know that if they don't understand something that's being said or some part of the process, to please, in mediation, ask that question, right? Because for us, in court, they're really looking for 100% accuracy of what is being said, right? Within mediation, I am looking for the highest level of understanding possible, right? And that isn't always 100% accuracy in what's being said. I want that participant to understand what we are doing and what we are saying. And I need that interpreter's help ultimately to make sure that that's happening.
Yeah, and adding on that, I think as a practical matter, there are things as a mediator and as an attorney and as a party you can do to make your interpreter's job easier as well. Things like not talking too fast, not talking in huge blocks where you just go on and on and on, and then you realize the interpreter's trying to catch up. I mean, if you can just be aware of that dynamic, speak a little bit more slowly, more deliberately, don't use as many buzzwords maybe, or as many acronyms as you might otherwise, just to make that job easier and make sure what you're saying is being interpreted clearly and accurately. Provide those pauses, just be aware that the more you can help the interpreter, the more that interpreter can help the process. And that goes back to awareness too, I think, that we talked about initially. It's just being aware of that going on and trying to make it easier.
Yeah. I was going to drop an anecdote here, but I see that we have a question. So I'll pose it to you, Doug. What are the pitfalls of a skilled bilingual mediator acting as the interpreter if one isn't available other than the focus on his or her job as the mediator?
Well, we have a whole pitfall section we could get into, and that's a real tricky one. That is a real tricky one. I think the first thing as a practical concern that I have is what happens when I leave the room. There have been situations where I'm expecting that party to come in with either an assistant or a paralegal or an interpreter, and it's all set to go, and then something happens where the person's unavailable, or they're only available partly by Zoom, or all these things can happen, and I'm left as faced with the necessity in the moment to interpret the best I can. And like I said, the first thing when I leave the room, how is the attorney communicating with the party? Because when I'm there, I can make sure that they're communicating, again, with them understanding I'm not a professional interpreter, but I can help you get to the understanding level, as Michael, as you talked about, getting to that highest level of possible understanding. But as a practical matter, you need to be spending that time between when I'm going to speak to the other party in the caucus. That's your time to bond with your client. That's the time for you to be really communicating, understanding what they're really looking for and hoping to get out of the process, and what their concerns are, and all those things that make mediation what it is. You're missing that. Yeah. I can't be in there the whole time. And I think that can be problematic.
So I'll say this. I think there are, if it's a court program, certainly, I think you really can't. I don't think. I think there are ethical and legal reasons that when it's through the courts, that person has a right to the best available interpreter, right? And under the circumstances, that's not the role of the mediator, and it's not appropriate. In the private context, I think it's a little bit different. I think that removes that concern, but there still are ethical and practical concerns if it's a purely private mediation, as far as serving in that role, that dual role as interpreter and mediator. Beyond, obviously for anyone who is bilingual and who has tried to, do that and think about other things at the same time, that, keeping all of your thoughts straight and keeping organized and doing the task at hand becomes that much more challenging, of course. But it also, I think, does it probably a disservice to both sides. I think I've had the instances where parties have asked me to interpret very specific things, or they'll say, "Can you say this to them in whatever context?" I'm always worried. I have done that. I am always worried in a private mediation, but I am always worried that my role to that person is going to become blurred. Because I am in that instance, I am saying the words of the other side as an interpreter directly, right? I'm not saying they said this. I can do that, but that's a little bit different than interpreting, right? I'll have conversations with them about the messaging that the other side wants to communicate, but in a role as a mediator, that's a different thing than actually one-for-one interpreting what is being said by somebody as though it's coming from you. I think that in my mind, I think that blurs the line between mediator and interpreter, kind of for the advocate almost, and becomes problematic towards, really serving in my role as a mediator going forward. But that being said, I mean, I know, and Doug, you've probably done it before too. I have had instances. I had one where they didn't know I spoke Spanish, and the interpreter was late. And I was able to at least interpret for that lawyer who would have otherwise sat there not being able to even communicate to their client what was going on, exactly what was happening, and what, at least explain and interpret for her the things that she wanted to communicate. And that was fine. I felt very comfortable doing that. But yeah, I do think there's a risk with that bilingual mediator acting as the interpreter.
And then you make a really good point too, that if you're looking at the court connected mediations there, you really should. I think this is referenced in our paper. You need to look at the rules of the commission, and then also the Georgia interpreter rules are quite extensive and really a wealth of information just to see how much goes into overseeing and regulating interpreter practice, and then your responsibility as a court-connected mediator to, again, follow those rules and make sure that you've got a qualified interpreter to assist with the process. And, I think as I've had a similar situation, Michael, as you were describing, as a mediator, where I've been not necessarily acting as a bilingual mediator, but kind of being there and hearing some of the conversation. Sometimes I can actually correct things that I hear, or ask them to, could you retranslate or reinterpret that, because I'm not sure you got that all correctly, and then just give them an opportunity to do that. So it's sort of like another set of eyes, or because we do have a different level of expertise in the mediation process, let's say, than some interpreters might, or some of the jargon that you might hear during, and let's say, an opening session. You might hear something that maybe it's not that clear for an interpreter, even someone that's trained in legal matters. Sometimes there are going to be those things that just requires another going over to make sure that that's being accurately interpreted and understood by the other people there.
I had an interpreter once thank me after a mediation for introducing her to the proper terms, some of the proper legal terms that she was not that familiar or comfortable with, after that she'd been taking notes, which, but that's the reality of, while someone may be, very qualified and may pass the test, there may be some nuances to whatever the matter is that you're mediating. They may not know those specific words, right? Or they may not be prepared for that. I know we've done this before. I think last year we did it with Jana Edmondson Cooper, and she tells this story about when she was an interpreter in the courtroom, about coming in with the Spanish-English dictionary, and I think the courtroom deputies kind of laughing, going, "Oh, you're in trouble. Your interpreter needs a dictionary," right? And it's the exact opposite. If your interpreter has a dictionary, they're doing their job. Right. That's the interpreter you want, because not everyone knows every word in English and Spanish that is going to be said in every matter. I remember an interpreter, we had a case that involved a shotgun, escopeta in Spanish, and she didn't know escopeta. She didn't know that word, right? She looked it up, but if she didn't know that word and she didn't even know it was a gun of any kind, I mean, otherwise she would have been left saying the thing, right? And we would have spent the whole time talking about what happened with the thing, and that does nobody any, that was there was a trial in that instance where that was an issue, but she looked it up, right, and she got that solution, and then she knew it. And so I think, within that, being aware, I said the G.I. Joe thing, right? The knowing is half the battle or whatever.
Yeah.
Right? So, but I think that applies here, instead of being, nervous or scared when you're working with interpreters, just understanding those limitations, understanding that it's not going to be a 1-for-1. It almost never is completely a 1-for-1. And it may be, a 70%. And you need to slow down. You need to look and for those cues that someone is struggling, within the mediation. Right. If somebody's speaking for 25, 30 seconds, and then the interpretation is one word, and if it keeps happening, you might start to get a little concerned that the interpreter doesn't know, doesn't understand. The example, and I'll give this anecdote because I was going to a minute ago, I give in probably every one of these presentations, is why I became a mediator. Was a civil case that I was involved in on the plaintiff side 8 or 9 years ago now. But we went to mediation against a hospital, and we had a Spanish speaking family, and I spoke Spanish. So I'm in our room with my client speaking Spanish. And the hospital said they were going to bring an interpreter, which, medical interpreter. And we thought, okay, that'll be great. And we went to this mediation, and the mediator started going through, the opening caucus, talking about, the confidentiality of the process, about the control that the parties would exercise on the outcome, and why, all the reasons that mediation was the best place to get the case resolved, and all of those things that we all do within the opening caucus. And the interpreter, who had never been to a mediation before, right? She was a medical interpreter, I think was very nervous or got lost in maybe the new process and didn't really, something happened, because what she ended up doing is her interpretation was basically, él dice que estamos aquí, vamos a hablar, entonces él dice que, and if you don't speak Spanish, basically all she's saying is, he says, we're here, we're going to talk about, he says, we're here, and she just kind of kept repeating these things that communicated nothing to my clients, who needed to hear what the mediator was going to say, but needed to hear it from someone other than me that day. And unfortunately, it wasn't possible that day. We had a very frustrating, very difficult, about 10-hour mediation that day that didn't get resolved, where I think it would have. I served as ultimately, when we were in our own rooms, I served as the interpreter for the clients, but they were very disconnected from the mediator as a result. They already had a relationship with me. That interpreter really could have served to help connect them with the mediator. And absent that connection, I think they weren't ready then, and it became too difficult to get it done. And it costs a lot of time and money for everyone. A year later, it ended up getting done. But it was, I remember sitting there and thinking to myself, if I hadn't been there and known that nothing was getting through, what would this have looked like, right? What would this mediation have been? What do we do in mediations when we have somebody who, has limited English proficiency? Yeah.
That's just a story that encapsulates the issue so well. And I know that is what drove you in large part to just realize there is a need here for people that can help make this overcoming the barriers, make that just better because it's we talked about it earlier in one of the panels, serving the client's needs. This is something that's out there that is just begging to be improved upon to the extent we can. And I will say, you mentioned that sort of everybody benefits on both sides of the equation when the communication is there and enhanced. And I am reminded of what I would call a success story. We have the pitfalls and we also have the success stories. But I had a mediation a few years ago where I had a Spanish-speaking plaintiff and a bilingual attorney with that client. And on the other side, there was a defense attorney and a client. And the defense attorney was very skilled, very persuasive, a very effective speaker. And coming in, I knew that. And so we're signing in for the mediation, and I noticed there's a name I don't recognize on the claimant side or the plaintiff side of the ledger. And I said, who is this person? And the plaintiff's attorney said, I'm not really sure. Who is that person? It turns out the defense had hired a professional interpreter, knowing that I was a bilingual mediator. There was a bilingual attorney on the other side. And this attorney wanted to have an opening session and wanted to make sure that everything he said was being accurately conveyed to the other side. And it was a conciliatory, it was a very effective opening presentation. It wasn't adversarial, but it was more, conducive to a productive process. And he wanted to make sure that that was conveyed. And sure enough, this was one of the best interpreters I've ever seen working in a mediation. And she was, simultaneous interpretation. So we were talking and she was whispering in the plaintiff's ear so that as we were talking in real time, the defense attorney could be as effective as possible by communicating directly to this person. And it made the mediation successful. I'm convinced of it, even though after our opening session, we're in the private caucuses, and there was 4 of us speaking Spanish at that point because the interpreter was then in the plaintiff's private caucus room they were fine with it. They encouraged it. And throughout the day, it enhanced everything just because in large part, I credit the interpreter and the defense for being aware of the issue.
Yeah. Yeah. I mean, I think, I wish that in every instance we had those resources. Everyone always had those resources available to them, but that is the way to approach it. If you have all of the resources in the world and not in the world, but the ability in a case that you can do that. And I think in a lot of cases, that may not be possible. In some cases, you're dealing with, you're working with a certified interpreter. And then in some cases, you're dealing with, unlicensed or other interpreters, right? And I'm thinking, staff in an attorney's office or a family member or worse yet, a child. Though I've never done the mediation with the child. I've heard about it. I have been a child who, although my mom spoke very good English, that did some interpreting at times. And it's a great benefit to that child, but I would, ultimately, I guess, long term, but obviously within the mediation process, that one is the one that makes me the most uneasy when I hear about, their child spoke whatever language it was. And so what, I guess, Doug, I'll do it presenting it to you, kind of what obstacles or opportunities do you see with, if we can't find the licensed or the certified interpreter, right? If we have some language where we're just, we're searching for the best that we can do, do you see a benefit for whether it's a family member, office staff, or some other solution to having somebody to interpret or serve in that role?
Well, I do think it goes back to something you said earlier about, it's not always necessarily essential, in my view, particularly in a private caucus, to have a word-for-word interpretation of what's going on. And a lot of times, to me, it's more about the comfort level. Again, I keep coming back to that as well. It's just, if you have let's say it's a paralegal or a case manager, office staff who's been maybe knowing that client for weeks, months, years. They've built a bond. They just have. And there's a trust there that, I mean, to me, it's part of that communication. It's not word for word communication necessarily. It might be, but it's more the background understanding and the knowing how to relate to the person, having that bond of trust. And for a family member, that those elements are going to be even stronger when you've got somebody who you feel like, it's not like having a stranger in the room with me when I'm making potentially one of the biggest decisions of my life. Should I settle my case today? You have somebody that you can, again, feel free to express yourself and not have that other dynamic of a different person in there that may impact that plaintiff in a way that causes them to feel less comfortable or less free to speak openly about their emotions or things that they need to get out there to work through one way or the other to get to yes in a mediation process. So I think maybe as we said before, interpreting is really hard. So you might very well lose some of the precision of a professional certified interpreter, but it's a balancing act to me. So I don't know, that's kind of the way I look at it. I'm sure there's different ways of looking at it too.
Hey guys, I wanted to interrupt just as we're coming to a bit of a period of closure here, of a question that I got from the audience, and it actually shifts a little bit from the language to culture.
Yeah.
And I don't know if you're willing to speak to this, but I think it's an interesting question as you guys have worked with different communities, putting people in a room that need to understand the concept of mediation, the concept of willing to reach a resolution as compared to have a principled position and not move from that in terms of a cultural position. Can you guys be willing to talk about that for a couple minutes?
Yeah.
Sure.
Yeah, absolutely. So, and we've got, and that question is excellent. That is a, I think particular challenge if that is right, that there are some, I think some cultural reasons people hate what we do, right? They hate the idea of trying to compromise and meeting in the middle or whatever it is, like that idea is just the most abhorrent thing that they could imagine. Right. And I think as far as it, with that specific scenario or that specific question, if I'm dealing with somebody who has kind of that deep cultural tie to that, number one, I want to make sure that they understand the respect that I'm showing them through the process, right? We go back to the dignity of being able to make your own decision, right? And so I would very much focus on first hearing what it is, their thoughts on what they anticipate the litigation will be, what they anticipate will be the outcome of that. Kind of assess where they are in their understanding. Some people may be unsophisticated completely. They really don't understand what litigation is going to look like. But I've dealt with some folks in those instances. I had a business dispute where I had someone like that, but she was very sophisticated, right? She was an executive of a company. She understood exactly, but she still had that cultural, no, I'm not doing this unless, whatever. And I'm not going to. And I think the most important thing I feel like we always do in facilitating communication and negotiation is building that rapport with the person. Right. And if you've got someone like that, empowering them, making them feel like right. Because anyone I know who wants to stand on principle, they want control. They want to know that right. And so give that to them. Stress the importance of that as a factor in their decision making, generally. But this gets to what Doug and I talked about with the cultural barriers. Don't overgeneralize. Right. I think that I saw something recently, one of the, I can't remember, it was Harvard Business Review or one of their negotiation programs sent me something by email. And they gave this anecdote about I think a negotiation between a company in America and a Japanese company, and where they came in very sophisticated parties, and the Japanese executives studied how Americans negotiate and how to behave with Americans, and the Americans studied how the Japanese negotiate and how to negotiate with the Japanese. And so then they came to this negotiation and they missed each other in the middle, right? They had overgeneralized and prepared themselves to be prepared for their adversary, and in the process they completely missed each other, right? And so while we need to prepare and be aware that these things exist, there's nuance in everything. We're all, each individual is a little bit different, even if we have some of those cultural indicators that would suggest that we're going to behave a certain way, we might not, right? And being, I think, aware and flexible within the mediation to exactly what it is that you're dealing with and how best to get through to that participant would be my best swing at an answer to that one.
Yeah, that is a great question. And, I think I would tend to lead with the approach I take to mediation generally, which is leading with empathy. And I want to know, I would continue to ask questions about those principles and try to draw those out. And then, like Michael said, then once you can kind of find something, if you find a thread you can pull on a little bit and then help that person, if control is their objective, for example, then help them see maybe how you can get there through this means of, you might have, a way of getting to that concern in a different way. If you can be creative and not overgeneralize, as Michael said too, and just treat every person, it is useful, I think, just to have those general concepts in your mind, and maybe do a little research if you're having somebody from another country, let's say, or a company that has it. Companies have cultures too, right? So if you know that there's a certain way of coming in with a mindset maybe, or something that they're taught, or they have mission statements or things like that, kind of figure out where they're coming from, and then figure out how you can address those needs, how you can make them feel good about the process and arriving at a decision in a way that they are able to convince themselves that they're getting what they need, even though it might look to you a little bit differently. Don't assume, and don't, try to come in without judgment about those principles or whatever's driving them, because ultimately it's about getting them to feel comfortable that they're getting what they need out of the process. And I'm not, as a mediator, I might look at it differently, but it's their process and it's their end game that they need to make those decisions and feel comfortable with them. So it's very complex, obviously, but something we have to find our way through as neutrals and as advocates.
Yeah, and as people.
It's
funny. I was thinking about this as Doug was talking about that. I'll say the one kind of practical thing I found that works for me, at least with this is in general, not just with language or cultural barriers, but people who are really they really dug in and really, they're having difficulty seeing the other viewpoint. That's something other than what I think can happen, right? And that is, and I'm sure you can read all about it in lots of different places, but the power of mirroring, right? For somebody who is like that, generally, at least what I have found, is using their own words, right? Their own, I do all my mediations. I make 3 promises to the parties. I say, number 1, I'll listen to you. Number 2, I'll be honest with you. And number 3, you will have control. Okay. That's my mantra, within mediations. And so listen to them, right? Get them whatever they want to share or willing to share initially. Try to open them up, kind of like Doug was talking about. But then when you start addressing them back, if someone is that intransigent, I have found that really honing in on the words that they're using and the way that they're saying it and mirroring it back to them. We all like to think we're very intelligent. So when we hear our own words back to us, we think that speaker must also be very intelligent, right? They must know what they're talking about. I think there's a little bit of that, but generally there's that likability factor and that building rapport and that connection in some way with the person, so that they will, if you say something other than what they believe, they'll trust you at the end of that process, right? They'll have built that up within that short period that you're together, to believe you and maybe be convinced to do what you're asking them to do. So.
I don't want you to think that I'm now making you sound that I want to make you feel like you're smart. When you said the word mirroring, I think it's a fabulous thought process to consider as part of a conversation with the parties to recognize they're looking at you to make sure you understand them, and mirroring is part of that. And I think many times we forget about that, and that, you know, as this day goes on and people give these little tidbits of wisdom that I think really shape how we all are as neutrals. I think that that's a really interesting piece right there that I hadn't thought about at all. So thank you for that. That's interesting.
I think that's interesting. We're going to run out of time, but on the technical jargon piece, the flip side to that, one of the things you just addressed is, you know, you may have folks who want you to understand their technical, right? You're doing something that's got particular technical nuance to it, and to build that rapport, that trust, they want you to use their words, right? Whereas other people, they want you to speak plainly. And so I think it's, it's interesting.
That's
Doug, you get a chance for last words on this then.
Yeah, good, Doug.
Oh, wow. Thank you. Well, as you were talking about the mirroring, you know, it made me think again about sort of both sides of the communication equation. And a lot of the way you might think about interpretation and language barriers is making sure the other person understands what's being said as part of the mediation process. But I think ultimately, you know, to connect with that person, I'm a big believer in making that person absolutely feel that they've been listened to and they're being heard and understood. And you have a lot of ways to show that you are listening and understanding as the other party, or as a mediator as well. Mirroring is one of those ways, but you know, you can do it through body language. You can do it by asking questions. You can do it by, you know, rephrasing things, just making sure that you're getting it right. But I think that listening, feeling listened to and understood, is as important, if not more important. I don't want to say it's more important, but it's really essential to make everybody feel that they're engaged in the process and that they're adhering to the principles of mediation that we talked about at the outset: self-determination, voluntariness, control, all those things that make mediation what it is. And that's why I know Michael and I are so passionate about this topic, and we think that there's a lot of, again, we don't have all the answers. There's so many wrinkles to this. There's so many nuances, but it's something, if we're all more aware of, we can start thinking about continuing to build these solutions. And yes, there are pitfalls out there, but I think if we all continue to work together and just try to make everything, just kind of increase our connectedness and our communication lines, I think it makes the process better for everyone. And that's why we're really proud to be here to talk about it. And thank you again, and thanks to everybody for being here to participate in this really awesome day. So Scott, kudos to you and everybody that's organized. This is great. Thank you.
I so appreciate both of you making the time to participate in this. I know Michael definitely worked around his schedule to join us today. I know it's a topic that we heard last year with the GODR Day, and really appreciate you guys carrying on that topic for us today. Just to mirror what you said, Doug, I really enjoyed listening to you guys over the last hour, and I've learned a lot. I know our participants have as well. So I will let you guys go. In fact, I will let everybody go. We've reached our noontime break, and we will reconvene at 12:30. Enjoy your lunch, your break, and we'll see you back at 12:30. Thank you guys again for participating. We'll see you all soon.
Thank you. Thank you.
Appreciate it. Thank you.
We've got a minute to 12:30. I just wanted to make sure, since we're in a virtual format, that I've got my speakers here so that Lane at State Bar can highlight them. And as he's doing that and getting us started to start the program, I want to introduce you to Justice Sears, who is here. Wonderful. Marcy Dixon from NAM and Tapestry, and Audrey Lee visiting us from Harvard, I presume all the way from Boston. Thank you, Audrey. Marcy, wonderful to see you. And I guess we're just waiting to connect with Justice Sears. And there we go. There we go. All right. Again, for those of you who are joining us, maybe just for the afternoon session this afternoon, the bios of our speakers are all provided in the materials given to you when you registered. And it's an honor to present this group on a topic that I know many of us have been talking about a long time regarding implicit bias and mediation. So I'm going to turn it over to you guys. Thank you all for being here and participating in this event today. Thank you.
Thanks so much, Scott. Great to be here today. I am going to share my screen momentarily. I'm having some tech issues. I am actually not in Georgia right now. I'm in San Francisco and on my little laptop. So I'll share my screen in a minute. But it is great to be here with you today. And I'm really excited about this discussion that we're going to have. I am Marcy Dixon, as Scott said, president of Tapestry ADR, which is a new business unit at NAM. I'm also a member of NAM's executive leadership team, and I'm really, really excited to be joined by two women I respect and admire a great deal, former Chief Justice Leah Ward Sears and Audrey Lee. I'm just going to do a brief introduction because I think it's important that you know who they are before we start our program on implicit bias and mediation. Justice Sears, if you're in Georgia, I don't think she needs any introduction. She is a panel member of NAM, but she's also a litigation and appellate partner at Smith Gambrell and Russell in Atlanta. And most notably, before she returned to private practice, Justice Sears served 17 years on the Georgia Supreme Court, including 4 years as Chief Justice. And I think what's just absolutely worth mentioning is that she was also the first woman to serve as a jurist on the Georgia Supreme Court and the Superior Court of Fulton County. And she was the first woman elected statewide in Georgia. And then we also have Audrey Lee, who is a senior mediator at Boston Law Collective. She's also a founding principal of Perspectiva. And she's also a lecturer on law at Harvard Law School. And she teaches courses on mediation and diversity and dispute resolution. And she's also a lead faculty member for the Harvard Mediation Intensive. So if you have reviewed the CLE materials, and if you haven't, that's entirely fine, you will find that one of the articles that we submitted is one of Audrey's articles. It's called Implicit Bias and Mediation, Strategies for Mediators to Engage Constructively with Incoming Implicit Bias. So I encourage you to check it out after the program. Now, we'll get started. We are talking about strategies for overcoming bias. I'm going to share my screen. Bear with me. Hopefully this takes just a little bit of time. Can everyone see my screen?
Yes.
Perfect. Thank you, Justice Sears. So we chose to do this topic because it's an incredibly important topic that we should have top of mind as dispute resolution practitioners at all times. In addition to all of the practice enhancing information that you're receiving today for this program, we believe that the issue of implicit bias is something that we want to keep top of mind because it's a phenomenon that affects each of us. And as an ADR administrator at NAM, we help 2,600 neutrals across the country, including in Georgia, work with parties. And in that process, they are highly skilled, experienced, and also bias aware. If they're not, it can potentially impact the mediation proceeding, and it won't necessarily be perceived that it's fair and transparent. So this is an important issue. Implicit bias is something that is wide-ranging, and it is also something that has wide-ranging implications in the courts and healthcare outcomes, employment and hiring decisions, education, consumer discrimination, and the list goes on. So I've already introduced Justice Sears and Audrey. So we are going to start by, well, I should mention that our goal for this session is to make this as engaging and interactive as possible. So if you have questions while I'm talking, or Justice Sears or Audrey, please drop them in the chat. We will monitor the chat, and we'll also have a Q&A session at the end. We also have a couple of exercises that we'll do with you at some point. So to start, I think what would be very important is for us to frame the conversation in terms of what exactly implicit bias is. Implicit bias, unconscious bias, they're terms that are used interchangeably. And most important, how implicit bias can impact a mediation proceeding and the ultimate outcome. And then on a larger spectrum, how mediation is perceived in terms of its effectiveness, broadly speaking. And then we'll close out by sharing practical strategies, and then we'll jump into the scenarios. So it's worth mentioning that Justice Sears, Audrey, and I are not social psychologists. So what we're sharing with you is steeped in research and also empirical data as well. So in terms of what implicit bias is, it is a form of bias that is the tendency for us to process information based on unconscious associations and feelings that run counter to our conscious and stated beliefs. They're rooted in our subconscious. And what the research shows is that unconscious bias is pervasive, it's measurable, it's malleable, and it's extremely persistent. And as a result, it shapes our actions, our behaviors, and also how we interact with others, which, as you can imagine, in a mediation proceeding might have some issues. And it also operates on a subtle level, because below our awareness, it's often driving the behaviors and micro behaviors. And that is incredibly important, especially as dispute resolution practitioners, if you are dealing with people from all walks of life. So it would be important to highlight that there are a number of different types of implicit bias, right? I'm not focusing on cognitive bias here. We're talking about implicit bias, which presumably would be the occurrence of making judgments, having attitudes that you're not aware that you have, and it shows up potentially in a mediation proceeding. Or, the parties who show up to a mediation may show biased actions toward the mediator, and it's important for the mediator to be able to recognize what's going on in that situation. So I'll just highlight just a few of them here. And there's affinity bias, which is our unconscious tendency to connect with others who have similar backgrounds and interests and characteristics. I went to UVA. So anytime I meet a UVA grad, I'm like, yes, this is wonderful. I will work with you. I'll do anything. That's a form of affinity bias, because it's someone that I feel that I'm connected with. And if that colors how I do business with them or determinations that I make in terms of working with them or others, that can be problematic. Another form is confirmation bias, and that is our tendency to search for and interpret and remember information in a way that confirms our pre-existing beliefs. And I know that when we share some scenarios later, I'm sure that we'll be able to highlight some examples of how this plays out in a mediation proceeding. Another form is gender bias. It's where we prefer one gender over the other, and we have stereotypes about, one gender over the other, or anyone in terms of how they present themselves. There's age bias. There's name bias. There's no doubt that factors in, at times. There's the halo effect, which is when you believe that a person is good or competent in one area, so you just automatically presume that they're great at everything. And then there's also the horns effect, which is the opposite of halo effect, where you interact with someone and they perform poorly. We all have our moments, right? But then you presume that individual is incompetent, and you don't necessarily perceive them or give them the grace that they deserve because they didn't necessarily meet your expectations. Another form of implicit bias is outgroup homogeneity bias, and that is where you see members of an outside group as more similar to each other than they truly are, while you see members of your own group as more diverse. And then there's also conformity bias, which is where we're influenced by our thoughts and our actions of a group rather than objectively assessing the information that we have. There's also in-group bias, which is where it's the inclination for us to favor those who belong in our group, right? Like my UVA counterparts, right? And those who don't. And sometimes when we do this, we don't even realize that we're doing it. And that can have serious implications, particularly in an ADR proceeding. And then last but certainly not least, and there are so many other forms of implicit bias, there's authority bias. And that's where we place more value on the opinions of those that we see as authority figures, like Justice Sears, judges. I don't know, it's
Yeah,
it's a common occurrence. You see a title, you just assume that someone has the authority, so you give them the power. And you can imagine how that might play out in a mediation proceeding as well.
Marcy,
So I'm going to stop. And Justice Sears, yes.
quick question for you. This name bias, is that like foreign name or name that you're not familiar with? Or what exactly is name bias? You don't like the name, or it's an odd name, or?
It's a good question. I think it's a combination of several things. It's where we make judgments about a person solely based on their name, especially if it's a name that has an ethnic or a national or cultural characteristic.
Okay. Got it. Interesting. Thank you.
Audrey, anything that you wanted to add here?
Just something briefly first. I just wanted to say hello. It's really wonderful to be here with everyone and with Marcy and Justice Sears. I just wanted to mention that in my own reflections on this topic as a practitioner and someone who's just interested in trying to learn as much as possible on it, I've been really sort of struck by the power and also the sort of trickiness about something like affinity bias. Like when we have a positive feeling towards someone, because typically when we think of a bias, it's something negative, it's a bias against. And so I've been trying just in my own sort of personal practice and as a mediator, I've been trying to be aware of that sort of natural feeling, like you're saying, like the same college, same grad school, same neighborhood, et cetera, because it's something that I think otherwise might not be on our radar.
Absolutely. Okay. So in terms of how this impacts a mediation proceeding and just, I think, ADR generally, there are a lot of different ways, and I'll just highlight a few of them in the interest of time. There are a lot of different ways that a mediator displaying implicit bias or parties showcasing biased behaviors can derail a mediation. The first one is, the judgments and perceptions that we might form as a result of interacting with those, the parties who, bear with me, my screen just froze for a second. Sorry about that. And it's based on whoever is at the mediation table, whether it's, you're judging them based on their race or their age or their status or so forth. So if that can derail a mediation, if the mediator particularly is in a situation where they're engaging in that type of bias, it can also impact the communication dynamics at the table. Because if a mediator is unaware of their biases, they may not even aware that they are communicating with one party differently than the other, or maybe they're misinterpreting statements, or maybe they're favoring one party over the other, and that might color how they communicate with the parties. Obviously, one other implication is decision-making. Mediators who are unaware of the unconscious biases that are at play in a mediation proceeding, it may impact how they assess and make recommendations, and it might skew the actual outcome in one, in the favor of one party. And that's not intentional. It just happens. They're unaware that they're doing it. And then there are also some other implications as well. There are impacts on the ability to build rapport, because if a mediator or parties are unaware that they are favoring one party over another based on their shared values, characteristics, experiences, they're going to have a deeper rapport with that individual, right? And we all know that in a mediation proceeding, building rapport is critical, especially for the mediator. There are also, there's the economic risk that can come, as a result of implicit bias being present in the proceeding, as well as reputational risk for the mediator or counsel if it's obvious that implicit bias is at play throughout the proceeding. And then there's, broadly speaking, and, we talk about this a lot, about wanting the broader society to use ADR and to see ADR as an effective tool for resolution. So if implicit bias is impacting mediation proceedings, does that lead to an erosion of trust for the mediator, right? And then also just for ADR and mediation specifically in general. So Audrey, Justice Sears, anything here? What else would you share in terms of how implicit bias can impact a proceeding?
I mean, it it does impact. It's just something that particularly mediators have to work. So you have to listen very, very carefully. You have to be, it's a job. You have to work on your biases because they absolutely exist. They even exist in me. And I'm kind of one of the most minority of minorities, an African American woman. And I've noticed, I caught myself, oh my gosh, I thought so-and-so. And I thought as a Black woman, I would never think like that. So they are absolutely in everybody, and you have to be always aware. I think I work on it. So my concern is that many mediators don't. You know, it just goes right by them. It's just not an issue for them, but it needs to be an issue because it totally skews the mediation process. And it does create a situation where people don't have trust in the ADR system. I mean, they don't. They'd rather take their chances in a court of law which also has implicit biases mixed into it as well. So that's all I would say.
What about you, Audrey? Anything?
Yeah, it's so good. I always take a moment. I need a moment to reflect on what's just been said. That was so helpful, Justice Sears. And I was just also thinking about some of my own experiences where I think that our human nature, right, is to maybe think about situations where other people might be seeing us in a way that is incorrect or incomplete. And just appreciating what you said, Justice Sears, about the need to look inward and to raise your own self-awareness about how you're showing up, how you're interpreting information from your parties, whether it's, you know, before the mediation, it's the initial conversation, the preparation as you're reading, you know, what they've submitted beforehand. And so I think just taking that step of sort of committing to some heightened self-awareness is just so important for mediators because we're charged with being neutral. And I think for me, I've been trying to sort of retrain to think of it as impartiality or omnipartiality, something that just sort of in a way recognizes that, you know, what is it to be neutral?
Right.
We have this heightened awareness about these implicit biases that we have.
I mean, it's almost like you can't be neutral. And I think you made one of your articles talks about this, Audrey. It's like people who say, I don't see race, you know, and I just roll my eyes, you know, really, you know, or, oh, I don't see this, or I don't see that. And even the statement itself is an acknowledgement that you see race, or you see gender, or you see this or see that. So it is something you have to work on. Everybody has to work on. So.
Absolutely. So that's a nice segue into discussing how we can recognize our own biases, because Audrey and Justice Sears are absolutely right. We are all biased, and you know, sometimes it's conscious, sometimes we are completely unaware that we're doing it because we've just been conditioned you know, to believe certain things. So in terms of how we recognize bias and how it shows up in a mediation proceeding or in our interactions with parties, Audrey, I think you're going to say a word about this, but there's a tool that you can use. And I would actually encourage everybody to do this. It's the implicit association test. It's a psychological tool that's used to measure an individual's subconscious biases and their associations between concepts that can help uncover hidden preferences and prejudices. And Audrey, do you want to say something about that? Because I know you're much more familiar with IAT than I am.
I think you described it really well. And maybe that's something that could be included in follow-up information, just a link if people are interested in checking it out, or if you just Google implicit association test or IAT, a lot will come up. So I echo what you said, just in terms of encouraging folks to check it out if you're curious, to just get a little bit of additional data using this particular format.
Will this test show you where you're biased, or just show you that you are biased? Does it show you the areas where you've got to work? I'm just curious. I'd be interested in it.
Yeah, that's great. Marcy, should I initially respond? Would you like to respond first to that?
You can take that. I took the test a while ago, and I do not want to share what the results were. I mean, to the point of everyone being biased. I mean, it does. It highlights biases that you otherwise were not aware of. And in fact, the creator of the test, one of the co-creators, after she took her own test, as a Harvard professor, she was just floored by the results. So Audrey, do you want to say more about that?
I would just add, going back to your question, Justice Sears, about sort of what you learn, about yourself. And again, just, this is a particular way to try to gain some self-awareness. You are able to choose amongst different, I'll call them social categories. So like I've taken a number of them. So like the race IAT, there's one that looks at Asian American or Asian faces and compares them with images of sort of famous sites in different countries, both in the US and abroad. And so it's kind of looking at your reaction time between pairing images, for example, using this one as an example, of Asian or Asian American faces with domestic or foreign places. And so the idea is that if you're able to associate more quickly or on an unconscious level, things that sort of go together in your mind. And so that's the way in which this particular test tries to give you that information.
Okay. Excellent.
And we'll actually share the test for anyone who's interested in receiving some of the resources that we mentioned in the presentation. We'll do a follow-up. Scott, sorry to put you on the spot, but if you just reach out to Scott, he can put you in touch with us, and we make sure that you get a link to the test and additional resources that we mentioned. There are some other ways that we can also identify biases as well, and that's just, as Justice Sears and Audrey mentioned, just doing serious self-reflection. Sometimes just sitting and doing an analysis of what our own beliefs are, what our reactions are in certain situations, and then what are potential triggers. Another useful strategy is just feedback. It's so helpful to ask your peers or your colleagues, anyone, how you were showing up, and especially like the parties. I would imagine most mediators follow up with the parties after a mediation to get a sense of what their experience was. But in that follow-up period, it can be very helpful to solicit feedback from the parties to just see what their experience was with you. And it might be uncomfortable to do that, but you might be surprised by something that a party shares with you that you can then make an adjustment. It's just useful to get that knowledge from individuals who are interacting with you in a mediation proceeding. And then obviously there's training. I mean, there's so much out there in terms of trainings and workshops and resources. I know Audrey does them, and the state bar obviously does programs as well. It takes a concerted, intentional effort for this to stay top of mind. And as Justice Sears mentioned, it takes work, because we all have biases. We all have them, and it's impossible to show up and say that we're completely unbiased. It's just unrealistic. So to the extent that we are surrounding ourselves with different people so that we get to flex the muscle of being in uncomfortable spaces or interacting with others we otherwise wouldn't interact with. And then also doing training and education to make sure that we're aware of all the various ways that implicit bias can factor and color our interactions with others. Very useful. And then there are other ways as well, in a mediation proceeding, you can watch for language or certain cues. Like you can pick up on all of this based on comments that a party might make, or maybe you're saying something that, a party may have an adverse reaction to, and it's worth stopping. Like Audrey did a second ago, she stopped, she's thinking, sort of stopping and thinking, like, how is this landing with this individual, and why are they reacting in this way? It could be the way that you are interacting with them. So it's worth stopping and just like being mindful of it. And I'll talk about mindfulness in a minute, but mindfulness factors in so much, because when you're aware of how all of these biases can show up unintentionally. You're just more aware to make adjustments, to interrupt it, and we'll talk about strategies in a minute. But from active listening to reviewing your decisions after a mediation, there are a lot of different ways that you can recognize whether or not there's a pattern of bias showing up in your interactions. And then also, again, Audrey mentioned it, there are going to be situations where you'll be interacting with others, the parties, counsel, where they are also showing similar bias, and you have to know how to counter that in that particular situation. Justice Sears, Audrey, anything that you'd add to that? Any other strategies or tools that we could share with the audience in terms of how they can recognize bias?
I don't have any more. I don't.
I think one thing that comes to mind for me is, and maybe we'll talk more about this a little bit later in our time together, is just, as a mediator, sometimes, and I guess I should take a step back to share that a bulk of my mediation practice is on workplace disputes or early cases. So it's before maybe there's been a formal complaint of discrimination or lawsuit. So it's maybe a special opportunity to really try to look at some of the things and maybe repair working relationships. So I guess what I was thinking about as Marcy, you were sharing this information is just that sometimes we as practitioners or as attorneys or parties in a conflict might have one reaction or interpretation. And I think especially when we are the neutral, something to consider is, am I experiencing that comment or behavior in the same way that the other party, the maybe receiving party is? And sometimes yes, sometimes no. I think it's a challenge because we're in this sort of middle neutral, or impartial third party role. And sometimes we might have a certain reaction and gosh, that the other people or person doesn't. And so I just think it's one of these things where it's very dynamic and in some instances very individualistic in terms of how someone might be experiencing a comment or behavior.
Yeah, because what happens is it goes through your filter, and your filter has all these biases in, and you have to be mindful that might be coloring the story. You have to always be mindful that they're not hearing it the way you said it, or the way you are hearing it is not what they intended. I mean, I get that a lot, and I try to be a good listener, but that's part of what Marcy was saying. That's part of the work, or what did you mean? Always asking, like, what did you mean? Could you break it down for me? Could you explain it versus receiving it wrong because of your filter?
Absolutely. Okay, so with that in mind, what are some of the tools and techniques that we can use in a mediation proceeding to create a bias-aware, culturally sensitive environment where everyone feels safe to speak, everyone feels like they're being heard, one party isn't getting more time than the other? Like it's the ideal situation for a mediator and the parties at the table. I'll just go through a few of them, and Audrey and Justice Sears, please jump in. The most obvious is training. We talked about that. Like, this is something that we always have to keep top of mind. So cultural sensitivity, diversity, implicit bias training, always helpful for any individual to use. There's the need for more diverse mediation panels, right? So if we encourage diversity among our mediators and potentially even having co-mediators work alongside other mediators, that might provide an opportunity to reduce the risk of cultural insensitivity happening in the mediation proceeding. And then also the parties have an opportunity to work with two different mediators as well. Active listening, we've mentioned that always comes up. This just ensures that mediators truly understand and respect the perspectives and the values of all the parties who are at the table and vice versa. And another, effective strategy is to ask open-ended questions that don't lead or suggest specific answers, because in doing that, that can reduce the risk of imposing one's own biases on the parties in the proceeding. And then some obvious ones like avoiding assumptions. Like Justice Sears said, always ask for clarification rather than making an assumption based on a party's background or their appearance or their behavior. And part and parcel with that is also using neutral language. So avoiding charged or biased language that might help in maintaining a neutral and respectful tone throughout the proceeding as well. And there's just so much more here. So I'll stop. And Audrey, Justice Sears, please jump in. Let me know what tools and techniques have you seen? What do you do yourself in your own proceedings? I would love to know your perspective.
I use active listening quite a bit. And I always establish the ground rules. I'm going to have a mediation tomorrow, and I have all this list of ground rules that involve cultural and sensitivity and that kind of thing. I've never used co-mediation. I would be very interested in that, but I've always assumed that parties may not want to pay for two mediators. I'd be interested in your experiences on that. I've seen, everybody says co-mediation, but I've never seen that happen. Is that something lawyers and parties are willing to pay for? Does it happen frequently?
Justice Sears, I think that's an entirely different segment. I think, no, it's not as common. I think I am showing my own bias here. I think that it's a useful tool, but there's a lot to unpack there. And I think in the interest of time.
Okay. Okay, sorry. Sorry, okay.
I have a quick sort of response, or I guess to chime in on this question of co-mediation. And then I was really curious, Justice Sears, I would be so interested to learn maybe one thing that you just sort of briefly mentioned about, I think you said like a checklist about ground rules and things that you cover, or maybe make explicit with parties in your mediation that relate to cultural sensitivity. I would be so interested to learn one of those. And then just briefly to go back about co-mediations. And sometimes when I'm on a pro bono panel or helping out in a court program, like in the past or present, that, I've had experience co-meeting in that context. And I have had one experience where the organization was willing to pay. It was a blended fee, so not like two full fees. But it was, substantial because it's more than just one person. And it was myself and a male colleague. And the issue was a gender discrimination situation. And they thought that it would be very helpful to have a male and female mediation.
Audrey, I could see how that could be extremely effective. I don't know, Marcy, if we're all off track, but I would enjoy having somebody to balance me out, so that we're just, we're doing right by everybody, because you just never know. But I don't want to, and in terms of like what's going to one of the things that's on my checklist is that when you have to hear the person out. There's no jumping in, over talking, and this kind of dynamic is really, really important with the male-female dynamic, who has power, who doesn't, that kind of thing. So I'm very much emphasize, uninterrupted conversation, uninterrupted statements. And I say it, I don't just say statements, it's always uninterrupted, because of the power balance in much of the employment mediation and domestic mediation that I do. That's just one. Does that help?
That's great. Yeah.
Okay.
Thank you so much.
Okay, so we will stop here. We have going to shake it up a bit because we could continue going on and on, sharing strategies about how to identify and interrupt bias. I mean, we've already shared some strategies and some tools. I did want to say, because I didn't mention this earlier, that studies have shown, this is my plug for mindfulness, that mediators who meditate and have mindfulness practices are more effective at not letting implicit bias color their interactions in mediation proceedings. So worth noting, because there's been significant research done on the effectiveness of mindfulness. So we, in the interest of time, I'm watching it because I want to make sure that we leave time for questions. We've prepared a couple of scenarios. And this is where I would love for all of you to participate if you have questions, if you would like to weigh in on these scenarios. Audrey's going to take this one, but what we will do, because we have over 100 people on the call, we won't break into breakout sessions or anything like that. But please take, if you're eating lunch or doing something else, this is your call to look at the screen. Please take 30 seconds to read this scenario, and Audrey, I will pass it to you. And then we would love to hear from you in the chat. We would love to know how you would respond in this particular situation.
Great. Thanks for the setup, Marcy. So I'll just let folks take a look at the scenario on the screen. And as Marcy said, we invite you to share reactions, what you might say or do if you were the mediator having this conversation in private session with one side. What is coming up for you as questions or possible mediator moves, what you might say or do? While we're waiting for folks to chime in via chat, just wanted to acknowledge the 2 questions/comments in the Q&A section. And so Shanna, we will definitely include a link to the IAT test in the follow-up. And Shan, thanks so much for, giving the shout out for co-mediation and community-based mediations. I agree that like the diversity of sort of professional background, lived experiences is huge in my experience as well.
Are we still waiting for responses?
I think so. Oh, amazing. Getting some responses in different ways here. Okay. Right. Thank you so much, Elizabeth, for sharing an idea that you might say something like, hey, let's not jump to conclusions and give everyone a fair chance. So sort of acknowledging maybe an underlying concern about, whether something's going to happen here, whether there might be an agreement at the end of it. So sort of maybe a more general response, and seeing some other responses here as well. This is terrific. I'm looking at both the Q&A and some folks have been direct messaging me in the chat. Yeah, I'm just going to read some of these out. So what do you mean, like them? This reminds me of something that Justice Sears said earlier that I try to remember as well when I'm mediator. Sometimes just kind of relying on and trusting our sort of basic mediator instincts, right? Not to make an assumption about the intention behind it, or just to ask, just to invite them like, hey, what do you mean by that? Great. Another person here shared an idea, help me understand what has led to that concern. Amazing. Let's try to keep an open mind, look toward the possibilities of working toward resolution. Great. I just want to take a quick look at the Q&A now also. Oh, I love this positivity. Josephine, I would say you'll be amazed how incredible and awesome people like them can be. So in a way, it's inviting a counter, like the way I think of it is like a possible counter stereotypical response. And that to me actually reminds me of something that I have done from time to time, which is to maybe share back my own experience or observation. Oh, from what I've seen so far today, it looks like everyone here is really interested in resolution. or if there's something more specific, oh, when they said this or that, that's why I don't think they're here in good faith. Like, oh, like I took that to mean, something else. So it may or may not fit for everything, just something I was reminded of by Josephine's comment. Okay, Daniel, great. I'm saying this not to agree, but to observe. So nice mediator role distinction. It sounds like your expectations are low here. What would it take to raise your expectations? Great. So I love this idea of sort of just observing or naming an observation and inviting some additional conversation on it. Yep, great. Just going back and forth here between the chat and the Q&A. Great. Love this idea, Leanne. Are there things you've observed that led you to feel that way? Another way to get at the specifics. Help me understand more so that we can address that. Great. Okay. Thanks, LaTanya. I will respond. I'm a neutral. And a sidebar comment that comment is not acceptable here. Thank you. I understand your concerns. However, let's address these issues only. So appreciating how some of us might see our roles in a certain way to acknowledge what's coming up and to sort of set it aside. So I totally get that as well. And I think that can also be very effective. I think in my own experience and sort of reflections, I think some acknowledgement or follow-up, I think can be helpful. I think if a mediator were to do nothing, which sometimes people say like, well, I don't know, like I would just keep going. I think that could be interpreted maybe as that the mediator agrees. So just different considerations to possibly keep in mind. Phew, so many responses. I just wanted to pause for a moment and just see if we're ready to move on, or Justice Sears or Marcy, if there's more you'd like to say about the scenario or some of the comments.
So Audrey, I actually have a bunch of direct messages, and I think I love the participation here. So I'll just highlight a couple of them. Christine shared, address the bias alone with the party that made the rude comment, but make it known that the great thing about mediation is that we leave bias behind during mediation. I see Steve, great comment. I think you have to take care not to step into the pose of instructing the party on bias, but rather noting the bias as it impacts that party's way of processing things, and noting that you may recommend to the other party that there might be bias that they need to mitigate by participating with your help in a sensitive way. And then Amanda, I see yours. I believe that you would have to respond to them for sure. I would also ask what brought them to come up with that comment like that. And I think that echoes some of the other feedback as well. Thank you.
I will just throw, are you finished, Marcy? I don't want to.
I'm finished, yes.
My experience at 43 years in the bar is that most times no responses like this that you're reading are made at all when comments like these are made. You just, the person about whom the comments are made just have to eat it, which is a sad thing. Yes, no?
What do you think, Audrey?
I'm just not used to seeing the majority respond like, oh, this is bias. You really need to be careful about it and do something that's not a good thing. That just doesn't happen very often.
So it sounds like, just so I'm understanding it right, so it sounds like you're sharing that in your years of experience, typically there just is no follow-up or sort of comment about addressing it.
Not at all.
Yeah,
not at all. Okay, my career has been not at all. People just run and hide. Okay, so this is a good exercise, but you got to actually do it. You can't just do it for this exercise.
Yeah, point taken.
Well, I think that's why discussions like this are so important, because it keeps it top of mind. It's important. I mean, I would imagine, I would hope that everyone tuning in their next mediation proceeding would remember this discussion and have the courage to actually intervene and just also interrupt the bias as it's happening. So
There are a few more comments that just came in, I guess, okay.
it's a good point. Someone just commented that the new generation of lawyers is calling it out. They are much more vocal when they see it occurring.
I hope so.
All right, so we have another scenario. Clearly, this is working. So we've got another one for you. I will read this one. Or Justice Sears, would you like to read it?
Yes, happy to. Scenario, party and mediator. You're mediating a breach of contract case. In your first private session with the plaintiff. Wait a minute, we already did this.
Did we do this one? I'm so sorry, did I not pass?
Yeah.
Maybe slide 9 has it.
Here we go.
Okay,
Here we go.
neutral selection. Okay, thank you. You are representing a client in a contentious, high-stakes commercial dispute involving two prominent corporations. Ideally, you need a mediator with industry expertise who is capable of effectively navigating the complexities of the dispute. The ADR administrator has recommended a few mediators, but you prefer to only use one of the 3 mediators you regularly retain. How might you approach a suggestion to consider retaining a new mediator for this mediation? I mean, this is something, I think, you know, from what I've seen, and again, maybe I'm just the old dog here, this is how mediators and arbitrators are generally selected. You know, I know this person, I've seen this person, this person, and obviously that has created the racial gender disparity in mediator selection, because it's just how partners in law firms are selected, and that's why we have the imbalance even in law firms. People want to work with people that are more like them. They don't really realize it, but they're just picking people that are more like them, that they're more comfortable with, and it creates a situation of them versus us, and that's not very good for the system.
Absolutely. So we are going to just give you another 30 seconds. Would love to hear from the audience. Justice Sears is absolutely right. This is, it is a embedded issue in the ADR community. I could talk ad nauseum about the number of times I have witnessed a mediator not be selected, even though they were clearly the best choice for the mediation, because of exactly what Justice Sears highlighted. So 30 seconds, we would love to hear from you. How would you approach this scenario if you were in this particular situation? All right, it's been 30 seconds and I don't see any comments. I hope that people are still thinking about their responses. I'll give you another 30 seconds. Okay. I'm just going to assume that oh, okay, we got one. Good. Thank you. Let's see. So we have a comment that we should inquire about the qualifications and the background that prompted the recommendation. Absolutely. Absolutely. I mean, I think at the core is not doing due diligence and getting into the habit of working with the same individuals, like having our lists of mediators that are unquestionably effective. But for a dispute like this, if there are other individuals who have the subject matter expertise and are well suited, they should be considered. We have another comment. If the same few are always selected, it is challenging to bring in new talent. We may want to begin training a new group you feel comfortable with. Okay. I would suggest that we find a disinterested panel that neither party has used previously. Okay, yeah. I mean, that could absolutely be a practice where there's an initiative called the Ray Corollary, where you're required to, not required, signatories who are committed to putting new mediators, diverse women, 30% practitioners on a list. So as a practice, even absent that particular initiative, which models the Rooney Rule, and that the Rooney Rule was problematic, you know, in a number of ways as well, is just the general practice of saying, yes, we have our list, but how about we engage 3 mediators? We always have 3 mediators that have the subject matter expertise, the qualifications. We do the due diligence and we include them as well. And then, you know, let everyone decide from there. We have another comment. I would respectfully explain the need for a specialized mediator and if there are any examples of prior experience being successful, and to provide a summary of it. Absolutely. Acknowledging professional relationships is important. Absolutely. However, sometimes forming new relationships, and it is important to consider another subject matter expert for the job is also important. Absolutely. I think we're all in agreement. Someone else has said, if I were advising the client, I would make explicit reference to the technical complexity involved in the dispute, recommending that may outweigh considerations of known quantities. Absolutely, Steve. You know, I agree with you. We have a lot more here. All of these comments they're all they're all very similar. I think we're all in agreement about how we would approach this. Here's another one. Compare qualifications objectively. One could argue it's an ethical responsibility of mediators, especially if the recommendations are more qualified on merit. Absolutely. Justice Sears, Audrey.
I have a question or just an idea. Could you use the co-mediator idea as a way to, you know, break some more diverse mediators into the, you know, into where they would otherwise be shut out, into opportunities from which they would have been shut out? Be people more comfortable.
Yes, absolutely. Yes. Okay. I mean, it is an effective strategy. I mean, someone commented earlier that particularly for community mediations, like it's a very effective strategy. I've seen it work. It mirrors, well, no, I won't say that, but Justice Sears, I'm going to call you immediately after the webinar. We will talk about co-mediation because I love that you are embracing it.
Okay.
So there are more comments. I don't want to ignore the people who took the time to add their perspectives. Leanne has shared, it's difficult as an advocate to step outside the circle of mediators you have good experiences with because of client expectations. I am open to having conversations with prospective mediators to get more information about their backgrounds and approaches so I can be more comfortable recommending them. As a mediator, I am always willing to have those conversations or pre-selection interviews. Yes, absolutely. And then we have another comment. Could you not interview the proposed mediators with opposing counsel, perhaps to see what the proposed alternatives are? Absolutely, yes. I mean, I will go out on a limb and say that that should probably be a practice. That should just be a part of the neutral selection process. These are all great comments, and I hope I didn't overlook anyone. And Audrey, I want to give you an opportunity to weigh in as well.
Oh, thanks. This has been such a great conversation. I just wanted to also mention that there's another nice comment that I received from Grant responding to this scenario. And I'm going to summarize a little bit, Grant, just reinforcing the need for some due diligence on the proposed mediators, as we've already discussed, to just see what kind of experience they've had with this type of case. Are they comfortable handling the subject matter, et cetera? And I'll just agree with the comments that have already been shared, that I also welcome and have had, conversations where people are essentially feeling out a new mediator. And so I think mediators are always happy to have those sort of initial conversations. And I think, just reflecting on my own experience at times when, someone who is just so busy and so sought after, one of the three, like in the example, is just not able to handle a case because they're booked out like a couple of months. When that neutral suggests, oh, have you thought about so-and-so? This person's really terrific, right? That goes a long way as well. Just thinking about it from a very sort of holistic perspective, I think can be helpful in terms of thinking about this important issue.
Absolutely. Okay. So we are eking it out here. We are right at almost at time, and we promised that we would leave a few minutes for Q&A. So would love to hear from anyone if they have questions. And I just want to say that these types of conversations are so vital to have, and to have them often and with our colleagues and our loved ones, because as we said at the outset, we all are biased. And to the extent that we can truly de-bias our actions, for mediators, it's a way to facilitate fair outcomes for parties in dispute, which I know this is what we all want. It can ultimately foster greater trust in the mediation process and ADR in general. So that's the goal. And I think that these conversations are so helpful because we are all working towards that goal, right? So that more individuals use ADR and mediation as tools for resolution. So to the extent that we can be aware of how our various forms of biases can impact how we make determinations and mediations, absolutely vital to continue having these conversations and using these strategies and relying on the resources that are available to us, like the IAT test, and having checklists, and just reminding yourself all the time that all of this is something that we all deal with, because no one, as Justice Sears commented, is truly unbiased. So with that said, we have 2 minutes for questions. So fire away, put them in the chat. My promise to you at the beginning was that if we did not answer your question, you have my personal promise that I will follow up and answer the question. So
can I just ask a question, since I'm going to help with the transition here? I looked up, I couldn't help but do this. I looked up the IAT test, and Audrey, is this the Harvard Implicit Association test?
That's it. Yes.
So can you tell us, like, is this something we can just go on ourselves, and it's a free test to evaluate our own approach to this?
It is. Yeah. There's some really helpful information at the outset when you land on, I think, the initial page, and then you're taken to a subsequent page where you can choose which test you would like to do. So
I think I was struck by the fact that each of you honestly acknowledged your own implicit bias, even though you're so aware of the issue. So I don't know if we have a solution to that, but it's so great to talk about it. And I now with a minute left to your session, I just want to thank the three of you for taking the time to talk about a really crucial issue in our industry. And I think something that I know from the participants, and I love the scenarios you guys did to draw out interaction with the group. Thank you for doing that. I can tell there's a lot of energy about this topic that is important for all of us to learn from. So I appreciate that. Any final words from any of you before we conclude the session?
I just want to say thank you so much for Marcy. Thank you for pulling me in to participate here. And thank you, Scott and Audrey. It's a pleasure working with you, really. This was great. I learned a lot.
Thank you. Thank you so much to everyone. It's been really a treat to get to have this conversation with everyone, and appreciate all the responses in the chat as well.
Thank you, Marcy, for putting it together. Great,
Of course.
great work.
Thank you. Happy to.
Thank you all
Scott.
very much.
care.
We'll move on to our next session. Thank you.
Bye-bye.
Bye-bye. Wow, what a way to start the afternoon. I don't even know where to go from there, except for the fact that we get to go to Daniel. Want to introduce you to Daniel Serviansky from University of Georgia School of Law's graduate program in ADR. And I had the opportunity to meet Daniel last year at the Georgia Office of Dispute Resolution Program, and excited about what University of Georgia is doing with its School of Law in ADR specifically. So Daniel, thank you for taking the time to join us today, and appreciate you talking to us today about the psychology of mediations. Look forward to hearing and learning from you.
Absolutely. Thank you so much for this invitation. And I want to start by telling everyone that I'm headlined as here to talk about psychology, but we've of course been talking about psychology for an hour now. And not only that, as mediators, we are known generally in society to be a group that is psychologically minded and a group that is influenced by the concepts of psychology, which is all to say that I hope that our immediate prior panelists who just finished presenting and everyone else here will participate either by asking questions or making comments in the chat, or even by jumping in. I am originally from South Florida, but I lived in New York for 20 years before coming to the University of Georgia as the founding director of the graduate program in alternative dispute resolution. That means that I actually quite enjoy being interrupted if it's done respectfully. I find it energizing. If you have something to say, we're here to talk about different perspectives, even if it's to disagree, maybe especially if it's to disagree. Please jump in. If you want to test the waters before that, you can always do it by typing at me. So our topic today, the psychology of mediation. Before we get started, I want to thank my friend Scott Zucker, my friend Sean Momin, and the entire dispute resolution section for this opportunity to speak. I'm honored to be here, and I hope that what I present will be helpful. So, why psychology? Well, quite simply, it helps us understand how people experience conflict. Now, that begs the question, why not psychologists exclusively as mediators? Why lawyers? And I want to invite comments here. Why is it that there is this profession of being a mediator, being a neutral, and so many of us seem to be attorneys? Any thoughts? Please take a moment to type in, why lawyers? Now, as we wait for answers, I will say that as a law professor, I am very used to cold calling. I will not do it here because I also understand the difference between this sort of event and a law school class. But you will all forgive me if I slip for a moment and try to cold call. I'm feeling the itch, but Yolanda says disputes are our business. We understand the art of arguing. Oh, do we? Does that make us good or bad mediators, by the way? Well, it seems that society puts us in charge of conflict. For one reason or another, society has made that decision. And it means that we're the ones who deal with it. We're the ones that everyone, and that's mental health professionals included, come to when it's time to manage conflict. And Scott has provided the suggestion that we understand how to resolve disputes, and he has, of course, complicated the question himself, and that is very much appreciated. We're trained to see all angles. We are. And yet we also have the representation bias, right? Think about when you've researched something on behalf of a client. How much work does it take? How much more work does it take to see the other side? So some thoughts. It's not by no means obvious that lawyers would be in charge. What would it be like if the mental health professionals were in charge? So in any event, we can all establish that lawyers have a seat at this table. Why this guy? Why me? Well, I've been a mediator for almost 20 years. I believe it's a little more than 19 at this point. I spent 10 years negotiating for a living, mostly in real estate private equity. And I've used the concepts, all of the concepts that I'm going to present as a principal, as a lawyer, as a manager of lawyers, as a neutral, as a coach, and as a professor at Columbia Law School, and most recently at the University of Georgia School of Law. Now, that means that when I present something, I can't guarantee you it's right? This is social science. And one of the most important parts of the scientific method, if we take it seriously, is that we're always seeking to refine, and every once in a while we even replace. We are seeking the right answer. We are not looking to be told we are right at any given moment in time. Now, what I try to do is stay up to date. I try to present, to the best of my ability, the most recent information that I have. And I encourage you to see this as perhaps an analogous to a case law update. We do continuing education to be generally familiar with trends. And then when we use a particular concept, or by analogy, a particular case, we actually look up at that moment if it's good law, or if it's, in this case, good science. But I try to go one step further than that, because we know that one thing is to find effects in the lab and the other thing is to find them in the field. And I very much put an emphasis on concepts that I have used. So I'm trying to present to you not only the social science, but also what has been part of my clinical experience. I'm not only presenting my clinical experience, it needs to be both in order to present the most useful, most robust, most practical also concepts. So today's goal, what I would like to do is to present concepts from psychology that may be useful in mediation. And that may be useful in mediation to mediators, to parties, to counsel. That is, to those who manage conflict, to those who experience conflict, and to those who lead the way through conflict. And I want to put an emphasis on the most recent updates that we have, and also to do so with the long-term goal of participating in a dialogue with everyone here. Now, as I've said, here means very much at this moment, right? Please do type in, please do jump in, and please do follow up. The goal here is to get it right, not to be seen to be right. Now, before we get complicated, and we'll get complicated, but before we get complicated, I want to take a minute to keep it simple. And in addition to the concepts that I've presented here, I want to emphasize the concepts that my colleagues on the prior panel brought up. And that is particularly to emphasize co-mediation. There's a lot of ways to manage the complexities that our minds bring to conflict. The complexities that are explicit, the complexities that are implicit. And the Nobel laureate, Danny Kahneman, one of the founders of behavioral economics, which is a branch of psychology, has said that there's a limit to how much of our own bias we can see. We can do work, we can see some of it. There's a limit to how many of the flaws in the way we reason we're going to see. But you might see mine and I might see yours. And that is an argument for working in diverse teams and for working in co-mediation situations. And there I want to particularly recommend the work of my mentor, Carol Liebman, who years ago wrote an article after co-mediating I believe the last of the campus takeovers, and it was in the early 1980s at Columbia University, around issues of diversity and issues of teaching diversity. And the way through that conflict very much was in two co-mediators of different backgrounds together, bringing the legitimacy and the ability to see the issues that needed to be on the table. Three other ways to keep it simple. Number one, work in teams, work in diverse teams. Number two, already mentioned as well, active listening. There's a lot of detail that I'm about to go into, but active listening is at the top of the list and remains so of what psychology brings to what we do as mediators. Secondly, empathy and assertiveness. The importance of both, and the importance of appropriate assertiveness as opposed to, say, aggression. And lastly, and this one is so simple that particularly as lawyers who we all really want to get to the point, we can miss it. For psychologists, acknowledgement is that word of hello, that nod, the eye contact, the handshake, the way we walk into a conference room and immediately make sure that we have locked eyes with and at least nodded with or said hello to everyone there. We have good evidence that that in and of itself makes a huge difference. And not only because it allows us to see everyone at the table, but because it allows them to know that they have been seen and to feel seen. So helping people feel heard, empathizing with people, and letting them know that you're doing that. So, and again, my goal today is to present a number of concepts from psychology that are useful. So we're moving on now to a broad overarching one, and also to its own category, which is persuasion. And here I'm going to define it as the act of causing someone to do something or to believe something. And this is generally believed to operate through reasoning or argument, although often it actually operates through the use of psychological processes. Now, the big question, and this applies to a lot of what I'm going to say today, is whether this is appropriately part of the mediator's toolkit. Now, I presume that this is less of a question for those of us more on the evaluative side, but many of us are on the side that emphasizes impartiality, particularly early in our training. And in that case, as much as in the most directive of cases, I want to say that persuasion, limited by the values of mediation and the particular school of mediation that you're practicing, is very much part of what we do. And the lens I want to suggest here is one of consent. Parties come to us and they tell us what their goals are, and they ask us to help them reach a resolution. And as long as that request is ongoing, and as long as we let them know what we're doing, as long as we're not engaging in trickery, then essentially one of the ways to express what we've been asked to do is to persuade them in service of their own interests to take actions that will lead to a resolution. Now, generally some concepts to use here, and they link up with the subject matter that we were talking in the past hour. Number one, I've already mentioned Daniel Kahneman, and here is an analogy that he uses. He's not the first to use it, but he is the popularizer. And he talks about our brains, and this is a model. This is not an actual truth claim. It's a method of categorizing. And he says that you can broadly talk about the systems that make up our minds as falling under two categories. First is the automatic system, system one, that is understanding a language that you speak fluently, that is driving a route home that you drive every day, that is walking, breathing, say. And then we have system two, which is the effortful system, the system that can step in and change things and consciously think about things. And as our colleagues who are talking about implicit bias point out, it's the automatic system that does a lot of the work. We wouldn't get through the day if we had to think about walking and breathing and everything else. And that no exception there is what we do as mediators. We need to put our attention somewhere, and that means for that moment, not putting it elsewhere. And being aware of that as mediators, let's put aside the question, the headline question of bias, and really broaden it. As mediators, we need to think about where we're putting our attention, about where the parties are putting their attention. And that is central to our job. Now, affect, also emotion, is often in the driver's seat. Another way of saying the same thing. Rationality takes effort. Rationality is often along for the ride, except for the moments where we consciously put it in charge. Now, those of you who have read the work of Bob Cialdini on influence will recognize an older analogy which he uses, which you see here at the bottom of this slide. And that is simply by the way, can someone, I want to confirm, are my slides visible here?
We are not.
And this is what they are not?
No.
No.
They are not. Okay, well, thank you to whoever that was. I greatly appreciate it. Let's give this one more try. Okay, so you have the two quotes that I already presented. And then lastly, Bob Cialdini has simply described the mind as working like a machine that clicks and swings into motion with the whir. Now, I want to ask you this. In mediation, who are we trying to influence? And here I very much do want to ask for another round of responses. Take a moment when you've been a party, when you've been counsel, when you've been a mediator. Who are we trying to influence in mediation? So, everyone at the table? Michika, no one. Can you, if you're willing to jump in, can you tell me more about that?
I think we are.
Where we put in the chats, but Professor Serviansky, this is Nesbitt Kendrick, I'll say, it depends. I would say we're trying to influence everyone. People come to us needing to be influenced to the possibility that their problem can get solved. And we're trying to influence different people about different things.
So we're trying to difference, thank you, Ken, it's good to see you. And we're trying to influence different people about different things. Now, in alternative view, LaTanya Hayes says that as a neutral, we're not trying to influence anyone. We're trying to facilitate the parties influencing each other. What a beautiful alternative way to phrase it. LaTanya, I want to give you the floor to jump in if there's anything you want to add. We also, as with everyone, without any obligation. As you decide whether to jump in and anyone else decides whether to jump in, I will invite an interruption if I have assumed too quickly that you are not going to. So maybe the best way to say it is that we're trying to influence and we're doing it cautiously. And maybe we're not doing it directly. Maybe the gold standard is for the parties to influence each other. But that said, there's no denying that there are things that we emphasize. There are things that we zero in on and things that we put aside. One way or another, whether it's direct or indirect, I would argue we are exercising influence. Now, this for decades now, the gold standard on influence, both in the popular literature and in the academy, has been Cialdini on influence. And what I'd like to do is just very quickly present, it'll be a review for many, but very quickly present the categories of influence that he provides, and then provide some more recent updates that I think you might find useful. Now, I first encountered these in freshman psychology. I have consciously used these strategies ever since, or for well over half my life by now. And I can tell you, you can study them forever. So please, let's not confuse this brief overview with the whole topic. But he categorizes the methods of influence we can use according to the following categories. And that's reciprocity. Now, whether we use it or merely observe it, that is central to our role as mediators when we manage negotiations. The monetary aspect of negotiation often involves one party saying one word, one number, and then the other party taking a turn. And there is this automatic, it is so natural in our psychology that we should take turns making concessions and moving toward each other if there's progress, that we almost don't realize that that is an artifact of the mind, it's an artifact of culture, that didn't need to be that way. And managing the rate of reciprocal concessions and managing the starting point in what we call anchoring is central to at least observe as a manager of negotiations. Scarcity of resources, scarcity of time. Log on to Amazon and they'll often tell you that there's only 1 or 2 or 3 of an item left. That's how I come to have a dictionary of art history. I did not want a dictionary of art history. I'm sure someone does. I'm sure it's a very good book. But I was thinking of buying it for 2 seconds and I was told there was only 1 left. So I clicked buy. Now, authority has already been mentioned. I won't dwell on it. If someone has a position of authority, it has the appearance of authority, we'll often listen to them. We'll allow ourselves to be persuaded by them. It's a responsibility we have as a mediator. It's why even evaluative mediators evaluate with caution, because people listen, and people listen even more than you might intend to what the neutral says. Consistency. If I say I will be there, I want to see myself as a consistent person, and therefore I'm more likely to be there. If you can get me to say I will be there, you increase the likelihood that I will show up. Then like it. Quite simply, and this is with all of the complexity that this brings, and with all of the difficulty and the opportunity for bias that this brings, we allow people we like to persuade us. Lastly, consensus. We look around at what other people are doing when we want to decide what we're going to do. So the question is, what's new? And I want, before sharing with you 2 concepts that I believe are new additions, I want to ask all of you. We have here a number of advocates. We have here a number of managers of negotiations. We have here a number of neutrals. We are in the business of observing influence and in the business, with caution, of influencing. What methods of persuasion do you use? What methods of persuasion do you see in addition to these categories? Take a minute to share. I'll present mine, and remember this moment, by the way. I'm going to visit with the psychology of it. This moment where no one responds, or at least for a while, no one responded. It looks like we have one now. And actually, this is a procedural question. I will make a summarized version of these PowerPoints available. I won't give you every step of every build, but I'll send out the relevant ones. Or rather, I will ask for help doing that. I don't know that I have access to the list. So here are my, before presenting mine, we have Sharif Jones saying, pointing out areas of enlightened self-interest and ensuring folks see their own interests and not working against said interests. How wonderful. Yes, interest-based negotiation, interest-based analysis, absolutely at the center of persuasion. And perhaps the fact that it's left out of books like Cialdini's Influence means that we, the mediators here, have a profession. So absolutely, and thank you for that. Additionally, Cialdini has added unity, and Cass Sunstein has recently added behavioral cascades. And a quick note on unity, and then a little more on behavioral cascades. So unity is simply the observation, and examples I think will be evident to everyone who's read the paper in the last half decade. The observation that not only are we persuaded by people we like, we also seem to separately be persuaded by people who we see as being the same as us. And note that those are different things, and also things, I'm not presenting this as a good, right? These are things to be observed and things often to be managed. But often we find that even if we don't like someone, or even if we don't like a public figure, if we see them as belonging to the same group that we do, or if our parties we note we see them following someone who they don't seem to have good things to say about, but who they feel an affiliation with, that is actually a separate mechanism of influence. If you need help thinking about it and you don't feel like thinking about politics, think of sports, right? It is simply very common for our favorite team to have someone who we don't particularly like, but who we feel an affinity for, and who, when they endorse a product, we might find ourselves buying that product. And Chad, thank you for the additional comment on needs and wants, which very much comes with enlightened self-interest, and we will visit with that. And I invite everyone who has pointed that sort of thing out to participate as we bring it up. So, fear. Thank you for that. There's simply, I've often said, I'm not the first one to point this out, that there's simply two stories, fear and hope. That kind of storytelling is about as persuasive as it gets. And when I present this to my students, I often like to present political ads that are from more than 20 years ago, because you find that the parties kind of switch in choosing fear or hope. So no one has ownership of any particular one. And that binary itself is, of course, only presented to make it easier to understand. There are so many more positions than simply two. So behavioral cascades. Let's start with the concept of social proof. If we want to find out what's right, we often look around and we decide what we see other people doing to be right. For example, you might look and see that no one is answering. So you might conclude that the thing to do is kind of to sit back and not answer. And then one person answers, and think about how your observations change at that moment. Let's illustrate that. Imagine that you're in a large organization, and imagine you see something that makes you uncomfortable or that you don't like. Imagine not only that it's just an organization, but it happens and you're either all in the same room or you're all on the same corporate form of social media, call it a Slack channel or something proprietary where you can all type at each other. And in any event, you either look around that room or you look around that virtual room and you see that no one is saying anything. Now, in this hypothetical example, everyone is saying, wow, should I speak? Should I say something? Wow, that was uncomfortable. Wow, that was wrong. Wow, he hasn't projected his slides and he thinks he is. And you look around and you say, well, maybe the polite thing to do here is not to say something. And not only that, I have limited ideas of what I should do. So I'm going to look around and, well, what am I seeing? It looks like I'm seeing 100 examples of no one saying anything. Therefore, if I want to conform, and I don't need to want to do that consciously, my mind will do that for me without even realizing it. If I want to conform, if I want to be safe, well, maybe, just I won't say anything. After all, no one else has anything to say. Why make myself stick out here? Now let's change one simple thing in that room, that social media channel, that Zoom meeting. One person says, stop, I've got something to say. Think of how the observable universe has just shifted. A minute ago, before anyone said anything, I was observing a room or a virtual room full of people who apparently were all cool with what was going on. Now, I'm in a room where someone has said, no, we need to talk about this. That change immediately makes it more likely that everyone else will say something. And think of how this gets accelerated, by the way, on social media. But suddenly everyone is saying, stop, actually, I'm not okay with this. Stop, we need to talk about it. Now, before the societal phenomenon that went by this title, I had this slide saying, me too. Stop, me too, right? And I took it out in order to emphasize that this is broadly applicable. But notice that it is very much, a behavioral cascade is very much a way of explaining one of the things that changed in society and that changed in our conversation at that moment. Wait, why are things that everyone, when you stop and think about it, would agree are not good things to be happening? Why are they suddenly all visible when they weren't before? Well, suddenly the one person and then a group of people and then a cascade of people have decided to speak up. Behavioral Cascades, Cass Sunstein, 2019. So as I move us toward the next topic, I want to invite any questions at all generally on psychology and mediation. Now, I realize the potential cascade that I'm opening up there. So I'm going to say this. I do not promise you that I will have answers. I will promise you that I will carefully consider questions along with you. And if I have something potentially intelligent to add, I will try. And I will also welcome anything that you add. So please do not limit yourself to the particular topic. Let's make our general topic recent updates on psychology and mediation, and in fact, psychology and mediation generally. And as people think about what they want to say or what they want to ask, I want to move us on to the next topic, which is satisficing and maximizing. A neglected topic in mediation and absolutely central, in my opinion, to mediation. So well, does anyone here has anyone here had the experience recently of buying a pair of jeans? You've maybe seen something like this. Well, let me tell you a story about a professor who found that situation quite difficult. It is Professor Barry Schwartz, early 90s, out in at Swarthmore in near Philadelphia. Professor Barry Schwartz had a pair of jeans that I like to imagine went back to the 60s. He was writing about it, I believe, in the late 90s or early aughts. And the pair of jeans was quite comfortable. It had slowly molded itself to his body. And he didn't much recall where it came from. And suddenly he realized that it had become threadbare and was no longer wearable. So, as one did 20 years ago, he goes into a retailer. Let's imagine it perhaps at the Gap or something like that. And he finds out that since last time he bought a pair of jeans, there are now many choices. There's the thin pair of jeans, there's the stretchy pair of jeans, there's the baggy pair of jeans, there's the high-waisted jeans, the low-waisted jeans, the dark wash, the light wash, the selvage, the everything in between. And he just doesn't know what to do about it. And he tries on a bunch of pair of jeans, and this one's a little more comfortable, this one looks a little better, I like the color on this one, look at the way this one's come scuffed already, I like where they patched this one or didn't that one. And finally he walks out and he buys a pair of jeans. I'll ask everyone to take a guess, and you don't even need to type it in, but take a guess to yourself on how he felt about his new pair of jeans. How did he feel about his new pair of jeans? How would you feel about your new pair of jeans after presented with that many choices? And the answer, and this is anecdotal, and as far as the subsequent experimental evidence tells us, you're simply not going to be as happy. The jeans will likely fit you better. They will definitely come closer to what you would have chosen. After all, there only was one choice decades ago. But your experiential experience of it will be that you like them less. Why? Because you will compare them to all of the other possibilities. And here, this is from the Old Navy site. I just ran a search for men's jeans earlier today. And this is by no means everything that came up. This is what I was able to fit on a screen by taking a bunch of screenshots, and I could have scrolled and showed you more. So even much more than when Barry Schwartz was writing, now there are even more choices. And lest we leave this at an analogy, I want to make sure to explicitly bring this around to what we do as mediators, which is that as mediators, we are among the large number of professionals that have the experience of working with parties who have every argument and every option and every alternative available in the world at their fingertips, one Google search away. And that means that part of our job is to manage what is salient to the parties, using their choice of what should be salient, but to ask the parties and work with the parties to present with the real alternatives, and by implication, what their real BATNA is, right here. Not this collection of every imagined benefit that might be out there somewhere in the world. And what that allows us to do is to provide a reality check, but we don't stop at that. And here I want to be a little more rigorous about our definitions. Well, how do parties decide what they want? In this model that I'm presenting, there's two options. there's the one that conventionally is seen as the agent, as the lawyers, as the firm's job, which is to maximize value. How much do I want? As much as I can get. How much do I want? As much as I can get. That's maximizing. There's another option that's satisficing. Satisficing, a term coined in the late 40s by the Nobel laureate Herbert Simon, subsequently picked up by Barry Schwartz, who I already mentioned. Satisficers, on the other hand, set a target. I want to find a pair of jeans that's comfortable, that's blue, and that I can wear to meetings on Fridays in casual settings, somewhat professional. When I put on a pair of jeans that fit and they're blue and I can imagine wearing to an informal meeting, I will buy those jeans. And I will not try on the other. Let's say that was pair number 7. I will not try the other 180 jeans. Now,
yep. And what else?
Go ahead. If that was a question, please go ahead. So Latanya, when you're saying, can you tell me more about this? It sounds like a habit mindset. I'm not familiar with that terminology, and I want to bring it out.
Good afternoon. So the habit mindset is when I am a creature of habit. I want it one way. I'm going to do it this way. I want these type of mediators. I'm going to go with this company. I'm familiar with this company, so I'm going to stick with this company. I'm going to stick with this mediator. I'm going to stick with this attorney. I'm going to stick with these types of blue jeans because this is what I like. And this is what I'm familiar with and comfortable with.
Wonderful.
Habit mindset.
A habit mindset, another way to say that is a positional mindset, right? I have my position. I will argue and fight until I get it. Now, as managers of negotiations, as advocates, as parties, as neutrals, as mediators, we can suggest, though of course not impose, but we can suggest a particular kind of satisficing frame. The problem with maximizing is you're never going to be happy, right? Did I get enough? No, I wanted as much as possible. Should have gotten more, should have fought more. We've all of us who have had clients have been the lawyer to that client, right? Why didn't you fight harder? Why didn't you get more? Are you happy? No, of course not. We're maximizing here. Now, the alternative, of course, is to say, what are we aiming for? To go through an alternatives analysis and say, what are we aiming for? And to agree to stop when we get it. Now, by the way, that doesn't mean stopping short of what we wanted. It means broadly defining what we're looking for to allow for flexibility. And when we hit it, saying yes. Now, here's the good news and the tragedy. The good news is that if you're able to do that, if you actually counsel someone to satisfice, or if you actually are a satisficer, you'll be very happy. Satisficers are happier. Now, the bad news is you can't fake it. A lot of us who came into this line of work through the law came in with a certain kind of type A orientation and a certain kind of achievement-oriented orientation. Apologies for that phrasing, and that's hard to let go of. Now, to provide an additional argument for its use as mediators and as counsel, the alternative doesn't really exist, and it's not a recipe for success, because there's really no such thing as continuing to maximize forever. Right? You do need to define a target. So how do we, zooming back out to this question of managing attention, another way to do it is through the concept of framing. For many of you, this will be a reintroduction, or perhaps one that you've encountered through the study of negotiation. And I want to point out that we do it as mediators by necessity. We choose one thing to say and not another. And to say, let's work with it and let's align it with the values of mediation. So I'm going to first illustrate framing. And if you look at the feed of video, of my video right now for a second, rather than the slides, framing is from photography. You used to see people do it like this, where they try to figure out what's going to be in the photograph. Much more so today, you see people do it through their iPhone, right? They kind of just look at what's going to be in the frame, and everything outside of it is not in the frame. So you are choosing what to put in the picture, what to show and not to show. So I'm going to provide an example of it, and I warn you, I can almost guarantee you are about to see a photo of one person you don't like. This is a content warning. I can almost guarantee you are about to see a picture of at least one person you do not like. Framing. Interesting choice of cropping on this photo. And to pick up on the prior hour's work, notice how much our mind needs to put effort into this. Trying to remember why there could be a picture like this, and what is this even? And notice that it really doesn't so much matter whether you like the people presented or you don't like them, or you like one and not the other, or neither. This is something else entirely. There's a bias that says these two people, I'm not used to seeing them together. What is this about? Or you might choose to frame the picture like this. Notice that regardless of what you believe and whether it's in alignment with the people depicted, this requires less processing, right? I've seen many pictures of these two people together before. Or you can use the original photographer's framing. And I believe, by the way, this is from the wedding of the two people on the outside of this photo. There's a different story with the broader frame and with each of the narrower frames. And as mediators, we're either going to do this subconsciously or consciously. And the argument I want to make is that we should do this consciously. Because if your active mind is not deciding what to put on the agenda and what story that involves, your implicit mind will. And as mediators, we have more of an opportunity to bring our values to the active processes. So I want to take a moment to check if there have been any additional comments, and also to invite any comments that people might have come up with. Okay, so I want to take a moment on recent developments in the analysis of emotion. As mediators, we take in a fire hose of information, and our job is to very quickly decide what to do with it. And as our colleagues have pointed out, we increasingly are aware that we have the job of doing that, even while realizing that we need to manage a bunch of systems in our minds, not all of which we're conscious of. Kind of like we need to figure out what we're paying attention to. We need to then be conscious about making sure we're paying attention to as much as possible. We need to eliminate what's truly irrelevant. And then we need to keep kind of diving back into the recesses of our minds and say, did something go wrong there? Right? And this, by the way, this is not just a bias comment. This is a noticing things comment. This is a, have I missed the solution comment. This is a, did I do the math right comment. So one of the things we take in are the smiles, the frowns, the grimaces, the eye rolls. The question is how to be a rigorous observer of those emotions. So if you took Introduction to Psychology early in college and you did it more than, say, 15 years ago, more than 20 years ago, like I did, 25 years ago, perhaps, or more, you likely saw images like this one in your textbook, like these two. And depending on who wrote your textbook, or depending on what TV show you subsequently watched, if you watched the kind of TV shows I did, you will see the claim either by a actor playing the part of a scientist, or earlier by actual social scientists, that we can interpret what these mean, right? That you can look at these people and know what emotion is being presented. Now, this is very important. The most recent science kind of tells us we're not as good at that as we think. And that's for a number of reasons. Number one, some of us are good actors. Sometimes expressions are consciously presented the same way language is in order to make a point. And that point can be true or false or something in between. So is the person feeling this, or are they wanting to convey that they're feeling this? Now, another thing is that there's much more cultural variation than we used to think. Imagine yourself in a group, whether you usually have the experience of being in the majority group, visibly say, or the minority group. Imagine yourself in a room where you're the majority. And imagine how and when you might laugh or frown. And then imagine yourself in a room where you're the extreme minority, whether that's usually your experience or not. And think about how many fewer emotions you'll show. And in fact, most importantly, how you might not show dissatisfaction with something that's happening in the group. Which is to say, sometimes extreme anger can look like not much at all. And that's only one of many examples. And of course, there's the complete cultural disconnects where different expressions do in fact mean different things if you go far enough to people who have had little enough exposure to Netflix and YouTube. Now, what do we do about this? Well, there is something that everyone agrees is universal, or at least two dimensions. And number one is how activated you are. It's also called how emotionally aroused you are, but how activated you are. Does someone seem to have energy or no energy? As this mediation is progressing and they're hearing something, are they getting more or less activated? You can usually observe someone and measure that accurately. Are they having a positive or a negative experience? It's called valence. Is their experience positive or negative? Usually we can measure this accurately as well. And my advice to you is, particularly in culturally diverse settings, or in settings where we think there might be acting or posturing going on, let's put aside the project of saying this person is ashamed or frustrated or ecstatic or psyched or nervous. Put that aside. Is their activation increasing? Is it decreasing? Is their energy high? Is their energy low? That's one dimension. Number two, thumbs up or thumbs down. Are they having a positive or a negative experience? If you're plotting that over time, you'll find that you can make conclusions about the parties rather than concluding or misattributing what you think you might be seeing. Very important. If we are to be observers of what technically gets called affect and a lot of us call emotions, let's really strip it down. And Carol Lieben, who I mentioned earlier, before neuroscientists got around to the sort of thing I'm showing you right now, pointed out that when she started teaching, like I do now in an experiential setting, she was at Boston College, and she would often find herself taking students to court to argue under her supervision. And she tells a story of a large former football player athletic guy.
And I'll
strong
get
guy.
her out of here.
Was that a was that a comment that someone wanted to make, or I'll take a minute there. So taking a student to court, and she remembered this particular former football player, and she turned around and he was a ball of nerves to her appearance, right? And he was shaking his legs up and down and getting ready to go into court and arguing. She looked at him and she said, "It's going to be a disaster. They need to say something to encourage this guy." And she looked at her and said, "It's going to be fine." And he kind of looked at her confused, and he said, What are you talking about? I'm not nervous. I'm psyched." Now, that's how you can use this sort of analysis. She observed him to be activated, moving around a lot. She attributed unpleasantness. If she had observed longer, or in this case, she asked, she found out that he was having a pleasant, activated experience. Now, we're coming close on wrapping up here, and I want to present one more concept in closing, which is that, as a number of us have pointed out during this session, one of the strongest tools we have is interest-based analysis, interest-based mediation. Now, if you're used to that kind of terminology, by all means, continue to think of it as interests. For our purposes today, let's say that interests are needs. You can think of it as needs. I do encourage you to go down sort of the literature of interests, but we can also think of it as needs. Let's use it interchangeably here. And now, many of us who have studied needs or studied social psychology will have run into the work of Maslow. And simply by this process of shepherdizing or updating what we know, I want to point out that Dr. Scott Barry Kaufman, with access to Maslow's papers, has recently done an extensive shepherdizing of the concept of needs. So you might have originally, if you studied needs, seen something like this, like Maslow's pyramid, which, by the way, was put together by management consultants using Maslow's theories. He never actually used a pyramid to illustrate his hierarchy of needs. And if you didn't previously see these concepts of a hierarchy of needs, ignore this one, because this is the most updated one. This is Scott Barry Kaufman commenting on Maslow. And what Kaufman, building on Maslow, points out is that needs can be broadly categorized as being security needs and growth needs, with one more kind of need that we will leave to the end. What are security needs? In this case, they are portrayed as being the hull of a boat. They're what keeps us, the hull of a boat, what keeps us afloat. That's our own self-esteem, connection to others, our physical safety. Without those, we're not floating, we can't get anywhere. But it's not enough to float. And that's where he portrays the sail. These are our growth needs. That is looking for a sense of purpose. That sense of connection becoming a full need for love. A need to explore the world, explore our minds, explore fields and concepts. Exploration. And as colleagues who sail point out, it's not so simple as to say that simply you get one set first and then the other, because if you're sinking and you're sinking slowly, you might choose to sail to land and you might succeed at it. So we're always asking the question, what's going to solve this? Growth needs or security needs? And in closing, I want to leave you with this image. This is my own image of Kaufman's hierarchy of needs, building on Maslow. And I try to keep this in mind when I'm mediating, which is to remember that the parties are going to need a sense of security. If someone is hungry, you're not going to talk about them. You're not going to talk about ultimate meaning, but you're not going to be able to stop at making sure they have enough to eat. To solve a problem, you're going to have to talk about their higher aspirations. And lastly, those of us who have the privilege to mediate often get the opportunity to see, rarely, but often if we do it enough, every once in a while, we will get the opportunity to see parties who have their needs met enough that the needs only have a way of letting go of them. And that's what in the psychology of needs we call transcendence. And here it is portrayed by the seagull looking down on everything. Our problems are only something that doesn't have hold of us. That's something that we can look down on. And if you ask me why I'm in this work, it's for the opportunity to every once in a while get to be an observer as parties find their way there. Thank you for having me today.
Daniel, thank you so much. That's a beautiful image right there. I think something we all can strive for. I have to, before we go to the next program, I have to apologize. I was probably part of the cascade problem with your slide for, you know, it's really an intellectual, psychological thing right there that, you know, we didn't know whether to say anything to you or if you really needed it. But as soon as somebody said something, it's so fascinating that you actually tested us right there. That was pretty funny. And I think we all want to take your class, so expect a bunch of audits for your next class. Daniel, thank you for making the time. Thank you for representing UGA and the School of Law for its program in ADR and what you're doing to help our industry. And thank you for your time. Really appreciate it. Learned a lot today. Thank you. Okay. All right. As we move now to our last program of the day, and so appreciative of everybody that has stuck out this entire day to stay for this last program, which personally for me, as we roll Mark and Paul onto the screen, is a personal achievement for me to get these guys to speak to us today on the issue of collaborative law, which is a topic in Georgia that we haven't yet achieved to the same level that you'll hear these gentlemen talk about that have happened in other states to accept the concept of collaborative law. I mentioned North Carolina when I first spoke this morning, because I've talked with a lot of the folks that are doing collaborative law and have legislation, statutory support for it in North Carolina. We've been trying to get into Georgia. And I know Mark and Paul have taught a lot about this to support what they're doing in other states, and hopefully can teach us now this afternoon about what the potential might be for collaborative law in Georgia. So Mark, Paul, welcome. Thank you for joining us today, and I will turn it over to you.
Thanks, Scott. Just want to make sure I can share this screen. Can you help me do that?
You have co-hosting privileges, just press the share screen button at the bottom.
Yeah, I see it. I'm not seeing it on our screen though.
Try changing your view to gallery.
Yeah, I'm just seeing my desktop.
Once you hit share screen, then you choose which box on your desktop you'd like to share. There we go.
All right. Should work.
Yeah.
Yes, I'm seeing your screen now.
Yeah, there we go.
Excellent.
If you'll just maximize the presentation and put it in presentation mode.
Sure. See if I can do that. Worked?
Perfect.
Excellent. Just going to minimize this up. So first, Scott, thanks for having Paul and I to speak on collaborative practice. We're appreciative of the opportunity to speak not only to you, but also the folks on this. I see there's about 125 folks, so we're really excited to have the opportunity to speak today. Just by we're going to go through sort of our backgrounds quickly to talk about, and I can't really see, but you know, as far as the show of hands, if I did gallery to see who's known about collaborative practice, but hopefully we're going to start to give you a primer and understand its distinctions from the mediation world that you heard about this for most of the day, and to speak a little bit of how we can sort of help folks in Georgia grow their own type of collaborative practice as well. So I want to introduce my colleague, Paul Faxon. We can go.
Hello, folks. How are you?
So I just want to sort of introduce myself, and then Paul can introduce himself as well, so you can get an idea of who we are. I'm an attorney located outside of New York City. I practice
in the field of, I still practice some litigation work as well, but I'm also involved as a mediator and as well as in collaborative practice. I chair the IACP Trainers Group, the International Academy of Collaborative Professionals. I'm actually here in Toronto that I'll be presenting later today and have the opportunity to speak to you folks. Paul and I are members of the Global Collaborative Law Council. It's an entity that focuses on collaborative practice, as you hear, outside of the family law domain. I'm also sit on the board of a group called the Attorneys for Family Held Enterprises, where we look to apply what you hear about as a multidisciplinary approach to helping folks problem solve family business disputes. So with that, I'd like to sort of pass on to Paul to give him a little introduction of himself, and then we can kind of dive into what collaborative practice is, the nuts and bolts.
Hello, everyone. I assume you can hear me. So my name is Paul Faxon. My history has been as a transactional attorney for almost 40 years, primarily in the area of commercial real estate law and closely held business law. I'm also a consultant for an outfit called Continuity Family Business Consulting, which works with family businesses, primarily those that are experiencing some type of conflict. And so I come to collaborative law from the perspective of a transactional attorney. And it just seems a natural way for me to resolve many types of legal disputes where you can really have a win-win. It doesn't have to be a binary type of situation. With Mark, I'm on the board of Global Collaborative Law Council, which I encourage you to check out on the web at your convenience, along with IACP. And I've worked with Mark before. He's a terrific presenter and brings a wealth of knowledge. So you didn't come to hear about us, you came to hear about collaborative law. So let's get after it, Mark.
Okay, well, thanks, Paul. So I want to talk to you sort of broad brush about collaborative practice. We look in the field of ADR that collaborative practice is a revolutionary dispute resolution process. As we're going to talk to you, I know Paul just mentioned the IACP, which is an international organization of which collaborative is recognized in over 24 countries at 5,000 members. We are going to sort of focus, and Paul and my bailiwick is more of the commercial side, where we focus on non-family disputes, the family type of related disputes, as I mentioned, family businesses and alike, partnership, closely held businesses. Overall, we look at it as a process of it is an interest-based type of negotiation, and we'll talk sort of the nuts and bolts of that we deem to more for clients to be fiscally efficient. It generally takes a third of the time of a traditional litigation, and probably a third of that cost too. And we think it really helps in problem solving for clients. Like mediation, it's private and confidential. The parties sign, as you'll hear, an agreement to keep it confidential, as you would sign in a mediation. And all the focus is on the clients. Our focus is to be hired as a limited scope representation as attorneys. Both parties will have counsel, and they are limited scope in their representation, and we'll talk about that further as we go on. But the real construct, I think, collaborative practice is it's client-centered. It's really putting the clients front and center to help to support them in making those tough decisions, kind of working through emotion and getting to, as you can see, using the ability to sort of use that support of both counsel as well as we use non-legal professionals to support that growth to get toward resolution. We like to call it a win-win outcome as in our parlance, and I think that really rings true for collaborative. We really focus on the parties really looking toward a win-win outcome and supporting that endeavor. Paul, anything you want to add on that?
No, you got it.
All right. So moving on. So I wanted to talk about collaborative in terms of the ADR continuum, and I know this is not my slide, it's from the Northern Virginia Mediation Service. So one of the things that we look at, and Paul will talk about this in a little bit as collaborative kind of fits in this picture, but I wanted to use this slide to talk to you more about sort of just a frame of what, where collaborative kind of utilizes all these different methodologies on the sort of ADR continuum. As you can see, on this slide, particularly on the left side, you have conciliation, where the parties basically have control of the dispute. The kitchen table, typically we talk about, where parties look to kind of resolve the situation themselves. As you progress, the parties have less control. As we know, as we get toward mediation, they have some control, but there's a neutral involved in that. And as you move closer to litigation and arbitration, the parties kind of cede control, and ultimately the neutral decides that outcome. The collaborative uses different elements of this continuum. And something we want to talk about is, and I like to talk about, Paul and I were talking about this in preparing for today. I look at collaborative practice as using the advocacy element from litigation with the facilitative aspects of mediation and other facilitation efforts. And Paul, just to sort of touch on that continuum, if you could.
Yeah, so the message, one of the main messages that Mark and I want to convey here in our presentation today is the intentionality that you as the counsel need to have with your client when you're thinking about the type of dispute you have, the party on the other side, and what's the sweet spot on the ADR continuum for your particular dispute. What of these methodologies best fits the parties and the nature of their dispute? And in my experience, there is a we can kind of go to the next slide, Mark. There's a rush oftentimes to go with a default type of dispute resolution process. Now, obviously, the biggest default in our society oftentimes is litigation. But even outside of that, folks will tend to gravitate towards a default in their alternative dispute resolution toolbox. And under the ethical requirements that we have that are listed up here, as well as meeting the needs of our clients, taking a step back, really thinking about the nature of the dispute, thinking about the nature of the relationship of the parties, thinking about the parties, is so important. And it's a decision that you make at the beginning of the engagement that's going to have huge ramifications. And you also have an obligation to educate the other side, not just take a no for the only answer that can be provided. And in the end, the concept here that we're going to talk about in collaborative law, and this is one of the first applications of it, is one that was coined by my friend and colleague in the Commonwealth of Massachusetts, which is you as the dispute resolution professional need to always keep in mind that your goal is to maintain the sovereignty of the client, that we're looking for client-centered dispute resolution procedures, not one size fits all. We're not coming to you proselytizing that collaborative law is the way to go in all types of ADR. What we're saying to begin with is intentionality in terms of working through with your client, the other side, understanding the nature of the relationship and of the dispute. What is the best fit to try to resolve this dispute? Okay. And that's covered again in the slide on client autonomy. And that's a big part of you doing your job. When I have taught in law schools, one of the things I say to my law students is, in the R. Paul Faxon world of malpractice, I think that you're verging on malpractice if you haven't had that type of real consideration up front in terms of what type of dispute resolution process outside of litigation you're looking to employ. And it may mean some work on your part to educate the other side. Mark?
So touching on what Paul's saying, we kind of look at dispute resolution as collaborative practitioners as an opportunity to really before they sort of get into the process of collaborative is affording them those sort of choices as you would, and as Paul and I highlighted, the sort of the model rules talk about those ethical requirements. Because we believe when you actually have a client has decided to get into this collaborative process, the settlement focused, interest-based negotiation, that they've been availed of the sort of the risks and the advantages of doing these other dispute resolution processes. And that's important, particularly because, as Paul will talk about later, it starts to create that buy-in in dispute resolution. And we think that's quite important. And I wanted sort of, as you know, Paul mentioned early on, we're not processizing that collaborative practice is a one-size-fits-all for all cases. What we do say is we really try to figure out the best type of process for the client. What's really going to support the client's needs, wants, and interests. And so in the distinction from mediation, I sit, by way of example, I sit as a federal court mediator. And in that sort of dynamic, as a neutral, my role really is more at times authoritative. Parties look to me sometimes for answers. Parties look to me, perceived as sort of the language I use with counsel tends to be a lot like you hear in a court setting, a litigation setting. And traditionally, even in party represented mediation, even if it is a joint session, a lot of times the client's voice tends to be in the background. And for us, that's something quite distinctive here in collaborative. We actually sign, as you hear, an agreement that we are focused on settlement. Our total focus of counsels is focused representation for settlement purposes only. It's a very different mindset. And just by way of example, I represent parties in mediation as an advocate. And in that frame, my focus is not always on in a mediation on settlement. Sometimes it could be on, I tend to see, you know, what's going on in that negotiation, but I may have an eye toward litigation. I have that option. You'll see, as you hear, a distinction from mediation, and particularly any litigation as well, is we have limited scope representation with a withdrawal provision. And what that means is, in that context, if the parties using this process are unable to resolve the dispute, ultimately, we will not be the litigation counsel as professionals. And the non-neutral professionals that are used in this process, they won't be hired as sort of hired guns in a different litigation process. The parties are required to go out and get separate counsel. And so to us, that's an advantage. All the parties' focus is on really that settlement negotiations. Our role as professionals is to sort of help the clients identify and advance their interests and settlement options that work for both parties. And the neutrals that are there are helping us as professionals to sort of deal with issues on emotion, deal with issues understanding financial landscape, and something that Paul highlighted already. They help the parties educate themselves regarding what's at issue. They help in resolving the conflict by educating the parties on the financial landscape and working through the parties in restoring that communication.
So when you are in a collaborative law case, you're all in on trying to see whether or not there is a viable consensual settlement agreement that can be developed. Now, privately, you're having, you know, conversations privately with your client. You're advising them on the law. You're advising them on what would happen if this consensual dispute resolution process failed, which doesn't happen very often in collaborative law, but you would advise them, and this would be what the alternative would be if you went to litigation. But that concept that both the neutral joint experts and the lawyers are only there for the collaborative law proceeding, and if for some reason that collaborative law proceeding does not result in a consensual agreement, folks have said, wow, you're really all in. And I say, yeah, we are. And they say, well, the clients have really invested in trying to make this consensual dispute resolution process work. And I say, yeah, that's right. It's not a warm-up for litigation. It's not to make the judge happy that you tried mediation. No, That's not where we're at. We're putting all our chips on the table to see whether a consensual dispute resolution process can work here. And the clients still retain their rights to litigate if they want, but they're going to have to go out, get new experts and get new counsel to do so.
And we're happy with that as actually collaborative professionals. We think that really helps us in doing our job as far as supporting that process, because everybody is on the same page with an eye toward resolution. So in that sense, I want to sort of define collaborative practice. We're going to talk a little bit about structure in a minute, so you get a flavor for how this process looks. I know we've kind of talked high level a little bit, but we want to sort of give you an introduction and then kind of talk about structure. So I kind of use this quote, and I think it's important. So collaborative practice is really a solution-oriented approach to resolving disputes. And in its name, as the moniker expresses it, it's about the professionals working collaboratively to help the parties sort of restore that communication, as I mentioned, help them solve their problems, and avoid something that I like to refer to as collateral damage. And so just by way of definition, collateral damage in traditionally in a family dispute, as you can imagine, where collaborative law has its sort of genesis, that's the collaborative damage would be the children, or the collaborative damage could be the relationships that the parties have going forward. In the non-matrimonial and in my world, it could be the business impact that it's going to have on the business if the parties are not unable to resolve the dispute, or if they're heading toward a litigation, what that impact looks like for the business in terms of price of the company, affecting shareholders, the interruption of people having to go for depositions and the like. So that's kind of how we sort of frame it to help the parties think about those issues of what can affect, even though they have the dispute, what third parties can be affected by them, not looking towards inward and restoring that communication.
And if you want some tangible examples of this, think of a family business, multi-generational, where there's a conflict within it. Think about an estate or trust dispute. Think about a dispute among a very long-standing and profitable contractor-subcontractor relationship. We could go on, but especially when you have a possibility for valuable long-term relationship either continuing or ending because of the legal dispute, that's one of the key indicators that collaborative law might be a type of dispute resolution process you want to seriously consider. So you want, yeah, next slide. So I'm not going to read these down to you, but it gives you some basic outline of highlights. It's collaborative law is based on interest-based negotiation. That's something that we all share and have as some of our base skill set. There is a formal agreement that outlines this process and binds people and has a confidentiality provision in it. We have a whole panoply of conflict we can deal with, way beyond what you would have in an arbitration or a court case, including emotional elements. And we can be as creative as the parties want to be in terms of structuring the future settlement. And it can be a future-oriented settlement. And it can be a win-win type settlement. The parties still have the benefit of their own legal counsel and advice. We're going to have moments with our clients in collaborative law where we're privately speaking to them, giving them a reality check, telling them what would be their likely outcome applying the law if they went to arbitration or a court case. The mandatory and confidential information exchange is important. For a transactional attorney, it's sort of incomprehensible, the discovery process that my litigation colleagues go through. Here, we don't have a hiding of the ball. It's much more efficient, okay? I'm going to speak a little bit more about jointly retained neutrals, but when used appropriately, they are unbelievably effective in terms of moving the parties forward. There's no discounting of expertise because there is no battle of the expert. The parties have jointly retained a neutral, and that neutral is excluded from litigation if it was to go in that direction. So they're really freed up. They're not worried about qualifying their presentation because they're about to, in a few weeks, they'll be getting grilled on cross-ex. Totally different dynamic that we'll get into in a little bit more. And Mark, what else do you have to add to that?
I wanted to add, Paul, one of the things that I mentioned early on, we do something called participation agreement. And it's something I guess we'll probably talk on a couple slides as well. But the concept here is the parties agree at the outset to actually sign a document saying that they're like they would in I guess a private mediation agreement, the same concept. They're going to enter into this formal settlement process, entering in good faith. With the help of counsel. Counsel in most cases will either sign the document or acknowledge it. But everybody ceremoniously and on paper agrees that they're going to enter into this process, to use this process to support conflict resolution. And part of the sort of elements, Paul's comment about, I come from a litigation background. So the idea initially when I speak about collaborative is the concept, well, you're going to give over information in terms of dispute resolution. Why would I do that, right? As a litigator, why would I do that? And the way we've kind of turned it on its head in collaborative practice, particularly, is it makes a lot of sense. If one of the things that, ethically, you want parties to be informed, right? You want them to know what they're getting themselves into in terms of the conflict. And particularly, they need information to do that. And what we believe in the collaborative is we're going to kind of bypass all that arguments over discovery. We're going to kind of look at what information that can be relevant for the parties and helping them to make better decisions.
Yeah, Mark, one thing that occurs to me when you make that comment is that one of our respected colleagues, Michael Zaytunian, always speaks about when you hire a collaborative attorney, 100% of their efforts and the fee you're paying that attorney is going towards making sure that you've exhausted every reasonable effort at a consensual settlement. I mean, it's very efficient that way. We find that to resolve disputes through collaborative law is way more efficient than litigation. Mark can speak about the inefficiency of litigation in a way I can't, but that's something that's not to be glossed over.
Mark must be having some tech issues. He disconnected.
Uh-oh. Okay. Well, I'm going to hope that he gets back on very soon, but I'm going to continue on. What I don't have is his slide deck that's easily for me to handle, but you're going to get to listen to me until he comes back. Okay, folks? We'll navigate that. If you lose me, then you're out of luck. Very briefly, the history of collaborative law. It began back in 1990 with a fellow named Stu Webb out of, I believe, Minnesota. He's sort of the godfather. His focus was in family law, and collaborative law is by far best known in the area of family law. You can see with family law, where you have a continuing relationship, especially if you have children, how it's a natural fit. And the International Academy of Collaborative Professionals is quite large, well-established, and focuses on that. Mark and I are board members of the Global Collaborative Law Council, www.globalcollaborativelaw, and we focus on the application of collaborative law in a business context. The IACP, for instance, has over 5,000 members, most of whom are lawyers, but other collaborative professionals are involved. And they're in most states. They're in Canada. They're in about 27 other countries. And there are numerous practice groups. And if folks are interested, I would suggest reaching out to IACP in the family law field or global collaborative law about getting involved in our programs and setting up your own practices. And both Mark and I have extensively conducted trainings throughout the US and in Europe and elsewhere. So you don't have to start from scratch in any way. This is kind of covering here from Mark. Let's talk about what the structure is to authorize collaborative law. There's really two different routes that folks can take. First of all, there is a significant number of states that have adopted the Uniform Collaborative Law Act. So it lays out that this is a voluntary legal dispute resolution process that requires this signed participation agreement that goes over the parties' responsibilities and confidentiality and the like. It makes clear that the attorneys are disqualified from representing clients in the court except for an emergency application. And that also would usually mean their firm is disqualified. It provides for the full disclosure of information that's substantially related to the collaborative subject matter, and makes clear that the communications developed in collaborative process are privileged. So that's a formal statutory basis for collaborative law. There are also other many states, including my home state, where collaborative law is well established, but collaborative practitioners don't rely on a separate act. They rely on both the contractual provisions in the participation agreement, as well as law in the state with respect to the confidentiality of settlement negotiations. So both routes have worked for practitioners. I think that folks, when they can get the Uniform Collaborative Law Act in place, it sometimes helps provide a higher awareness and may sometimes allow certain practitioners to be more comfortable engaging in that process. But again, there are numerous states, including my state, which has been one of the leaders, that has never enacted the UCLA. Okay. All right. So I'm sorry about the lack of the PowerPoint, but appreciate you working with me on this. Is everyone still there? I still have everyone?
Yeah, Paul, I reached out to Mark by email, but I haven't heard back from him to reconnect, so we'll see what happens.
Okay.
But
So
I
let's,
appreciate you carrying the flag.
okay, I just wanted to make sure I'm not talking to myself and the Herring River Marsh and Cape Cod that I'm looking at. So for all you folks that are active clearly in alternative dispute resolution and interest-based negotiation, and obviously looking at the program mediation was a significant focus of today. Hold on one second, this is Mark. Hi, I'm covering for you. Are you there? Okay, all right, I gotta get off. Interest, Mark's trying to get back on, but in any event, when you're involved in collaborative law, you're still using all the discipline of your interest-based negotiation training. You're identifying interests, you're going through and developing options, you're testing them against legal realities. You're looking at the other side's needs and interests. You're doing some brainstorming. You're coming up with enforceable standards. You're advising your client about what their BATNA is if they end up going into litigation. So none of that changes. You're still doing that process. And one of the things about collaborative law is it puts the clients directly front and center in that interest-based negotiation process. They're not working through their attorneys getting to yes. They're actively involved. So maybe I can present this in a way that folks understand how this would work. Before each joint session that would have the attorneys, their clients, and any neutral experts that were involved, there will be preparation. There will be advising your individual clients about their rights and responsibilities. There may be some coaching of the client. There will be an agenda developed so there's clarity as to how to go forward. there'll be a conversation with the other lawyers, not to negotiate, but to prepare for that collaborative law session and make sure their clients are both ready to move forward. And in that session, they would be involved in interest-based negotiation, but they wouldn't be using the lawyer as the mouthpiece. They would be very actively involved with the lawyers supporting them. And if there was a session with a neutral expert, the neutral expert would really be there front and center, working with the clients, with the attorneys available and supporting that process, but not running it. Sometimes when we talk to people about collaborative law, you can tell the attorney starting to get anxious, which is, well, what's the role of the attorney? Well, the attorney still has a huge role. They're having conversations with the clients, giving them a reality in terms of negotiation and interest-based negotiation, feasibility solutions, and also what the law is, because if they don't navigate the collaborative law process and come to a consensual agreement, they're going to potentially be in litigation. They're also helping gauge the client's ability to participate in that process and help them out. Maybe they need some coaching. Maybe they need to have security of a very formalized agenda for the next session, okay? And I will say that going back to one of those early slides, when you're presenting various types of ADR processes to a client, you as the attorney are also gauging whether or not that client is a good candidate to participate in collaborative law. Collaborative law requires a client with appropriate coaching and advising and support and structure, but requires a client that can be an active participant in their dispute resolution process. And not all clients, even with the right structure, even with the right support, even with the right education, even with their attorney sitting next to them, not all clients have the right stuff for that. And that means collaborative law probably is not the right process for them. So that's part of your evaluation as you are navigating this process with the client, okay? Now, one of the ways that we coin one of the fundamental realities, and Mark's coming back, in our process is we call it the paradigm shift, where to me, the paradigm shift is really multifaceted. One is the attorneys are focusing on entirely on the settlement negotiation. The second one is that the parties are retaining the advocacy of an attorney, but with an eye towards settlement, not litigation. And the last one is we're not in a litigation process. We have that withdrawal provision. So that is very, and I would say it's client-centered. That is really a 180 from a lot of dispute resolution processes that we as attorneys are involved in, okay? Even to a significant degree along the consensual dispute resolution process. So Mark, I see you're back with us in the land of the living.
Yep. So apologize for that.
I'm at the paradigm shift slide.
You got it. So one of the challenges with Toronto is spotty Wi-Fi. But with that, I thank you, Paul, for sort of stepping in there. One of the big distinctions actually I was thinking about as I was off in the collaborative process is in that paradigm is we work together as a team. And so one of the issues that we sort of do is there are times in our collaborative negotiations in which as advocates, we actually support each other's profession to kind of support that dialogue. And I appreciate Paul doing that for me while I was away.
So Mark, I want to give a specific example of that, just to put two specific examples. I did a collaborative law case with Michael Zaituni, and it was a husband and wife who had gotten divorced, gone through a collaborative divorce. They owned their own business of about 15 employees, and they had been able to run it post-divorce in large part because they weren't as actively involved. They had a third party who was the manager. They had a falling out with the third party left. They're now coming into regular contact with themselves in the business is causing, a lot of conflict. And there were two situations. There was a situation where Michael and I said to each other in one of our conferences, not to negotiate, but to prepare the parties for the collaborative law session coming up. It became very clear that these parties had radically different views of the value of their closely held company. Radically different views, and an ignorance in large part as to how you would value a closely held business in that industry, which had to do with kind of a software industry. And so Michael and I both said to each other, we really need to have private conversations with each one of our respective clients, because if we don't get some handle on the valuation concept, not just a number, but how it's determined, and bring in a capable business valuator who can jointly educate these parties and who can be a trusted advisor, we're just never going to get this past go. It's just not going to happen. And we went back and addressed that. And another transaction I had with Michael, there were 4 equal partners of a privately held company. 3 of them voted the 4th one off the island. And when we had the first session, Michael and I decided that we'd have all 4 parties, his client and the 3 remaining that I represented, on one side of the table, and have Michael and I on the other side of the table, because otherwise it would just look visually like we were ganging up on the guy who had been knocked off the island. So those are 2 brief vignettes as to how collaborative law attorneys, while still representing their client's interest, and in furtherance, I would argue, of representing their client's interest, work together. Sorry, Mark, that took a little longer than I thought, but.
No, not a problem. Paul, while I was away, did they get to see the structure that we talked about, or is that something? I'm going to go back just to see if I can do that.
I talked about all your slides, but we didn't show them.
So let's do that. So I did want to sort of give you a graphic. I think this visual is important for purposes of process. So I know Paul covered this, but I'll highlight it kind of quickly. We sort of worked with the parties to understand both the parties' interests. We generally require them to sort of refine and rank those interests, as Paul may have said. We test them against, those interests and then help them develop options in a brainstorming session. We work to just sort of test those options against the practical aspects and the legal realities, testing against the other side's interests, and to develop mutual acceptable options, and then ultimately proposals and agreement. So it is a quite structured process. We have meetings to do a lot of these different elements here: an interest meeting, a ranking meeting, an option meeting. It's a very focused negotiation. I just want to sort of highlight that that it isn't sort of just 2 lawyers sitting around understanding each other. It's really a structure underlying this process. So I know you covered the paradigm shift. I just want to sort of jump into what I like to refer to as constructive advocacy. And maybe we'll just, watching time, Paul, sort of gloss over some of the more.
Yeah, why don't you just hit the key points you want on that one, since
Sure.
I covered some of your slides.
Sure, absolutely. So I like to think in terms of collaborative, the attorney is sort of functioning as a counselor at law. Something that we all took an oath as professionals to do. It's really, our job is to help. Really, our job here is to help the disputants resolve the difficult issues and conflicts. And one thing I think I do differently as a collaborative counsel than I would in another type of advocacy is the professionals model and acknowledge viewpoints. And we have the parties do that as well. And I think that's sort of unique onto collaborative. It's really, we model behavior. We actually model how the parties are to recommunicate, how they're kind of to work through the conflict at issue. We use different language. We talk about perspectives rather than positions. We use dialogue that we help facilitate a discussion of the law, talking about the legal risks and the practical risks, as I mentioned. And I like to think about in terms of my role as a counsel in a collaborative process, it's not to solve the problem. Okay, it's not my problem. I am there to support the parties in helping them to figure out through discussion and through negotiation opportunities to help them solve the problem. We still give them legal advice, as Paul said. Both attorneys have attorney-client relationships with their respective parties, but we really want to help those parties be sort of problem solvers, really, and work together as they once had to resolve their problems.
And let me just say, Mark, I'm sure that in the great state of Georgia, none of the attorneys listening to this presentation have ever entered into a settlement agreement where one of the other parties has breached the agreement. But in the unlikely event that you've ever had a settlement agreement where the other party breached it, I'm trying to be a little humorous here. Part of that is because the agreement may have felt imposed on the parties. In collaborative law, the parties have made a intentional voluntary decision to choose a specific type of dispute resolution process. Right there, you create some momentum towards settlement. And they have been actively involved in developing this settlement agreement. It can be future oriented, it can be innovative. It's not at all constrained the way an arbitration or litigation might be. And I would argue maybe not as constrained as kind of a traditional mediation process. And because of that, one of the benefits of collaborative law is when you get a settlement in a collaborative law case, I'll put cash money down. It's much more likely that it's going to be complied with.
Absolutely, Paul. In my cases, the parties, not only had to have buy-in coming into the process, but they had the buy-in in the resolution. It's definitely not imposed. They don't feel, and one thing I talked about in the initial slide, it's not a win-lose, right? It's not I as a mediator, I hear people saying, well, both parties are unhappy. And that's not the concept in collaborative. We want both parties to be happy with the resolution. We want to work so that both parties understand that there's going to be a consensual agreement at the end of it, and they own it, right?
And they can cover all the issues that they need to be dealt with. When I'm doing my family business consulting for family businesses that are in conflict, so often a lot of the dispute arises from matters way beyond just dollars and cents. You literally get situations where at a board meeting, someone's screaming that dad loved you more than me. If you don't deal with dad loved you more than me, you can put it under the rug. It's still going to come out. In a collaborative law case, if we have to deal with dad loved you more than me, then we'll deal with it.
Yeah, absolutely. So some of the advantages we talked about earlier, the confidentiality. One of the things that I think is important, particularly as an advocate for a client, whether it's any type of dispute resolution, particularly here, the client's involved in this process. The client is speaking. The client is supported by the professionals here. And because of their active participation in this negotiation, they see where the legal fees and the other fees are being spent, right? There's a lot of buy-in and there's a lot of acceptance of this process because they're directly involved in these negotiations. As I mentioned, you're avoiding, risk and bad press, particularly if you're a business, having this as a confidential proceeding, yet, having sort of these discussions to work toward resolution is imperative. But I think really what I think is important, and I talk to clients about, is really they're resolving their own dispute on their own terms. And I think that's really a great thing about this process. We support that in sort of working through this negotiation. We're also very flexible, right? We don't have to be imposed on a calendar. One of the most important things as lawyers we realize is controlling our calendar. And for our clients, the opportunity presents itself that I can have a collaborative meeting, and I have at night. I've had collaborative meetings on the weekends. I've had 2 hour, and I've had intermittent collaborative meetings during the day. It has a lot of malleability and flexibility, and which I think is a lot more attractive to clients, particularly ones who are operating businesses. So I do want to talk about this a bit, and I wanted to ask Paul a question, in terms of his experience as well on this issue. So we find that collaborative works very well in these interpersonal conflict cases. And what I mean by that is in employment cases where there's career transitions. I've done them where I have disputes with managers and employees. Family businesses, we've seen it that works well in sort of prenups in anticipation of potential conflict, working with, you know, the G2 and their succession planning from the founder of G1. We found that I've done a bunch of cases working on in estate areas where I think the family dynamic is there, where there's an opportunity to support each member of the family in that estate dispute, as Paul mentioned. We can deal with the issue that one child feels that dad loved, you know, him more or her more, and we can kind of work through that in this process, which I think is really one of the great advantages of collaborative. Also in supplier distributor cases, where they want to have an ongoing relationship, they just don't know how to get there. It's a really good support for that process to really understand the party's interest in moving forward.
It's also part of when I think of long-term relationships, I also think of reputation within a close community, close business community, right? So let's say that I'm a landlord and I end up getting a big new tenant in my space that's been empty, and I get into a dispute with one of the brokers involved in that transaction. I could decide to jam them up, litigate, or the like, and maybe I'd win. Maybe I'd win the case. I wouldn't have to pay him a brokerage fee. And I decided I'm never going to work with that individual broker again. Well, I'm a commercial real estate attorney, and when my client, that landlord, has another big vacancy in their building, and he's not getting any brokers either from that particular broker's firm or any other firms around town, shouldn't be a shocker, because his reputation precedes him. And it's very public that the brokers feel they got stiffed. So he has an interest in maintaining that reputation within the industry.
Absolutely, Paul. Good point. So I want to touch sort of quickly on something that Paul probably mentioned when we were talking about the non-legal professionals. One of the folks that I've used in some of my cases is a facilitator. In the family dynamics called a facilitator, and ours is called a communication specialist. And what I mean by that is it's someone generally trained in either a psychologist or psychiatrist, but someone who has an understanding of emotion, right? Someone who's skilled in learning how people process concepts and getting people to sort of get through emotion to get to that rational sort of discussion points. And in a lot of cases, and I did this in a sexual harassment case, I had somebody who facilitated the communication in the room. Now, for those who are mediators, that may look a little like a mediator, but it's a little different, right? It's somebody who acts in a neutral position and can kind of know how people process those concepts, how they talk, if they're a visual learner, right? If they're an auditory learner, what hot button issues, and something I'm going to talk about in a minute. The neutrals that we use are involved in the process directly, right? They're not just opining, right? They're helping us in the problem solving for the clients. So one of the things that we tend to do is to have people, the other professionals, meet with us or meet with the client in advance of meetings. And Paul, I want to sort of touch on something we talked about offline. The use of the neutral facilitator or the communication specialist, is it a requirement in your view, in terms of?
No, I mean, to me, it's not. Part of the sovereignty of the client is that after they understand the collaborative law process and after they have received advice from counsel, part of what they are involved with is how to staff up that collaborative law engagement with professionals, if any they need. So you can do a collaborative law case with just the two collaborative attorneys and the parties. In the case I mentioned with Michael Zaytunian, we were able to have them agree to one neutral expert, and the neutral expert that was absolutely critical in that particular situation was a business valuation expert. I could see a situation where you need to bring in a coach or some sort of other psychology type professional who might be involved at the actual collaborative law sessions, or they may be involved offline, coaching the individuals offline. There isn't one size fits all. Part of what collaborative law is about within this broad framework. There are certain key components you need to have, but within that framework, part of the whole beauty of it is you fit the team to meet the needs of the parties in conflict and the type of dispute you have. And the process of filling out your roster is part of the magic of having the sovereignty of the client, of building up the momentum. If two parties who are at each other's throats, two brothers who inherit their parents' business after they get, pass away, if they are at each other's throats, but they recognize with some assistance from their collaborative law counsel, they really need to have a business consultant in that particular industry come in, evaluate the whole business, evaluate the strategic plan, jointly present to them, and then facilitate a discussion in terms of what's next. Well, then that's what they need. That's what we'll get in the collaborative law process, and we'll have that professional sign up in their part of the participation agreement. So that's the beauty. The collaborative law process is not some one size fits all that you fit into the dispute. It is a vessel with some broad parameters that can be customized for each individual disputant and the type of dispute. That's the magic in part. Okay. And I think since Mark is never quite that unmoving, that we've lost him temporarily. I'm sorry, folks. I want to be sensitive to the time, and I think that I've covered most of what we wanted to cover today. And I don't know from my friends in the Georgia Bar how you want to handle this, but I'm happy to take some questions or input. Hello. Hi.
Hey, thanks for doing this. I know we've lost Mark for a bit, but
well, we're doing the best we can. I see a few people up, so if you can help tee people up, I'm happy to answer any questions that folks have or comments.
Yeah, I don't see any questions on my end.
Okay. All right.
But sometimes that happens with technology, and you guys are making the most of it. So we certainly appreciate it.
All right. Well, I want to. This was terrific from our perspective. I hope it met your needs. We were introducing some concepts that may be new to folks, so hopefully it gave them some food for thought. And it was a real gift to be able to participate in your program. And I hope if you have further interest, go onto the IACP website, go onto the Global Collaborative Law Council website. There's a lot of materials and the like that can kind of you can immerse yourself in to get a better sense as to how we operate. But again, many thanks to my friends in the great state of Georgia. And please, we'd love to hear from you folks. Okay?
Well, we certainly appreciate it, Paul. And I know Mark is not here. He logged out, but do send him our thanks. You guys had some challenges there, but I think you guys did your best to get through it. But before I let you go, I think there's a question here about what is general cost?
General cost. So I guess what I would say about general cost is some kind of key points to consider. Number one is you control your own scheduling. Number two is you control with your clients who you're going to bring in if you need any experts. If you do have any experts, it's going to be half the cost of the normal experts because you're not each hiring your own expert. You're having one joint expert. So right there, I've cut the cost by 50%. Not to mention that the parties will actually believe the jointly retained neutral, whereas if they're listening to the other party's neutral, they'll just discount them as being a hired gun oftentimes. So that's another aspect. You save, I believe, typically in enforcement. If the parties have been actively involved in developing this solution and resolution, way higher likelihood that you're not going to have somebody breach that settlement agreement. Okay. I won't even begin to get going as a transactional attorney in terms of the costs associated with litigation when it comes to discovery that my litigation colleagues have. But that whole hide the ball game is out the window. So I'm not going to come up with a number, but you guys do the math in your head. And for the right parties, for the right type of dispute, this is a very powerful mechanism. And I have to say, I just have to say in passing, this case I had with Michael Zaytunian where we had the jointly retained business valuation expert, it was magical. That made the case. Having that person come in, educate them in a way they both believe was reliable. Having that business valuator, he didn't just bring in the valuation and put it on the table. He had an active process of educating them as to how he got to that valuation. I mean, unbelievably powerful. So you do the math, but those are some of the advantages that do translate into real dollars.
Great, that's great. I don't see any other questions. And so perhaps we'll take a quick few seconds to see if anyone has any final questions.
I see someone made a comment. I think this is most valuable when there are only a few parties. I think it's much more complicated when you have multiple parties, because you are asking the clients to be actively involved. And at some point it may get a little bit like herding cats. So I get that. I will say this, the jointly retained neutrals could be valuable for multiple parties. So I had a case that wasn't a collaborative law case, but it was involved in my family business consulting, where 3-generation family business, 3 branches, each branch had 3 members on the board. So you were sitting next to 2 of your sibs and 6 of your cousins. And they really needed some expertise about the value of their business, but also what the value was of taking the business and redeveloping it, because it had turned out to be in a very valuable area that was subject to some new growth. They, with our help, found and retained a very sophisticated urban planning group. And in that case, that urban planning group educated at least 9 key stakeholders, and that worked. But a little bit different situation, but that's the one thing that comes to my mind. Well, thank you. Folks.
Yeah, thanks for sharing that example. It's been, and again, thank you and Mark for bringing our program to an end. It's been a very interesting conversation and topic. So thank you for spending the time with us this afternoon.
Thank you, and peace, and be well. Thank you very much.
And just with Mark and Paul, thank you to all of our speakers on behalf of the dispute resolution session of the bar. It's been a great day. We've been watching the level of engagement from everyone all day today. It's been fantastic. So thank you everyone for being with us all day today. Of course, thank you to all the speakers. You all have done a fantastic job in shedding light on these very fascinating areas in our practice. I know I certainly learned a lot, and I'm hoping everyone learned a lot as well. Scott, you did a fantastic job putting together the program. I think it's been great. So thank you for your leadership on that. I want to thank Lane and the State Bar for their tireless efforts as always. I do want to take a minute to remind everyone that in case you haven't received it, but you should have, that the materials for today's programs were emailed this morning. So please do check your emails to make sure that they came through. And the second reminder, I know Scott mentioned this at the top of the program, but I'll go ahead and mention it before we close here in the next couple of minutes, is that the CLE credits that you receive today can also be used for your accreditation with the Georgia Office of Dispute Resolution. And so be sure to take care of that. And then just with the Georgia office and the Georgia Commission on Dispute Resolution, just thank them for all the fantastic support and the work that they're doing. I think the fact that they're able to get a proclamation for this particular week, I think it's fantastic. It hopefully will raise more awareness in the public about the work that we all do and the work that we're all passionate about. And then just one more note on the GeoADR event. We've got the ADR Institute coming up next month on November 16th. It's a great program that they've got planned for all the practitioners. I know many of us here have been going for years. We went back last year in person and it was fantastic. It was good to see real people outside of our 2x2 little boxes. And so hopefully we'll see many of you again this year on November 16th at the ADR Institute. And just a final ask, perhaps a call to action. This is now, I think, the second year we've done this program on Mediation Week or Conflict Resolution Day. And we've had great support from everyone here. And so we really appreciate that support. And we hope that you will continue to support the section in this regard. We'd love for you to be engaged at a greater level. We're always looking for people to come present and bring their specialty and expertise to the section. We've got a large membership within the section. So if you're out there or interested in volunteering in a leadership capacity, want to present or do a program for the section, or just want to submit an article or at any level of engagement, we welcome you with open arms. We want to continue this high level quality of programming for years to come. And it's a collaborative effort, right? To piggyback on the topic of Paul and Mark. So I think if we can all work together, we'll continue to improve the quality of the programming for all the practitioners here. So again, on behalf of the ADR section of the bar, the State Bar, thank you all very much for being with us all day today. We welcome and we're thankful for your engagement, and we look forward to seeing you next month at the ADR Institute. So thank you and have a great afternoon.
Ladies and gentlemen, this does conclude today's meeting. Thank you so much for joining and have a great afternoon.